Someone make it make sense.
Probably a couple.
Hello, everybody. Happy to see you guys. For those of y'all who were here last night, you may have heard I've got electricians in my attic right now. And so hopefully, I don't know how much background noise you guys will be able to hear, but it is what it is. But the good news is that because of that, like I'm here, I'm can't really do a whole lot, but it makes me available to live stream. And I did double check thanks to Top Cat's suggestion. And she probably won't be here because she's in Australia and it's the middle of the night there. But she said something about, will you have electricity to live stream? So I did double check. And yes, they're only working with the circuit that deals with the HVAC system. So totally good there. So the only consideration is the noise, but I think hopefully you should be okay. Every now and again, you might hear some drilling, but I'll try to mute it if that happens. But anywho, so happy to see all you guys again. So y'all, of course, as per usual, as you guys have heard a million times, every time I do timestamps, right, for video, I always have like all these like light bulb moments, or I realize, oh, I forgot this thing I was going to say, or like there's this other question that comes up that I think of, or that was in the chat and I didn't see it. So as far as after last night's live stream, I began working on the timestamp. So I created a live stream for tonight, literally, because I'm like, oh my God, there's so much more to talk about here. And and one of them, like one of the things, especially for you, was we're going to take a look, especially at the location database of record. I found this incredible presentation. You guys are going to love it. It is a, it's a cellular analysis presentation made for like expert witnesses and like law enforcement that explains everything. It's like 174 pages or something, but it goes through even carrier by carrier specific. You guys, that's it. That is literally everything you could want to know about every type of thing with the phones. And you guys are going to just be in for such a treat. I can't wait. I almost decided to cancel this and do that instead, but I was like, no. So that will happen tonight. And we may also pull up some of Cyre's testimony as well, even though, we've all heard it a bunch of times, but it's always things are different when you get new information, right? So that's why I always try to refer back to things and revisit it, especially when we have all this new information. Things are different with more context, right? So, but I know there was talk about, and what kind of spurred this on, Twiz, was like, the location database of record, which includes GPS, right? Is that only in present day? Does that go back in time? And where does that come from? Because we know the pen, trap, and trace only started on December 23rd, but the pen, trap, and trace, and we looked at this a little bit last night, that included, right, in there, it included in the search warrant, the call detail records from AT&T. So I did more research on this. So the location database of record comes from the call detail records via the carrier. And I also will have things to show you guys tonight that shows exactly through AT&T, what exactly do they provide. So it's just, we're going to be in for a treat with all that. And I know that there was some question about, did the defense have that discovery? But I know that there was that motion to compel with Cyre, and that was to get the discovery. So in other words, what's different now? Like, remember when we were talking about like where's looking, like what's different now when we hear them discuss these things in these hearings? Well, the difference now is like they would have access to that. And anyway, I'm gonna get carried away, so let me just pause it there. We'll talk more about it tonight. Flash, are you feeling better? And I hope you had an awesome freaking birthday, dude. Right. So the ideal thing for tracking phones is a combination of everything, right? And again, a great example of that is like the location data from iPhone cache. It uses GPS, but it also, and I don't like the iPhone shit is pretty proprietary when I looked into it. It uses, because one of the things that's specific to iPhone is they use the, and again, Android also has a version, right, where they use the crowdsourcing. So it relies on more, so it uses the cell towers, right? It uses all the other shit that like normally would be accessible through the call detail records, like it uses all that shit, right? But and GPS, but it also uses Wi-Fi, and it also uses the crowdsourcing. So how close you are to someone else's phone, they can get a more precise location. And so, but I don't know. Again, we can revisit. Top Cat is here. Awesome. Welcome. I'm so excited. Top Cat, did you hear? So I guess you heard me talking about you. Literally awesome. I'm glad you got your appetite back yet. Or that you got your appetite back. Awesome. Yay. And yeah, there's a lot of us that don't tend not to sleep very often, which is, it's funny. We all have that in common. A lot of us do. So yeah, so this is really exciting. But yeah, so let me just look here. I don't know what Cyrate told you after the hearing, but I would love to know. Please. So, you know, your most, just in general, though, your most precise tracking is going to be, as I always say, a combo platter, right? It's going to involve a little bit of everything, which is why, like, for example, we were talking last night, like if you have location services turned off, your phone can still be tracked, your location can still be tracked, but it can only be tracked via the, as we've talked about, the cell phone towers and like the call detail, like the shit like that. Like, in other words, it can't track you in that precise manner with GPS type of a GPS, things in the realm of GPS, right? With latitude and longitude, you're working with, again, the more generalized, unless you're in a, you know, again, if you're in a city where there's a lot of towers, it can be different. Still not going to be as precise though, but it can still be tracked through those means, but it can't be tracked with like your GPS type stuff, that type of location data. But if you have it, location services turned off and airplane mode on, or if you have the phone powered off completely, it couldn't be tracked in any way. And the difference, again, being that if the phone is powered off completely versus airplane mode and location services turned off, is that when they get a Celebrate extraction, they will see that the phone isn't doing anything within itself, even if you aren't using it, right? That's the key difference. So Twiz said he told him that he knows exactly where BK was, and no other cellular expert could argue with him. So did he tell you within what time frame? Like what time frame? So well, again, just going back, well, okay, not to try to derail because we're going to be talking about Casey Anthony today, but you know, and this might be one of those things, right, where, like we were saying last night, right? If, for example, the data that the state looked at, the data provided by the state, if that for sure confirmed, like there's no way, you know, the location during that time period, there's no way he was there, right? If that's the case, again, we wouldn't be having this. They would be looking for somebody else, right? So the fact that that hasn't happened yet, if the state knows that they've got this expert, right, who can pinpoint exactly where he was, and it's during that relevant time period, then what you're going to have is the only logical conclusion there is that somebody's going to have to dispute that, right? Like, in other words, some cell expert that the state has is going to have to dispute that and say there's something that's flawed about it. I mean, just because otherwise, again, we wouldn't be here. I'm not saying I think it's flawed. I'm just, oh my God, I'm just saying that's what would, why are things beeping at me? That's what would be, oh my God, don't install things. Sorry, my computer is trying to hijack my brain in my life here. Okay, so I think it's trying to install another something rather, whatever. Okay, so oh, there's another Karen Reed motion, really? Hi, Carla. Welcome back. Welcome back. Let me know if you want a custom command, my friend. Shout out to Iowa. I hope you're feeling better also. Flash is doing better. Still haven't heard an update from Candace, and I think there's a couple other people who might have been sick, but hopefully you're feeling better. Happy to see you, my friend. Y'all, anybody who doesn't know Iowa runs a 24/7 live stream, night and day, obviously 24/7, of their backyard camera featuring, they've always got a really great setup with like a setting, like little like props and stuff, and squirrels, birds, all kinds of wildlife. And so it's really great just if you're wanting something relaxing to chill. So do go check out their channel and subscribe, please, because we love them. They've been a squirrel friend for a long time. So, oh yeah, squirrels all over the place. And Squeaky, how's Squeaky doing, Iowa, if you're still listening? Squeaky's one of the squirrels there. And also, by the way, if you guys do check out their channel, if you go to the community page, they post all kinds of pictures of, like, you know, they've got like how many cats, Iowa? Like cat. It's like they got all the animals, tons of cats, tons of dogs, and then also the squirrels. And you get to see like, you know, up close, like pictures of these. Anyway, it's awesome. You guys will freaking love it. Honestly, I get cute overload when I look at Squeaky, so I have to restrain myself because it's too much for me, honestly. Oh, okay. Money for the, okay. Thank you, Top Cat. Yeah, I haven't looked into that yet. So, hashtag Twizzlefacts. So, okay. Thank you. So one issue is that when BK was arrested, all he had was a CDR. No further data was available to MPD. I'm sure they're lying. It's clear that they're lying. That's for sure. So, okay, let me think. Well, and it sounds like what they're still relying on, by they, I mean the state, like what, like in other words, from these hearings, that's still really all they're using, right? Again, there is no location data being discussed in terms of precision location data, be it through a phone extraction or be it through the call detail records, right? Which again, they were given as return to the search warrant through the pen, trap, and trace. Well, having said that, they had the first warrant, right? The 48-hour warrant would have had it, and that would have included the time frame, right? So there's that. So they would have had that, but that was still the 23rd. But anyway, and there's this streamer spinning wheel. But they would have had all of that with the return of that search warrant, which included the CDR, if it existed, right? They would have either gotten it through that or then through the celebrating instruction. What is it? What? So, oh, it's a motion to dismiss. Are they going to try to dismiss all the indictment, or? So they didn't have the timing data. Well, I'm sure he didn't know how to use it. It's just so much like with Karen Reed and the people looking at the car. So I see what you're saying, but still, right? Once they get that information, right? Like, yeah, maybe sure the arrest might have still happened, but once they did get the timing data and learn how to use it and everything, right? And go through that, again, if it showed definitively that there's no way he could have been there. I say there's no way he could have been there, right? Because if there's still a possibility, right, they might, that's maybe going to be what they're fighting over in court, right? It's at trial. But they would still, you know, if it's like the type of thing where it's like they didn't know how to read it and then they got to it later and then they figured it out and then it showed he wasn't there, then again, they would have to be dropping these charges. Yeah. Okay, so you guys are hilarious. Well, and I know it's not an investigation. Yeah, I mean, that's clear. They did not do, I mean, that's clear, right? Because it was really the FBI's case that was doing things. But still, I mean, even if you have a flawed, let's say so if you have a flawed investigation, right? And then, you know, but the cell phone data is the cell phone data, right? Every now and again, there's room for interpretation, but it is what it is if it's there, right? So even if it was a flawed investigation, and even if there's all these other things that are fucked up, if they get the data back and it shows definitively he's not there, you know, I just, there's just no way. So did Iowa say how they're doing? Did you update us, Iowa? Right. So again, and that's what we were pointing out last night, right? The drive test can be wrong. That makes perfect sense. I've seen that in other cases, and we know that the drive test matters because of the tower. So we were looking at that last night, right? And we're gonna look more at it tonight as well. But the difference, right, is the drive test, again, that's not precision location data. That's still working with proximity. That's like the timing, you know, oh my God, I'm blinking, to the tower, right? Timing records. Your community post map. No, I haven't seen that. Honestly, the only community things that tend to pop up on my YouTube page are Iowa's like squirrel pictures and stuff. I don't know why. But we can take a look at that and we can implement that tonight. So, advanced timing, right. That, thank you for reminding me of the actual, yes, advanced timing report. Right. And again, we're going to have a presentation tonight, guys, that's going to explain all of this and show. And yeah. I need to see if I can find the part of the testimony from Murdoch where they explain how the phones try to communicate. I know I referenced this last night and I was like, gosh darn, I should have included that in the clips where the phones are all trying to communicate. I'll see if I can find that for the live stream tonight. I just have to figure out, the first thing is try to remember which witness it was. Anyway, okay. So, okay, so now, but we are going to, topic for today, right? Almost like Karen, oh my God, Casey Anthony. And if you guys, I'm sure everyone knows the case, right? Obviously. But if you've not watched any of the trial, that's okay. I think you're still going to love watching this. Jose Baez is amazing, GOAT. And also, we always start each episode with a recap from the previous episode. And it's the perfect thing for this right now with the timing, because guess what? Today, we're going to be hearing about DNA, the touch DNA. And guess what? It's the state in this case that doesn't want the evidence to come in. We're also going to be hearing about, guess what? Another thing that's relevant to like all these other cases, right? Discovery issues, late expert witness disclosures. The judge has been getting really frustrated with both parties. They've both been yelled at and scolded. It's amazing. There's a lot of drama. And by the way, this is the most high-tech Elmo I've ever seen, even though this trial was in 2011, and the courtroom is gorgeous and there's a lot of things. So we're going to watch this recap. So this is the episode 20 recap real quick. Get everyone up to speed.
It's a house.
My name is Dr. William Cesar, CEASOR, Renato, RANATO, Rodriguez, RODRIGUEZ III.
Wow, that's a name.
You may proceed. Please support Mr. Ashton. Good morning, ladies and gentlemen. Good morning, Dr. Rodriguez.
Good morning.
Sir, can you please tell us what your occupation is?
First, for the court record, if I may state, I am here as a unpaid consultant, and my
oh my God.
Listen closely to the questions and answer only the questions that I asked you.
Oh boy.
Can you give us your occupation, sir?
Yes, I'm a forensic anthropologist.
Okay. Are you a co-founder of the Forensic Anthropology Research Facility at the University of Tennessee?
Yes, I am.
Is that also known as the Body Farm?
Correct.
Farm. Oh boy. And so now we get to where, guess who's there? That's Dr. Voss, right? So I wonder, are they colleagues? I'm sure they brought him on purpose. Oh my God.
Okay. How did that get started? How did you start that?
That was actually the idea of Dr. William Bass, who was the chief member professor at the time at the University of Tennessee.
What is not reasonable as well, Judge, is that an important witness on a case like this should have been deposed. They chose not to, and your order says, and I will read as instructed, opinions that are not expressed in a written report or at depositions taken during the discovery will not be allowed at trial. I asked during a status hearing, what if they choose to not take someone's deposition? That's going to limit these people's testimony. It's going to create due process issues. And every bit of testimony is important, as is this. And I don't have Mr. Ashton's exact quote, but he claimed that they were going to take the depositions, but that this wasn't going to be some kind of trick that we were going to play with the reports. My response to that would be, my response to that was something along the lines of, no one's playing games here, just that if they're going, and it's hard for me to make representations without the exact recollection, Judge. But my understanding and the purpose I brought this up was they were going to try and pull a fast one by saying, well, not in the report, that's it. They should exercise what they have, what tools are given to them, and take the deposition to do the work.
So they did.
Well, Mr. Bias, I want to ask you the same question I asked you earlier at the sidebar. What you're basically saying, sir, is that you can pick which court orders you comply with and which court orders you don't comply with. And that's not going to happen here.
I couldn't disagree with you more, Your Honor.
Well, Mr. Bias, to be quite frank, both sides have engaged in what I call game playing.
Here we go.
Okay. And this is not a game.
Ruh-roh.
It appears to me that this was quite intentional. This was not some inadvertent slip.
Wow.
This was not some sub-issue of a major issue.
Oh, dear.
It was not inadvertent. The question is whether or not Miss Anthony should be punished as a result of this. Lightning does not strike twice in the same place.
Okay.
Werner,
This dude is a G.
E-R-N-E-R.
G. You guys,
Yeah.
y'all don't even. This dude is the greatest G, like OG of all time. Y'all are gonna love this. These clips.
GV.
You may proceed, Mr.
Good morning, Dr. Spitz. Can you tell us, sir, a little bit about just who you are? What is your profession, sir?
I'm a forensic pathologist.
What was the first thing that you did, sir, after speaking with the Bias law firm?
Thanks for this,
I
guys.
requested to attend the postmortem examination because the postmortem examination at that time when I received that call had not been performed.
Meaning the autopsy by Dr. Kerfuffle?
Yes.
This is
Wow. I'm so excited. Did they let him go? Did they let him attend or not?
He allowed to be in attendance?
I-
Oh boy.
Yes,
Oh boy.
he was accurate.
Wow.
You may proceed.
I think the last question was, sir, did you request to attend the autopsy with Dr. Kerfuffle?
Yes, I did.
Were you allowed to?
No, I was denied.
Oh my God.
Did you conduct a second autopsy?
I did.
Get ready.
When
Y'all get ready for this. If you did not watch this whole trial, or maybe if you did, but it was a long time ago, like you talk, get there. This case is just bombshell after bombshell after bombshell. Get ready for this.
initial autopsy was terminated, I was
Interesting.
given access to the remains.
When you conducted the autopsy, what, if any, first observations did you make that were remarkable to you?
Well, I came here to Orlando, equipped with all kinds of equipment to perform an autopsy, but I did not bring a cell because I was absolutely certain that this autopsy had been completely done.
Oh.
When I came and I looked at the body, it had not been completely done.
What had not been done, sir?
Oh my God. Don't tell me what. Just when you think it can't get any crazier in this case, right?
What had not been done, sir, that you believe should have been done?
Well, it's not that I believe, but I think the profession dictates that when an autopsy is done and done the way it should be done, there should be an examination of the interior of the head, and that was not done because the skull had not been opened.
And did you, sir, open the skull and examine it as a forensic pathologist?
I did.
Now, take the contents out, sir.
I'm sorry, I couldn't hear.
Open the bag and take.
This is where we get to his pet skull, as it were. I love this.
Skull, not the skull of this deceased.
Oh,
This is a skull
oh,
of
he's German.
an adult human being.
Oh my God, this is freaking amazing. He's got a plastic skull.
It's great.
In this case, do you know what the manner of death is?
The manner of death, I would not be able to tell you.
Determined.
Based on the exam.
And that makes sense, right? Because remember what Dr. G came up with was cause of death undetermined, manner of death, homicide by undetermined means. And then when asked again further, it's like, well, where did you get the homicide part? Oh, I got the homicide part because of Casey's behavior, but had nothing to do with the autopsy.
Disgusting.
So
Examination as it stands today, I could not tell you what the manner of death is. But to not open the head, I think, is a failure of the autopsy. And I'll tell you.
Now, this is on Cross. Okay, this is snippets of him on Cross. Dude, he obliterates Mr. Ashton. It's great.
Another thing, that if an autopsy was done in a corresponding to what I think every forensic pathologist.
How's that being generous, saying the state was mediocre? The state sucked, you guys. But I love, yeah, that's very generous. It is, it's an atrocity. Yeah, they're terrible. And Mr. Ashton, by the way, for anyone who doesn't know, became like a judge, but recently he's been in huge trouble. Well, he had ongoing troubles, but even more trouble recently, where they're trying to remove him from the bench for all kinds of disorderly conduct. You guys can Google it and see. It's a mess. So.
To tell you where the head is not opened, that tells me about a shoddy autopsy.
Ooh.
Excuse me the expression, but you provoked it. A shoddy autopsy, because if the head is not opened, what else wasn't examined?
Right.
Sorry, I apologize. I didn't mean to provoke you.
Yeah, it is. It upsets my better knowledge,
Yeah.
my better understanding of my profession that I've now practiced for 56 years. That somebody would
6 years.
do an autopsy.
You know, let me object. Excuse me, sir.
So here's what I think he's saying. What he's saying is, I'm sure it's published somewhere, but it's so obvious.
A skull is opened in an traditional autopsy of a non-skeletonized remains in order to examine the brain within the skull and the structures within the skull. Isn't that the reason?
No, that is one reason, but it's not the only reason.
What other reasons are there?
Well, each case beckons a certain examination of certain things within that same location, namely the skull and what else is there. I would never have known how this head was positioned, for example.
Right. Yeah.
If I didn't open it.
We'll discuss that in a minute. But what I want to establish is there's also a protocol for autopsy that requires the opening of the chest by, is it cutting the ribs along the sternum?
Well, you're not going to.
This is really dumb. So Mr. Ashton here is trying to suggest that, you know, there's a procedure where you might open up the chest so you can take a look inside during an autopsy, and that if that wasn't done in this case, why is that not a problem? But the head was, or whatever. He's trying to say it's the same thing. But wait.
To get access to the chest organ if you're not going to open the ribs, just as little as you're going to have access to the brain if you're not going to open the head.
So certain protocols apply to non-skeletonized remains, don't apply to skeletonized remains, because you can see what's in there because everything else is gone. Correct?
Not the head,
No.
obviously.
You mean you can look inside the head without opening it?
Yeah.
Well, you have to show me how to do that.
Amazing. He's like, dude, he's like, that's the stupidest question I've ever heard. Y'all.
You know, this this sediment is so common in skeletal remains that have been subjected to extensive decomposition of the brain and soft tissues that it is almost as definitive a finding as to say that here, this is a lower jaw. I don't need to research the background of this to say that this is the mandibular bone in an elderly individual. It is almost as definitive a finding as to say that here, this is a lower jaw. I don't need to research the background of this to say that this is the mandibular bone in an elderly individual, a human. So this, I don't need that because this speaks for itself. The same as this speaks for itself.
Race ipsum loquitur. Oh my God. Y'all, sorry, did you hear that? I don't know if you guys can hear that. Anyway, that's the electricians. I was saying race ipsum loquitur, right? The thing speaks for itself. Love it.
And the same as that speaks for itself.
There you go.
But if I had been there with Dr. Garavaglia, I would have insisted that I would have told her, you know what, let's take that and send it to the laboratory. Then we wouldn't have all this kerfuffle about determining what is what when you inject fluid into a closed.
Oh my God, kerfuffle for the win. Let me back that up. You guys, he is the best.
Dr. Garavaglia, I would have insisted that I would have told her, you know what, let's take that and send it to the laboratory. Then we wouldn't have all this kerfuffle about determining what is what when you inject fluid into a closed box, swish it around, and then now we're arguing about where it came from.
Oh my God, this is brilliant.
My favorite part. My favorite part. Him taking back his head.
The way he just collected his skull back. Hold on. And Mr. Ashton is like not happy. This is like, hold on. Look at this. Watch.
My favorite thing ever.
290.
That's my favorite thing of all time. Oh my God. Oh my God. He's protective over the skull. I love it. Good. I'm glad.
If this is
God, brilliant.
matted hair,
I love this. Brilliant. Brilliant.
this is a matted hair.
Oh my God.
Skull is like this, and the hair would be here, here, and here. That's what you see.
So your
That's what you see.
your
Let
recollection.
me show the
Oh my God.
That's what you would see.
So,
That is what this picture shows.
Doctor, so is it your statement that the photographs show that there is hair, a considerable amount of hair on top of the skull, that it hasn't almost all fallen to this back and the sides.
I don't see any evidence on this picture of what you call falling hair.
Amazing.
The other thing is that in a case of in certain types of death, there would be hemorrhage
This is a good one.
to the in certain locations on
This
the
is really important. Right here, he's getting to the potentiality of being smothered because the state's theory, well, the state doesn't have a theory of the cause or cause or manner of death. They don't actually have, and that's been something we've talked about throughout this entire trial. Because when I started streaming this trial, I'd never watched any of it. I just knew what everyone else knew, which is just the main general consensus. I had never watched it, so I went in completely objectively to assess this, like knowing nothing about it, right? So as we've gone through it, it's really fun, like discovering all these different things. And one thing that has been abundantly clear is the state really has no theory. But one of the things that has been posited is that maybe Caylee was potentially smothered, like via the duct tape, right? But listen to what he says here, because this is important in terms of addressing that potentiality.
to the in certain locations in the base of the skull. I think I mentioned that earlier. In the area of the middle ears, in the areas of the this bone here behind the lower jaw, which would contain a coloring that's in the bone that is difficult to remove from blood that had accumulated there, which is not here, did not occur in this case. Another
Excuse me,
thing,
Doc. What other types of death would cause that hemorrhaging and discoloration by blood on the base?
well, it doesn't occur each time, but in a good number of times, there's hemorrhage in those locations in cases of asphyxiation by smothering or by strangulation.
And how does that occur?
Well, because if you smother somebody, the blood pressure goes up in the head area, and then blood vessels break, and that's the location where you get the evidence.
So in many occasions, if there is a suffocation, an asphyxiation, the blood pressure alone will cause there to be hemorrhaging and discoloration on the base of the skull.
Well, as I said, it doesn't happen every time, but when it happens, when the blood decomposes, it leaves a residue, and the residue is colored.
I will be presenting the court with additional requests for sanctions to alleviate the prejudice. But at this point, those are my initial requests.
The prosecutor in this case has attempted to narrow the scope of the testimony of these expert witnesses by intentionally refusing to take their depositions.
That's what we
I say this is an intentional act.
And we talked about this the other night with when we were watching the Adelsons, because remember how I was describing how it works with depositions in different states, and in Florida they're unique, where it's like everybody takes depositions. That's just like a thing. In North Carolina, that is not allowed. So this is what he's talking about: is that the state should have and could have taken this deposition and intentionally did not, so that they could then later on complain that they didn't know this expert was going to disclose an opinion. That's what's going on here. I was actually pretty surprised that Judge Belvin ruled with the state here on this to a certain extent. And also Twiz, if you want to tag me, by the way, in that community post where you referenced that map, that way I should hopefully get a notification and see it. And I will implement that. I'll make a note too. I'll implement that into what we talk about tonight, by the way.
Because it is clear that there was a sufficient time period for Mr. Ashton to coordinate these witnesses for depositions, set them, and conduct them. This package that he claims to put together or want to put together can easily be done for him, as the state has violated this order.
I was literally just
It's a sanctions package is what he's referencing.
going to say, wait a second, shouldn't he be asking for sanctions on the state?
No, on two occasions. One with Dr. Rickenbach,
Right, exactly. Yes.
which was taken at sidebar.
Yep.
The objection was sustained because he wanted to elicit testimony outside of his reports or deposition. And it was quickly moved on with no threats of any sanctions and no threats of being held
I
against.
also referenced that earlier. What I referenced earlier is how when this happened before, it was just they just can't testify to that new opinion or whatever, but there was not, that was it, right?
Contempt of court.
Yeah.
Furthermore, when the FBI, with the late disclosure of photographs the morning of trial,
Right. I know. The photographs just didn't come in.
that too is addressed and moved on. I think that the court has made it clear that this is not a game, and that gamesmanship has been exercised by both sides. And I think that this is nothing but a clear exercise of gamesmanship that is carried on from Mr. Ashton from the very beginning. He is a skilled and experienced prosecutor that knows that with expert witnesses, you should take their deposition. I would venture a guess to say that he has never had a trial where he has just completely ignored expert depositions, especially those such as important as these. but yet
Yeah.
he was armed with a court order, which he thought.
I think one of those things happened where something didn't come in the StreamYard chat. What are you guys talking about? About smothering or asphyxiation? Yeah. So he was saying that if it had been smothering or asphyxiation, there should have been something present there in the skull that wasn't present. I know he was kind of hard to understand. So Top Cat saying what she does in Australia, all of the above to attorney, cop, and serial killer. That must be pretty difficult as well, huh? Oh, yes, we've talked about that. I think you were sick, Flash. That's right. Thank you for mentioning that. And for anyone who hadn't heard that yet, the case in Utah, that's insane. So yeah.
Yeah, exactly. Because Mr. Ashton is like, well, if I just don't take their deposition, then I can say this is a new opinion or whatever. Yeah, I agree.
Games with and use as a sword and both as a shield by completely and intentionally ignoring his responsibilities as a prosecutor to go forward and fail to not take a deposition. The remedy under the law is to give the prosecutor time to take his deposition. These things occur on many occasions, and these are really minor issues.
Y'all, is he going to have another schizophrenic moment?
He's having another schizophrenic.
The duct tape opinion.
You guys, okay, so let me back this up and explain. So there's a history here. Let me pull this up first. So Mr. Ashton does this. This is now a thing that he's been doing. So I actually saved a clip of this, and this is from a couple episodes prior, and I called it Mr. Ashton's schizophrenic moment. So let me play that so you'll understand why this is so fucking funny.
You were asked about Dr. Voss. And,
oh my God.
You were asked about
oh my God.
Air samples. Have you ever heard of any case where air samples were used in a forensic setting?
Objection. Relevant expertise.
Okay, so now he's doing it again.
On many occasions, and these are really minor issues.
Y'all, is he going to have another schizophrenic moment?
The duct tape opinion.
He's doing it again. Hold on. Another schizophrenic moment.
His deposition. These things occur on many occasions, and these are really minor issues. The duct tape opinion. We did not intentionally look at this order.
So good question, Carla. So the chloroform. So at one point earlier on, I was doing a poll, like what to the people in the chat, like what did you guys think the cause of death was, right? Because like at the time, I remember like back in the day, right? I remember being like, I remember there was talk of drowning, and I remember the talk of chloroform, right? But then there were other people who chimed in that they had heard something about being poisoned by Xanax. And then there was like another thing, being smothered or something, right? So the duct tape, right? The duct tape. So there were like at least 4 main things that people thought was supposed to be the theory of the case, the state's theory of the case. There's a reason why there was so much confusion with that. But as far as the chloroform is concerned, so, of course, we've already covered a lot of that, but just in summary, the thing with the searches being made is that it actually could have been Casey or her dad, because her dad was home. They looked at all the work schedules and all that, and that's the state has said that, right? That George Anthony was home at the time when those were made. But the other thing is that the media, I'm sure at the time, made a whole lot about the chloroform searches because basically like the way that they said, I can't remember the exact number, 78 or whatever, some crazy number of chloroform searches, right? But what we learned in the trial is that the amount of time on all of them total was something like under a minute or something. And basically what they were able to prove is that it was just because the search happened once, but then like every time you closed the window or whatever, and like that tab was still there, it kept refreshing it. And so it looked like a bunch of searches when it wasn't. And also the other thing that I think is crucial is that the first search happened right after Casey's ex-boyfriend Ricardo had sent her this thing on MySpace, and it was this weird ass picture that had this scene of like a fancy dinner party and a lady with an evening gown, and it said on there, "Kill her with chloroform" or something. And I don't know what it was supposed to be, but he sent her that, and it was right after visiting MySpace and seeing that the first search was made for chloroform. And so my thought, and they can't suggest this, but the jury probably intuited what I did, which is that she didn't know what it was because it's archaic and it's from like Victorian England or whatever, right? And so Googled it because she didn't know what it was. Okay. So, and then as far as the chloroform in terms of the body, the levels that were there were so freaking negligible, and that it is the amount of chloroform that would normally be found by a naturally decomposing body. Now, the state wanted to try to suggest other things because of the smell in the trunk and the stain, which I can't see it, it's invisible, but a supposed stain on the spare tire cover. But literally that has all been completely obliterated. And every expert that's come in the defense case in chief, and it only makes sense when you go through it with like the theory of the timeline and how everything works with like bodies and, you know, even the state's own experts, right? Like when we were in the state's case in chief, I looked at this timeline and I said, there's literally no way that there was ever a body in that trunk. There's no possible way. But then we heard it point blank from a defense expert who said there's just literally no way. So it's there's a lot of misinformation surrounding, I mean, that's an understatement. There's only misinformation surrounding this case. And oh, and her parents, so similar to Wendy, it was not her mother, it was her dad. Her dad, this is in the Orange County Sheriff's Office investigative report, which we went through that entire thing at one point. In the Orange County Sheriff's Office investigative report, it's even worse than Wendy, okay? Literally, as soon as law enforcement arrived at the house, George pulled them aside and said, I think Casey's not telling you everything, and something akin to that she could be involved or know something more, something like that. George threw her under the bus right away. My interpretation, having covered this entire trial so far, up to where we are now, is that Cindy Anthony is a rare bird. She's very unusual. There's a lot of weird toxic family dynamics going on. That's an understatement. But I think that Cindy still doesn't really know for sure what happened, because there's times in the testimony and in the video jail calls that point to that, where she's like shocked by information. The video jail calls are extremely telling. Anyway, I could keep going, but yeah. And the other thing that I pointed out is like, they have those searches, which are stupid anyway, but literally they have no bank records. They have nothing showing that then anybody went and tried to obtain chloroform, such as where do you buy it, or buying supplies to make it, or paying for it. They have literally that's it. It's just the search. And then there's no follow-up to that of like, here's the person making chloroform. And who would even like you think they would even like, who of all the things, right? It's just so it's like trying to, I don't know, what else is something that seems like a really archaic thing that would be like, who would ever think to do that? Like there's other ways, right? You're going to try to do that. Oh, and it's not just her. I have a screenshot saved on my computer. Let me show you guys this for those of you who haven't seen it real quick. This is from Verdict Watch of Richard Allen. Let me find this. This is crazy. And I just had like the local news feed or whatever, and they were waiting for someone to come out of the courtroom and say the verdict. And I see this all the time, but this is just a time where I was able to get a screenshot of it. Let me find it. And I wasn't like watching and this is before I pierced my eyebrow. Those of you guys who've heard that story, but I was just seeing that, just the chat scroll by, whoever it was. Again, it was just like the local news people. But I just saw something that caught my eye, which again, I see it regularly, but where is it? Hang on just a second. Oh, here it is. Okay, found it. And this is the thing that's so crazy, right? Is that people that still talk about it, they talk about it when it's completely irrelevant during other things. Like this example, that's what I'm going to show you guys, is what I see all the time. And it just blows my mind. And by the way, none of these people watched the trial. So here it is. So again, there you can see, so this was at the time waiting for the verdict. And I just saw this scroll by. And it's highlighted here. So Andrea saying, Casey Anthony was and still is guilty AF. Hate that woman. This is what I'm talking about. This is, at this point, this was 2024. So 13 years later, it's mind-blowing, right? Mind-blowing. Completely unrelated to Delphi. And you see that, you will see this all the time. I'm sure you guys have seen it as well. So isn't that crazy? And that's the Nancy Grace effect right there. That's the Nancy Grace effect. Hold on. Let me find where we were. Okay. No, that's also incorrect, Top Cat. The Orange County Sheriff's Office investigative report shows that and this came out in the trial as well, but literally every single person they spoke with, the way they got to the Xanax is because of the name Zanny the Nanny, which, by the way, if you also look at that report that we covered, was actually a real person that actually, like, all the shit about that was made up, and there's a whole other story behind that, but that was a real person that actually did go to the Sawgrass Apartments and fill out a card to look at the leasing office, which is crazy. But I think that's where the Zanny thing started from. But also, sorry, the drilling. Casey's, what's his name? Tony Lazzaro's roommate was prescribed Xanax, okay? And in the Orange County Sheriff's Office investigative report, they talked to him right away. Oh my God, I know, I'm sorry, that's probably really loud. They talked to him right away, and he also testified in the trial. And they were you could see that they were fishing to try to find some way to connect Xanax to Casey. So they asked him point blank, and when they interviewed him, and it's in the report, like, they asked him point blank, like, did you ever give her any Xanax? Did you ever sell her any Xanax? And he's like, no, I never did. Never gave anybody any Xanax, blah, blah. And then since that was a dead end, they went around to everybody else. And literally, even the notion that she was a big partier all the time is completely false. There was testimony at trial that even when she was out at the club, she wasn't drinking most of the time, or if she did, she drank light. So the whole thing, like, literally the only thing that has surfaced is, like, she drank light occasionally, right, when she went out, but it wasn't like what was portrayed in the media, and that she smoked weed. But there is literally nothing to show that she ever used Xanax. In fact, all the evidence points to the direct opposite of that. So yeah. She was acquitted by the jury. And I'm not the only person. I dare anybody, seriously, guys, I dare anybody to go in. This is what I did. I had no opinion. That's why this entire thing was like, did the jury get it wrong, right? Because my thought was they got it wrong, because that's the whole thing that everybody's been thinking. It's like that Mandela effect, right? And I went into this objectively. I challenge anybody to go through and watch this trial objectively and come to any other possible conclusion. And I never said innocent, by the way. I think that in my personal opinion is that I would say I'm like 90%, 10%. 90% is George had something to do with it, or it was some sort of accident, right? But then he asked, and then Casey saw it and he asked her not to tell. Like, I'm 90% that, like, it's George and he roped her into it in some manner, or she saw something happen and she didn't want to say something along those lines. Like, basically, I think my feeling is that it was George is really what was involved here. It's just a matter of, was it an accident? Was it a case of being negligent, right? And he just didn't want to get in trouble, and didn't think it would turn into a homicide case. Was it an accidental drowning, or was it something intentional? I 100% believe the pool was involved because of everything that happened right afterwards. And that's what Cindy had said over and over again. Laddergate, right? We've talked a lot about, and that Casey has some knowledge of it. That is, and then the 10% thing would be Casey was involved, but I think that it was an accident either way. If Casey was involved directly, and if it was George directly, then either accident or not accident. So again, there's innocent is, a completely different thing. We still don't really know for sure what happened, but no matter what, it's like, 100% the state didn't prove it, obviously. So. But yes, anybody who wants to be able to, if you want to be able to give your opinion of the evidence, the really only way to do that is to watch the trial, right? And so, again, if anyone wants to do that, everything's always time-stamped, as y'all know. Anytime there's a big tangent that's not related, that's time-stamped. Should you want to skip it, all that stuff. So yeah. A flash. So what's the video that you have, Heather? I swear there's messages that are not coming up in the StreamYard thing, which is annoying. And remember, the duct tape only connects to George, Anthony, and there's that. And so does the, everything that Caylee was found in all connects to George. And yeah, but again, I'm not going to go back through all the evidence and what it shows. You'd have to go back. Barbershop clippers. That's funny. Are there this one? So cell phones were not really a part of this apart from text messages because it was dumb phones back then. Right. So that's not really a part of this case. And I don't even know that it would really be that much different because they all lived, like Casey lived there. Well, she was, I guess, living with Tony at the time of the death of Caylee. But the cell phones haven't really been a part of this very much. The computer has. Yeah. But the thing that we're going to get to, if I can stop talking here, is the DNA, right? The DNA and the touch DNA. And that is highly relevant to BK for those of you guys who mostly focus on that case. Highly relevant. And that's what we're going to get to. We're almost done with the recap set.
And say, we're going to disobey it. Just the mere thought of that.
He's upset.
Disturbs me greatly. And it disturbs me that anyone would either A, make the accusation or B, even assume it to be true.
Well, the other thing I was thinking too is I was like, why would anyone deliberately not follow the order? Like, there's no reason to do that because it's like you're just going to have to turn the stuff over anyway, and you're going to get punished for it.
Because a prosecutor decides on his own, without assistance or acknowledgement from the court, to omit his professional responsibility and to omit his duty to carry out and utilize those tools which are afforded to him under the rules of discovery, and then attempt to use that as some form of sanction. Okay. It's not bad enough that he wants to omit these responsibilities in the efforts of taking a human life. He wants to go after her lawyer too. And I think it is repulsive. And I think it is also not under the law and shouldn't be dignified in any way, shape or form by this court. He had a responsibility. He intentionally omitted that and neglected it. And he should not be allowed to come forth, not even at the 11th hour, at the strike of 12, and decide, okay, now I want to utilize something.
Flash, you've been here for, I think, almost all, maybe not the first couple of episodes, but you've been here for almost all the Casey Anthony. What is your thoughts? I'm just curious on Casey's involvement and innocent versus not innocent, or guilty or not guilty, anything that, any thoughts that you have.
And do it in a manner that is, I don't want to use the word disingenuous, but to do it in a manner where it's unreasonable. It's unreasonable that he should think that Dr. Rodriguez would have opinions such as these. These are obvious opinions. These are obvious things that, these are obvious troubles with their case, and they know it.
Oh boy. Okay. What is Judge Belvin going to say? Somebody's going to get yelled at big time.
I'm going to ask both sides to turn around and look at that clock back there and tell me what time it is.
Oh my God. Uh-oh.
Mr. Ashton?
9:25.
And Mr. Bias?
9:46 is usually the number.
Okay. All right.
I saw where that was going.
That shows that the two of you will never agree on anything and will never interpret anything the same way.
Yes. George.
Enough is enough.
Yeah.
And both sides need to be forewarned.
Jennifer Welch. All right, here we go. There she is.
Jennifer Welch, Welch.
She's testified like 50 bazillion times. So that's the other thing. This trial is really funny. The witnesses all testify like dozens, literally, of times. It's really unusual.
Proceed.
Thank you. Ms. Welch, I believe you've already established that you are a CSI Orange County crime scene investigator. Is that correct? Yes, that's correct. Okay.
She lives in that courtroom.
We'll say, like, honestly, she's probably, if you look at all the days of this trial, I would say she's probably testified more days than not in this trial.
Yeah,
oh my God, I just remembered something. You guys remember last night when I was referencing that Flash looked up when the Elmo was invented and we were talking about the Elmo? I'm realizing now that's coming right up in this recap. That's where this was from. So you guys are going to see that, and you're going to see their Elmo, their fancy Elmo.
Oh, I see. Okay. Great.
She's never used the Elmo. Look at their cute Elmo. I love their Elmo. I love that their Elmo. It's just so funny, right? Because the Elmos are already so old school. Like, this one's a new school one compared to others. But like the fact that that's what they use in court, like, I love it. Please don't ever change. But in the world of technology, those are from like the dinosaur ages. like relatively speaking. And the fact that she doesn't even know how to work that is amazing, right? It's like she's used to like a chisel, like, and stone or something. Oh my God, Flash, you're the best. The Elmo projector came out in 1927 in Japan. So first of all, that's incredible. But that just, so here we are in 2011 and she does not know how to work this.
Okay. So now we're moving on to the next episode. Yeah, I couldn't agree with you more, Flash. That's why I guess I kind of got, I got sidetracked because whenever, because the question was that I thought she was innocent. And I guess I started answering it that way. But I agree. That's not ever something that I really think about for the most part, unless there's like a situation where I guess it just depends on the case, but like that's really not the standard, right? But when you look at things like Richard Allen, you look at things like Karen Reed, they're a little bit different, especially because of how the investigation was done, and you guys know, right? And in this case, there wasn't really any like funny business in terms of like the CSI and all that, right? Like it was very like the funny business really has come from once going to trial, the prosecution really misleading the jury. But in terms of like, so in other words, it's like, I don't know, it's a bit different in terms of the level of misconduct, I suppose you could say, if you will. She looks crazy. Oh yeah, she does. But when you, especially this, if you watch her parents testify, or if you watch the video jail calls, you will see that honestly, she's like the sane one in the family. Seriously. The video jail calls are very revealing. Highly recommend. And I think that I have a best of the video jail calls video that I made. That is really a good one. It might be under videos and not live streams. I think there is one. So anyway, oh yeah. So if you're talking about this case, so they didn't find the remains until 6 months after Caylee went missing, which is why she was completely skeletonized when they found the remains. Okay, so now on to the next episode, like Dr. Dre. Shout out to Dr. Dre. Episode 21, the states fight to keep out touch DNA.
My name is Jane Bach, B-O-C-K.
You may proceed.
Thank you, Your Honor. Dr. Bach, what is your occupation?
I'm a botanist.
All right. And what type of botanist are you?
My specialties are plant ecology, plant anatomy, and forensic botany.
And can you tell us what forensic botany is?
Wait, I missed her first name. Hold on, let me back it up a second, because
Dr. Bach, what is your occupation?
My name is Jane Bach.
Oh my God, the
B-O-C-K.
You may proceed.
Thank you, Your Honor. Dr. Bach, what is your occupation?
I'm a botanist.
All right. And what type of botanist are you?
My specialties are plant ecology, plant anatomy, and forensic botany.
And can you tell us what forensic botany is?
Forensic botany is the applications of plant science to matters of the law.
All right. And can you give us the benefit of your education?
Certainly. I have a bachelor's degree in botany from Duke University in North Carolina, a master's degree in botany from the University of Indiana in Bloomington, and a PhD in botany from the University of California at Berkeley.
All right. And have you had an occasion to teach botany?
Yes, I'm a retired biology professor, and I taught botany for, and I'm still teaching it a little bit, 40 years.
Can you speak a little closer to the microphone? I think some people may be having problems hearing you.
Yes.
Can you say that again? You taught what?
I've taught botany for 30 or 40 years.
All right. And have you authored any publications in scientific peer-reviewed journals on botany and forensic botanical issues?
Yes, I have about 80 peer-reviewed papers, maybe slightly more by now.
And what does peer review mean?
It means that you send in a manuscript to an head editor, and if they decide it might be of interest to their readers, they send it out to people thought to be expert in the field of the topic of the paper.
Okay, and have you authored any books?
By the way,
yes.
Any of you guys who watched, I know, still don't really know why, but Kane played a video on a live stream of me playing violin. I don't know if you guys noticed, but if any of my violin videos, if you look closely, and you might notice it now that I mentioned it, if you look closely at the edge of the stage and there's something there, that is my J.S. Bach action figure. So for every one of my recitals, I brought my J.S. Bach action figure and he sat on the edge of the stage because J.S. Bach is my hero.
Yes, I've authored 3 books and edited another one.
And what are the topics of those books?
2 are on plant ecology. 1 is on forensic biology.
Okay.
And
so great. We're going to just go ahead a little. There's George Anthony.
All right. And can you tell me, please, whether or not you've received research support and from what organizations?
And Cindy, right?
During my academic career of about 30 years, I had continuous research support from the National Science Foundation, not all of them at the same time. The National Science Foundation, the National Institutes of Justice, the Charles A. Lindbergh Foundation, the National Park Service, U.S. Forest Service. That's a good sample.
All righty. And what organizations, what professional organizations are you a member in?
I belong to the American Academy of Forensic Sciences. I belong to the International Association of Identification. I belong to the Botanical Society of America.
Tell me whether or not you've given testimony in trial or
Very good.
If you count depositions.
I mean, a forensic botanist is a very niche field, but the state did not offer one.
And have you ever given testimony in cases
Yes.
and forensic botany?
What says the state?
No objection to her qualification, and if I may have a moment with counsel as the court is announcing her.
Okay. Ladies and gentlemen of the jury, Dr. Bach would be accepted as an expert witness in the area of forensic botany and permitted to render opinions in that area. You may continue.
Thank you, Your Honor. Dr. Bach, what items have you reviewed in preparation for your testimony here today?
Bach is the German word for river.
I have looked at photographs taken by the medical examiner and
Oh,
photographs.
you know what's funny? That's funny because the closed captioning, and I think on Court TV it says Bach. That's really funny. I need to correct that because I didn't even think about the fact that people could get it wrong because I feel like when they say Bach, you should think it's B-A-C-H. And so if it's printed B-O-C-K, I figure that has to be the last name. But I'm wondering if it's just that people are dumb and got it wrong on the description on the video. I wonder if it's actually B-A-C-H. Anyway, I'm going to edit that just in case because that's really funny. I'm like, I assume that things are correct here. Kind of like with Google and 119 Lambton Drive, right? You think, yeah, you should be able to rely on this thing. Anyway, all right.
Taken by the Sheriff's Department crime scene investigation
How are you
people.
feeling?
And I have visited the discovery scene, and I have read several documents, printed documents concerning the case.
All right. What printed documents have you reviewed?
I've reviewed the medical examiner's report. I've reviewed the description of the recovery site as described in Ms. Welsh's materials.
All right. And any reports from anyone else?
Yes, I've read the report of a forensic botanist, David Hall.
Speaking of people being back, I have a t-shirt that I've never watched The Terminator, but you guys know, like he says like, I'm Bach or whatever. So I have a t-shirt that has a picture of J.S. Bach, but like in a robot version with like lasers and shit. And it says, or no, sorry, it's I'll be Bach. It says I'll be Bach, but it says B-A-C-H. Yeah, I'll be Bach.
All right. At some point in time, Dr. Bach, did you visit the area in which the remains of Caylee Marie Anthony were found?
Yes.
Are you going?
And when was that?
That was the first day of February.
Of what year?
2009.
All right. And can you tell me, please, whether or not you took any photographs?
I didn't take the photographs, but with me was Patrick McKenna, a photographer, and he took photographs of me at the crime scene and of the, not crime scene, excuse me, recovery site and my work there.
Your Honor, may I have permission to show the witness an enlarged photograph that was taken at the time in which she was visiting the scene?
You may.
She struggles sometimes to get things admitted. Like, so I'm just going to go ahead a little bit because, yeah. This photograph.
This is one of the pictures that Patrick McKenna took when I was at the
There we go.
recovery scene.
And can you tell me whether or not it accurately reflects your visit on February the 1st, 2009 to the area in which the remains were found?
Yes, it does.
Enter it in evidence.
Have we got an ID number on it?
Get it. Get it.
Oh, sorry.
Oh, sir.
If we received an
I'm going to get a lavalier mic for Ms. Sims. She's very soft-spoken. I'm not sure.
Okay, so here's what's going on. This is going to take a bit. So they're going to get a lavalier mic so that this expert can come down, and I love that we can see it, right? And she's going to describe things to the jury, and we're going to learn what she has to say. So they're getting her mic'd up. Technical things. Okay.
All right. Thank you, Your Honor. May I have permission to move the photograph down?
Yes.
Thank you. Can you tell the ladies and gentlemen of the jury what leaf litter is?
It's a general term used for leaves that fall off vegetation overarching the area where the litter accumulates. Mostly, in this case, it was leaves.
No, there's no body there. This is just looking at the foliage. I know that you, so Flash is legally blind, so I wonder if that's maybe why. It's just the foliage. They don't show anything with the remains, at all. So.
But also pieces of stems can fall off of trees and needles from
absolutely true. Right. There was no absolutely true for sure. Yep.
Evergreen plants.
All right, Dr. Bach, let me ask you, after having read the reports and the photographs that you mentioned and having visited the scene, the area, some 7 weeks and 1 day later, can you tell me whether or not you have formed an opinion as to the shortest period of time that the remains of Caylee Marie?
Now this matters. Remember what I was saying before, guys, about how the state's timeline is fucked? Like that's another thing, right? For those of you guys who love these cases where the timeline matters, the timeline here isn't with like cell phones and shit. The timeline, this is really more old school, but really matters, right? The timeline here is really based on the body, the remains. Because the state's theory is that it was in the trunk of the car. Why? Because that's the only thing that they could possibly use to connect it to Casey. The only thing that it was in the trunk of the car. And remember, like I said, is that when you look at the body decomposing, that's impossible. But also, we haven't heard yet from the most anticipated witness of this trial, Roy Kronk, right? Because we learned in opening statements that Roy Kronk is this dude who's like a habitual liar. I think he has maybe a past record or whatever. And he found the remains. And the evidence will show, we haven't seen it yet, but it will show that he found the remains earlier on and then took them because he'd seen signs for a reward. And he was mistaken thinking that the reward, he didn't realize that the reward was if she was alive. So that he had the remains for a period of time. And then when he realized that the reward was only for her being alive, he put them back in where in the proximity where he found them. And then called 911 and pretended to just come across it. Now, why does that matter? Because think about it, right? If a body is in one place for a long period of time, this is why we already heard from the bug dudes were really interesting. That's really great testimony. What is it? The forensic etymologists. So what you have at this crime or the recovery site, right, is you don't have the bug evidence that you would have if the body had been decomposing there for a long time. You don't, and she's going to get to, you don't have the plant evidence, right? And so in other words, the body, we know that there's all this shit. Well, we haven't heard it from his mouth yet, but we will with Roy Kronk. But then you've got the fact that the body was not in the trunk, and then it could not possibly have been the entire time at this location, right? So that's just in summary of what's going on here.
Anthony could have been at the scene in which they were found.
Yes.
Yep.
2 weeks, approximately 2 weeks.
And can you tell us when the remains were placed there?
No.
Heather's sorry. Did the guy with a skull for a pet finder? That's freaking hilarious. That's really fucking funny. No, but thank you for making me laugh at that. Yeah, right. Exactly. There's another guy handling the bones. Right. No, this dude is works for the city utility. He's a meter reader, right? He's a meter reader. Okay. And there's a lot of strangeness about this dude, right? But he's a meter reader. His own son is going to, I think, testify after Roy does. Again, we haven't gotten there yet, and be like, yeah, I knew he had the body. He told me he had the body, and he had a winning lottery ticket, so to speak, and shit like that. So just craziness.
And what is the basis for your opinion that it is possible that they were placed there approximately 2 weeks prior to their discovery?
Because of the pattern of the leaf litter.
The pattern of the leaf litter?
Yes.
And with regard to the vegetation that was found in the car that was driven by Casey Marie Anthony, do you have an opinion with regard to the vegetation that was found in that car versus the vegetation at the scene?
It isn't in agreement with the vegetation.
I don't believe it's been established that the witness has ever looked at the vegetation.
That the witness has ever looked at the vegetation from the car or what her basis of knowledge of that is.
I'll back up and clarify.
Sustain, establish a foundation.
Dr. Bach, did you review a report from Dr. David Hall dated October 31st, 2008?
I did.
Okay. And can you tell me whether or not Dr. Hall set forth items that were found in or under the vehicle driven by Ms. Anthony?
He described vegetation and vegetation fragments associated with the vehicle.
All right. And with regard to that vegetation, what kind of vegetation was found?
Bits of leaves for the most part.
From what?
Especially from a camphor tree.
All right. And can you tell me, please, whether or not there is a camphor tree at the scene in which the remains of Caylee Marie Anthony were found?
There is not one.
Did you review a report authored by Dr. Hall dated February the 9th, 2009?
Yes.
All right. Let me ask you about that report. Does the field of botany...
Objection to counsel eliciting comments on someone else's report.
Overrule at this
Yeah,
point.
she's
I
not-
don't know what the question is.
Well, she's allowed to do that. She's an expert witness. So yeah, just to reiterate, for anyone who's just not joining us, welcome. But yeah, I went into this having never watched the trial again with a completely open mind, because I think that's important, and to assess this from a clean slate, going through it very objectively. I had literally, it's like I had only heard what everyone else would have heard in mainstream media, right? But the thing that we know is that she was acquitted, and we know that, and I used to keep it in the description. I stopped copying and pasting it because I was running out of text limit when I was doing my timestamps. But anyway, like in less than 1%. So in Florida, the rate of acquittal is less than 1%. So it's so rare for a jury to acquit, right? And that's why, and what spurred this on is because people had always asked me, why did the jury acquit her? Like, my understanding, if people had asked me before I watched this trial, if people had asked me, where did the jury get it wrong? This is one of the cases I would assume would be like, yeah, this case, obviously, right? Like, that's what I would have said. But it wasn't until people kept asking me, like, why did they acquit her, that I was like, you know what? I can't answer that question because I haven't watched the trial. So let's do that. Let's watch the trial and let's ask ourselves this question. Did the jury get it wrong? And let's go through this with an open mind and objectively look at the state's case. And so that's what we've been doing.
Does the field of botany train botanists to estimate how long a root has been alive?
Remember, and that's the thing, is that, and we see this in cases, right, where it could be one way or the other, where people have their own opinion and they admit that the state, and Top Cat agrees that the state didn't prove their case. But remember, right, that's the jury is told to assess the evidence, right? So that, unfortunately, sometimes you might have a juror that, like, take Richard Allen, okay? Take Richard Allen. I think the only explanation there is that the jurors had a gut feeling or an opinion, and that they voted with that, or, they put their vote in for the verdict on that versus the evidence. That's the only explanation, right? That they went with their gut or their personal opinion versus the assessing the evidence. So what I can say about this case is that that's not easy to do. And you might have some, you might, like Karen Reed, for example, you might have some cases where some people can put their opinion aside if it's a biased opinion, and some can't. And you might end up with a hung jury. And I'm not saying that's what happened there. I'm just using it as an example where everybody was confused about that one, right? But what I can say for this case is that the jury here, and think about it too, right? Think about, when you think of, keep that in mind, and then you think about a mother killing her child and the circumstances of this case, right? And think about, despite that, the jury was able to set, if they had any bias or opinion, they were able to go off of the evidence. And I commend them for that. Now, having said that, it's entirely possible that their opinion or gut feeling is that Casey didn't do it, right? But regardless of what their gut feeling or opinion was, they were able to assess the evidence and hold the state to their burden.
If they don't know the root solely by measuring the diameter of the root.
Objection. May we approach?
You may.
Approach.
Dr. Hall.
Oh, yeah.
Just a second.
Oh, yeah. Yep.
Okay, objection sustained. You may continue.
Thank you, Your Honor. Dr. Hall, when you look at the photographs,
I'm Dr. Bach.
Flash had the wrong chat. You guys, Flash mods for other channels. I can't remember how many, but he's modding right now. He said it's the wrong chat. So which is okay. That's fine. It's all good. It's all good.
Dr. Bach, it's been a long day already. Dr. Bach, when you look at photographs that were taken in this case, can you tell us by looking at the photographs how old the roots and the plants are? Just by
No.
looking at the photographs?
No.
Why?
Because I don't know what plant those roots came from, and size and growth rates and all those
Can you get
things.
closer to the mic? I'm sorry.
And the thing is too, you guys will notice a theme, right? It's like, I welcome all opinions, right? As you guys have heard me say before, time and time again. And for anyone who's new or watching this later after the fact, now you're hearing it as well. But and so I think it's important, though, again, for us to be good trial watchers and people who study the law and have an interest in the law and justice, to try to, again, as I always say, keep an open mind and try to bring an objective opinion. Now, or objective perspective, right? And I understand that it's hard sometimes to set aside a gut feeling. I think it's something that you can practice doing and get better at. I mean, I can say that it is something that I have gotten better at through doing this, right? And I think violin also helps with that, because literally there's a thing where people can get really toxic in their own head of being like, that sounded bad, or I'm terrible, or whatever. And like, you can't continue on with like being a classical violinist and get anywhere if you don't learn how to change that thinking into, instead of like qualifying or like name calling or judgment. That's what it is. Like, instead of judging yourself, instead of doing that, you have to train your brain instead to be like, okay, was this out of tune? Or what was it that, you look at the music and then how to fix it. Right. And so anyway, but also I would say again, like, I would say that for me going into watching trials initially, I tried to be objective and open-minded, but I will say that obviously I love it when we can surprise ourselves, right? And I've been pleasantly surprised time and time again that I could have always been more objective than I was in the past. And you learn to do that through practice. It's one of the reasons why I love studying law and love watching trials. And so, so that's the thing, is like, I just ask that people, just be fair and to try to keep an open mind. And again, I totally understand it's hard to set opinions or gut feelings aside, but I do appreciate that for people that have that position, like Top Cat, love you, that if I appreciate when people state that and admit that, right? Because that way it's a separate discussion, right? Like, it's a separate discussion if there's like a gut feeling that somebody's whatever, and then versus what the evidence shows. Glenn is a great example of that, right? Why does he think Wendy's innocent? It's literally, it's his opinion and it's his gut feeling. It's his whatever. There's nothing to support that. But you see how that does make it a little bit difficult, though, to discuss it, right? Because if it's an opinion or a gut feeling and there's really no way to support it, it's fair to have that, but it does make it harder to discuss versus things like interpreting the evidence or looking at the timeline. It's the same thing like with BK and all these other cases too that I cover. I come in completely no opinion. I try my best to just objectively look at everything, and especially when it's pretrial, right? And then when it's in the trial, remember, then we're looking at it like depending on whose case in chief it is, and going through it anyway. So hopefully that helps you guys for, whatever.
Size and growth rates are characteristic of an individual plant, and they differ greatly among plants.
What kinds of things cause them to grow at different rates?
It may be the mineral nature of the soil, the presence or absence of lots of calcium, nitrogen, water, other plant roots being in the area, water, lots of water or a little bit of water, and so on. In other words, environmental factors.
All right. And if you were to attempt to determine how fast a root grew, what would that require in your field? What would you need to do?
First, you would need to know what plant it came from, and then you would need to do time-spaced observations on growth rates.
And when you say time-spaced observations, can you break that down for me?
Sorry.
And get closer to the mic. I'm going to be on you for that.
You would keep track of how the root elongated at what.
Too, because Miss Sims is not, honestly, she doesn't do many. This is maybe the third witness she's taken in this entire case, even during the state's case in chief. She's the least compelling of the defense attorneys. It's possible that we would be getting better testimony if she was being questioned by Mr. Bias or Mr. Mason. No offense to Miss Sims. She's usually the one bringing in the clutch, coming in clutch with the case law and whatnot. But you also have these two ladies with soft-spoken voices. So anyway, but she will be, I think, done shortly, and then we will get into fighting over the DNA.
What rate it elongated and what size changes occurred.
How would you keep track of that?
With a ruler, with a notebook, with a camera, with whatever you had at hand to help you. Or you could do it in a laboratory.
In layman's terms, you would watch it grow and measure it as it grew over time. Is that what you're saying?
Yes.
Okay.
Yes.
Thank you, Your Honor. That's all I have.
Cross.
Cross-examination.
Thank you, sir.
Okay, Flash. So if you make any mistakes, we'll hold you to it. I'm just kidding. Okay, here comes Mr. Ashton.
Morning, Dr. Bach.
And now I have to do my swoop because we're going on to cross. So this is the Garris swoop. Garris was one of the canines. Shout out to Garris. He's a hero. Here we go. Cute. That's a picture of Garris from when he was doing some of his training. Love it. Okay.
Hi, Mr. Ashton.
How are you?
I'm well, sir.
You're from Colorado, is that correct?
That's right.
And most of your work has been in that area of the country, that sort of middle area of the country. Is that not correct?
No, that's not correct.
How much time have you spent actually working in Florida as a botanist?
It was the site of my PhD thesis work of it. And since then, I have had individual research
Not the most
projects in Florida and hope to have more in the not too distant future.
And when your PhD is from what institution?
University of California at Berkeley.
And you said your PhD thesis and when was that, if you don't mind me asking?
No, I don't mind. I got my PhD in 1966.
And what was your actual work in Florida in the 60s for your PhD?
Moving up and down the state, looking at the distribution of water hyacinths in freshwater bodies in this state and also in semi-marine areas, estuaries.
All right. And other than that, what other projects have you worked in botany since 1966 that have brought you to Florida to actually work in Florida?
I studied the food habits of the tortoise,
Right.
which is an endangered species. And
That's pretty cool. That's like the coolest thing I've heard her say that she has done. You know, for me, I can get down with some studying of the tortoise.
and is a vegetarian.
And when was that?
Funny.
That was from about
Flash wants some fried chicken.
1980, off and on through 1990.
And how did that work actually bring you to Florida? In other words, would you come for a few days? Did you live here then? Tell us a little about that Florida experience.
My parents lived here. I came to see them. I also had some research support about tortoises in general, and I used some of that support as well.
All right. Any other involvement you've had in studying botany in Florida?
Yes, I was friends with the person who wrote the first flora of Florida. It's the late Robert Long, and I was very interested in the progress on his work. Subsequently, I've used field guides to Florida plants in order to become familiar with the thousands of plant species, native and non-native, that exist here, to further my botanical knowledge.
Was that review recently in preparation for this case, or just in general?
In general, and it continues to now.
And any other involvements with studying botany in Florida, other than I believe you told me about 3 projects?
No.
All right. Now, most of your work has been in studying grasslands and grasses. Isn't that correct?
Part of my work, and a big piece of it, is concerned with grasses.
Thank you for this question. So let me explain double jeopardy. So double jeopardy means that if you are tried and acquitted either by a jury or a judge in the event of a bench trial, no matter what the charge is, the state cannot bring forth charges a second time. Now, in the event that the jury hangs, you guys know, mistrial, right? Or in the event that something else happens and, in the rare situation that something happens that derails the whole thing halfway through or whatever, and it doesn't make it that far. I mean, I can't even think of an example, but I don't know. This would be an extreme exception, right? Where it doesn't get to a verdict by either a jury or a judge, where no one has a chance to assess to get that to that. Then they can bring charges in. But once somebody has, again, whether it's a judge in a bench trial or a jury has reached a verdict, right? Then they cannot bring those charges again. Now they can bring charges for a different crime but they can't be charged again for the same crime. That's the double jeopardy. Hopefully that makes sense.
This grasslands here and in South America, and yes, here and in South America.
Having said that, they had lesser included here, which is important. There are lesser included here for like manslaughter. Like I think they have like 2 different levels of manslaughter. They gave the jury other options, by the way, and the jury said no to everything except for perjury.
And you would agree that different areas of the country have unique botanical ecologies that differ.
To that end,
Yes.
just to reiterate, right? So the manslaughter, right? You know, essentially that if we recap, I'm glad this came up because I'd forgotten that part. But if you look at it that way, this would say to me that the jury didn't even really think it was an accident. Now, again, I don't remember. I'm sure at the beginning of this case, we looked at the indictment and we read the specific statutes for those charges and looked at the elements. And I feel like maybe the only one they didn't include was the one that was more like along the negligence line, like the least severe manslaughter. But they include, I think, they included like one that was just like some sort of like child neglect or child abuse, right? And then I think it was child neglect, and they included again, they had like a manslaughter, right? But and then the last indictment was perjury, and that was the only thing that the jury found. Although after the fact, that was appealed and some of those were dropped. But regardless, she had already spent time served by the time, you know, she was supposed to spend, like, for the perjury, it would have been like, I don't know, some minimal time in jail, and she'd already been there in custody for a long time. So anyway, but yeah. Yeah, she was acquitted on everything except the perjury, right? I think, are you confused in thinking that acquitted means they can charge you again? Because that's what I was just explaining, is that acquitted means they can't charge you again. They can only bring charges again if the jury hangs, or the judge, I don't even know that could happen with a judge, but the jury hangs, or like, let's say that they're midway through trial and a bomb goes off and they have to start over, right? It doesn't reach it doesn't get to the point where there's deliberation. That's different. Once there's a verdict, and that verdict is acquittal, again, that's why there's a distinction between hanging, right, versus acquittal, because that's not a verdict. Once there's a verdict, they cannot bring charges again, regardless of if it's guilty or acquittal, right? It was making false statements to law enforcement about the nanny and stuff, like Zanny the nanny and all that, which if you go back and watch, there's a backstory there that those stories and the lies have been going on for 2 years before Caylee went missing. It's really more like a pathological liar situation. But actually, if you really look at the jail calls, you'll see that she was gaslit the fuck out of. So, but the point being that my interpretation had always been that she made up these lies when Caylee disappeared. And like, I think that's probably what most people thought, right? Like that, oh, she made up these silly lies that make no sense because she was trying to cover for this thing or that. But the thing that's wild that you wouldn't learn unless you watch the trial is that, like, there's countless people who testified that she had been talking about Zanny the nanny and telling these extremely elaborate stories about Zanny's family and all the shit, literally all the shit that she lied about at the time. She didn't add anything. All of it had been going on for 2 years prior. So it wasn't like she made it up to try to cover something up. What it more speaks to is there's some reason why she's creating like a fantasy. It's like a fantasy, right? Or it's one of those types of things. That serves no purpose. Like 2 years prior, right? She had this elaborate thing about Zanny's family, and her sister Samantha got a haircut and all this stuff. And she would like come home and tell her mom, you won't believe what happened to Zanny's cousin. And it's like, there's literally no point for that, but that's what happened. So that's an interesting psychological element for sure. Okay. So different charges, they can. New evidence, if it pertains to the same charges, nope. Now the defense on appeal, of course, new evidence after discovered evidence, in the event that only the defense can bring that in. If somebody's acquitted and there's like it's too late. After discovered evidence, nope, too late. But different charges for something else, it can't be the same crime. So in other words, they couldn't use this same crime and charge it differently. It has to be a completely different crime. So when I say they can bring different charges, I should have been more clear that different charges pertaining to a different crime. So like, let's say that Casey stole $1 million from somebody. They could bring that in. They could charge her for that, right?
Now, you visited the area.
No, there was a nanny. There was a nanny. It just said it wasn't Zenaida. There was a nanny that she had early on, and that's talked about. But There was a Zenaida actually with that name. Again, it's on the card that they fill out at the thing. So there was a Zenaida Fernandez Zangales, but Zenaida was never the nanny. And there was a nanny, but it wasn't, her name was not Zenaida.
Where this body was found, correct? As you said.
I did.
And you also reviewed photographs of a large number of photographs of the scene, both in its pristine form and then at various levels of exploration.
An excuse for what? I'm not sure what you mean. I'm not sure what you mean by that. If you can clarify.
Would that be correct? And you would agree that this area, based on the botanical specimen seen, is basically sort of a swampy area, an area that's frequently wet. How would you describe it?
Yeah, and again, the drugs thing, again, it can be an opinion. People can have that opinion, but the evidence that's been borne out at trial through the testimony, even during the state's case in chief, is that there's no evidence that Casey had drugs, gave Caylee drugs. The evidence is only that she was a phenomenal mom and their bond was really strong, and people get really emotional about it up until Casey or Caylee disappeared, right? It's easy to get their names confused, and this happens even in the trial. But there's no evidence that Caylee was ever drugged, that Casey ever used drugs apart from marijuana occasionally. And also the autopsy, of course, found no drugs. Now, of course, there's the factor of like, well, let's skeletonize remains. There's only so much you can find, and that's true. However, there are some things that they still can find. We've already watched the testimony and all that. But in addition, that's why it also matters that, like, again, you can't just make up evidence, right? Like, this is the point, right? The state has the burden to prove that there's evidence that X, Y, and Z thing happened, right? And so that's why the fact that there's no drugs in the autopsy and that there's also no witness testimony of Casey ever giving her drugs or purchasing drugs, or Caylee seeming like she was drugged, or Casey seeming like she, acting like they're drugged. Like, there's just the evidence only points to the opposite. So I understand. So I just want to clarify, like, people can have that opinion, but in terms of the trial, the evidence doesn't support that. It supports the opposite.
It has been characterized in the ecological classifications as a swamp hardwood.
Oh, I see what you're saying.
Swamp hardwood.
But that's an interesting term. Part of the plants that are common there are upland plants, not swamp plants. So they aren't wet.
I've not heard any testimony, even from the state. I've not heard any testimony saying that Caylee was ever left unattended. I've not heard of that. I think that's why I was confused. There's not been any talk of her ever being left unattended. Again, in fact, even if that had been the case, the jury could have found her guilty on the child neglect charge. But all of the testimony is that she was the most attentive mom. She was a wonderful mom. There's not been anything, and the state hasn't even suggested that, except for once she disappeared. But of course, likely she was dead. So, right. But in terms of alive and unattended, that's not even been a part of this.
All the time or frequently. Others are.
All right. So you would characterize as an area that wouldn't necessarily be underwater all the time,
no,
but would frequently be underwater.
Frequent. I don't know what you mean by frequent.
Well, the plants that you saw there are many of them are species that require a great deal of water.
Yes, at certain times of the year.
So you would agree that the general character of the area is an area that is at least, we'll say, occasionally underwater.
Strangers, I don't know that strangers would be able to speak to that, right? Like, how would a stranger know? But what I will say is that even the testimony from who was it? Oh, I can't remember her name, but early on in the trial, like the people who even thought Casey, like family members, or like it's like maybe her brother's girlfriend, people that when Casey was first arrested and she's in custody and she's making these jail calls, right? And they're all like blaming her. Like, again, her family threw her under the bus, right? Remember, keep that in mind. Her family threw her under the bus. But every single person has only said that she was a phenomenal mom. And in fact, they got emotional on the stand. And I was thinking of, again, I think it's like the brother's girlfriend or whatever, who was really reaming Casey out and yelling at her on the phone during those jail calls and stuff. And then once they say, tell us what she was like as a mom, she gets emotional and says they had the most special bond I've ever seen between a mother and daughter. So, yeah.
Yes.
Okay.
Or wet.
Or wet. Now,
we don't know who the baby daddy is.
Your statements to counsel
you
that
guys,
you believe.
Come on, let's challenge ourselves to not be judgmental. I mean, you guys can do better. I know you guys can. I mean, imagine you guys think about Brian Kohberger, think about Richard Allen. I know there's cases that you guys care about. Imagine that those juries for Brian Kohberger or, oh, hold on, just a moment. Hold on. I've got a question from the electrician. Okay, they're done. They're done, guys. They finished earlier than expected. Okay, so that was very nice of him. Okay, great. So what was I saying? Right. So imagine like for BK, right, or for Richard Allen, which in this case maybe that's what it was, right? For those of you guys who think that that should have been a not guilty verdict, imagine if the jury looked at him and thought he looks evil, and that's why they went with guilty. Imagine for BK's trial, same thing. There's people that say that now about BK, right? So you guys see why I'm asking that question? Because why can we not? I don't know. Is it because you guys just don't think that Richard Allen or BK, you think they don't look evil? And if they did look evil, that's the question. Let me ask this question. If you guys looked at BK or Richard Allen and you thought they looked evil, would your opinion of their guilt or not guilty or innocence or whatever your opinion is, would your opinion change? Or is it that you look at them and you don't think they look evil, but if you did, would it change? But then the follow-up question is, should that matter? That's funny, Flash. Yes, my heat works. My heat works. They're all set. Yes. They're all set. Yes, heat works. Heat is on now. Top Cat goes by behavior, not looks. Okay, that's better, but still that's not quite the standard used in trial, but better than looks, I guess. And you're talking about BK, right? So, right, Nancy Grace said the jury's gonna take one look at him and find him guilty. So I appreciate that because I'm sure she did, right? That's it. And Nancy Grace did the same thing with this case, right? So how is that, like, if any of you guys feel like that's unfair for anybody, I don't care if it's BK, I don't care if it's, and if there's ever a criminal defendant that you guys have watched a trial of, or maybe it's pre-trial that you've been following, and you felt like that was unfair for them to be judged, then how is it fair to do that in any other case, right? You know what I mean? You know what I mean? I don't know what you're saying, Heather. Oh, I see. I see what you're saying. So you're kind of making a point because of Twit. Okay, I see what you're saying. Right. So, I mean, but can you ask yourselves the question, right? Ask yourselves the question. If you guys thought that either anybody else, I don't care who it is, if you guys thought that, but imagine it's somebody who you think isn't guilty or should be acquitted or whatever. Imagine that you thought they looked evil, then would that be fair for those cases for you to be like, yeah, and then be a guilter, to use the lingo, right? You know what I mean? Okay. I'm going to push back because I think it's important. So it's not just looks. Okay. Well, I only was saying that because of the thing about, what was it? Crazy eyes or whatever. Anyway, but I'm going to push back on this, and here's how. Because not reporting her missing, that could have resulted in being found guilty of the child neglect charge. Okay. And she was acquitted of that as well. But nonetheless, that does not mean homicide. That is not murder. That is not enough for murder. It is enough for one of the lesser includeds, and she was acquitted of that too. And again, I think y'all would have a different opinion if you watch this trial. I'm serious. I understand why the jury acquitted her, but it's hard to explain it to you guys without you guys having seen the testimony. That's all. Y'all are funny. Right. And the thing is that's also the evidence. The evidence doesn't support Casey's guilt here, and that's why she was acquitted, And so Cassie's letting us know that she's not involving looks. Okay, good. Okay, so Twiz, I think, is branching into like whether he would go near her versus involvement in, in terms of the case, right? The trial. Okay, I see. It's an important distinction. Like, in other words, the burden for being acquitted, right, is one thing, but then in other words, it's going to take a higher bar for Twiz to stay away from her. That's fair. That's allowed. That's allowed. That's funny.
Leave this.
And maybe that's part of it, right? Maybe for some of you guys, it's you view women and men differently. I don't know. Maybe that's something else. I'm just saying we can all do better, right?
They could have been there for as little as 2 weeks. You quoted the leaf litter, but is that opinion based upon looking at all of the botanical evidence in the case?
Yes, it is. Yes.
So you viewed the roots that are growing through the hair mass, and is it your opinion that those roots could have grown there in just 2 weeks in December?
Could have accumulated there in 2 weeks, yes.
Well, is there a difference between grown there and accumulated there?
Yes.
Okay, my question was, could they have grown there in 2 weeks?
Yes.
And the roots which are growing through the laundry bag, you recall seeing photographs of a canvas sort of laundry bag with roots growing actually into the fabric. You recall those?
Yes.
Okay. And is it your opinion that that could have occurred in only 2 weeks in December?
Yes.
And the roots that are growing in the bones, did you see the photographs of roots actually growing into the bones in this case? Did you see those?
I saw the photographs. I also saw the bones, some of them.
And are you presenting the opinion that that growth into the bone could have occurred in 2 weeks in December?
I suspect so, but I'm no expert on bones, and I'm not qualified to comment about osteology. But based upon what I know about the ability of roots to penetrate substances, yes.
But you, I believe, have, and I appreciate candidly admitted that you have never dealt with a decomposing skeleton.
And so this is the case. This is with any case, though, right? And I mean, and honestly, with the way it works, if you're the prosecuting attorney's office, right? If they can't find the evidence for any reason, right? Whether they're just dumb or they're stupid or it was hidden or it was eroded over time or whatever. If they can't find the evidence they need to bring forth the charges, they shouldn't even bring forth the charges to begin with, let alone take it to trial. But that's where the jury comes in to hold them to that burden in the event that they do. No, it could have been an accident. And in fact, the first theory of the entire thing was that she drowned in the swimming pool. Because Cindy Anthony testified or told law enforcement right on. Like, remember, George threw Casey under the bus. Cindy said, I came home and I saw that the ladder was up at the pool and the gate was open. And the first thing she thought was that Caylee had drowned. That was what her first thought was. We've talked a lot about that. I call it Laddergate. So the first thing that came from the mom was, oh my God, what if she drowned or whatever, right? And what came from the dad was Casey's hiding something, and law enforcement zeroed in on Casey because she's the mom. But there is no proof that Caylee was murdered. I mean, it's undetermined. Cause and manner of death are undetermined. Okay, so it could have been an accident. It very likely was an accident, but never mind that. They can't prove that she was murdered. I mean, that's why the manner of death, it was technically it's undetermined, but then they say homicide by undetermined means. But in other words, the only way that they are even able to say homicide is simply because of like the other circumstances. It's really sketchy. Watching the testimony from their forensic pathologist will piss you guys off. I promise you guys that.
That root growth in the skeleton. You've never had that experience, is that correct?
No, there's no evidence that she was asphyxiated. And like we were saying, remember we were watching Werner Spitz, the guy with the skull? He said that in the cases where someone's asphyxiated or smothered, you would have this hemorrhaging found in the skull. And that was not the case here, that's why I pointed it out, because I was like, that is really important, because the asphyxiation or smothering or whatever, any of that, like you would have had that and you didn't have it. So in other words, if you're a forensic pathologist, you can't say what happened for sure, but you can rule things out, right? And he can rule that. It's still undetermined, but he said that's something that normally you would see to rule out.
Yes.
Now,
I,
sorry, go ahead.
I have in skeletons that had been in place for several years.
Now remember, in the case of drowning, that's different because there's no way from the skeletal remains to determine that, right? And that had she been found sooner, they could have, but that would have to come from looking at the lungs. So that's the other challenge here, right?
So you say you have dealt with?
I have looked at that evidence.
No,
and
no, and the state doesn't even have a theory. They've offered conflicting theories throughout the trial that contradict each other. There's not a solid there. They don't know. And that's why, again, if you look at what happened immediately, the whole thing about the drowning looks like it's the most likely thing. I mean, given from what Cindy Anthony's own observations from at the time, and a lot of other context clues, again, you could go back and watch the testimony, but yeah. And
so sometimes yes and no is not so easy.
The parents are also habitual liars. It's true, Casey is, but so are the parents. And Anthony too. If you watch those video jail calls, you will see that Casey is probably of the family the most honest one. I'm not kidding. I know that sounds crazy, but one example real quick. When Cindy Anthony called 911 on the day that they finally called 911, when she calls 911, she makes false statements to police officers on the first 2 of the 911 calls. During the first 2 911 calls, Cindy Anthony says grand theft auto. She says that there's that Casey, she says, my daughter has committed grand theft auto and stolen money from my bank account. Okay. It isn't until law enforcement officers arrive on the scene and they ask her, and they're like, wait, they show up because they think they're responding to a stolen car. They show up and they're like, wait, we're looking for a stolen car and we're looking for somebody stealing money from a bank account. And then that's when Cindy Anthony tells them, oh no, I made that up. It's really for a missing kid. One example. There's billions, seriously.
Okay. Well, let me just put it to you this way. Have you had the occasion to examine a skeleton where plants or roots had actually grown into the skeleton?
Yes.
Okay. Let me direct counsel and the witness's attention. Do you recall giving your deposition on February the 12th of 2011?
Oh, yes.
Okay. For counsel's benefit, this is page 64 going to page 65. Do you recall the following question being asked? Okay. Well, let me put it to you this way. Have you ever had occasion to examine a skeleton?
The body was not only decomposed, it was skeletonized. In Warner Spitz's testimony, we didn't watch this clip in the recap because it was just the recap, but like the pet skull, right? If you imagine a Halloween skeleton, right? Decoration where it's like dry bones. That's what they found. Dry bones, completely skeletonized.
Skeleton where plants or roots had actually grown in the skeleton. You said this would be page 64, line 24.
Skeletonized, just like a
You answered no.
Prop.
However, I've taught classes where I've done experiments getting roots to penetrate heavy, thick particles. I asked bones, and you said, I'm trying to think because they're just amazing. Clay, I don't think I ever used bones. No bones. You said, doesn't sound like me.
Not in teaching. However, I belonged to an organization and was present at a crime scene where there were forensic anthropologists, forensic archaeologists, etc., MDs.
I will say, I don't think that this is really getting anywhere either way. And you know, I'm going to do this. Let's just see here. I think is this still her? Because I want to get to the DNA. I've not skipped over any witnesses in this entire trial, but this is just, I'm over it. Okay. So let's go on. Give me just a second here. Let's go on to where it's going to get really interesting with all the DNA and the touch DNA. Okay, let me pull it up. Okay.
Okay, court will come to order.
Judge Belvin.
Mr. Bias, who is the defense's next witness.
Right.
Richard
So right,
Eikelenboom.
6 months, it would be, it just did because of the heat in Florida, right? It did, but it was fully decomposed, and that's what they talk about, right? In some places, you could have it be not that badly decomposed, right? I mean, sometimes things are fairly well preserved. It just depends. But in this case, it was, summer in Florida. I guess Florida year round probably would be pretty much the same, at least in Orlando. Anyway, like I don't know that it would matter if it was winter, but anyway, yes, with those conditions. I mean, but that's how she was found. So.
Okay. I have reviewed the requested instruction that the state has proposed, and I've reviewed the instruction that the defense has proposed.
So this is because of the issues with the discovery and like the sanctions.
Now, did Dr. Eikelenboom provide a partial report?
No, Your Honor. He provided an affidavit, and he, in deposition, referred to it by that term as an affidavit. It does not. I provided the court with a copy of it the other day, and
well, this is what I'm looking at. It says affidavit R. Eikelenboom dated January 21st, 2011. Is this what he provided?
yes, Your Honor, that's the item that was provided
Okay.
to defense counsel.
This is the instruction I propose to give. All expert witnesses were required by order of the court to provide reports.
So one of the things that he's doing to remedy this discovery violation is this special jury instruction with which he's reading now.
To their findings by providing 1, a complete statement of their opinions. 2, the reason for those.
No, it was like exactly 30 days. She was so the last time, well, okay, the last time that Caylee was seen was on June 16th, and she was reported missing on July 15th.
Those opinions or conclusion. And 3, in a data or other information considered by the witness informing their opinion or conclusions. These reports were due at a time prior to the trial of this cause. The report of this witness was not provided to the state of Florida until Saturday, June 18th, 2011. You may consider this fact in judging.
All of these things are the things that people would have thought going into this case, but all of this has been dealt with during the course of the trial. It's hard to explain away everything because I understand why people think that, but even just the opening statements addresses that. But even if you just want to go that far and watch the defense opening statements or watch the state, watch how terrible the states are, right? And watch the difference. But anyway, but again, where my light bulb moments for me happened during those video jail calls. And there's a video jail call where it's just George and Casey, just the two of them. And then there's several where it's both the parents and Casey. There are some crazy ass moments in there that are really interesting of where that's where it seems to me like George looks like he's going to fucking kill her. Like, it's like he's threatening. And there's actually times where he's bribing her to give a confession. By the way, you hear about that in the jail home calls. He's trying to bribe her by saying, I'll put money on your commissary if you go and talk to them, law enforcement again. And basically he wants her to confess. And she turns it down. Have you ever heard of anybody turning down money on their commissary? Ever? She says, I don't need it. I don't want it. It's wild. It's fucking wild. He tries to talk her into meeting with him alone in a room, knowing that it would be, and she, he tells her it wouldn't be recorded by law enforcement, but of course it would be. He tries to tell her not to listen to her attorney. He tries to get her to just go and confess to it. And it's very clear that there's something fishy going on. Like I mean, you guys can read between the lines. Hopefully I don't want to make an assertion that is accusing somebody of something, but it's very weird. And so my point is that somebody can be hiding something, but it could be because they saw something they shouldn't have, or maybe somebody forced them into doing something or covering something up. It could be that type of thing. It doesn't necessarily mean, it could mean anything. Hiding something could mean, you know what I mean? So yeah.
The credibility of the witness's testimony.
Yes, I already said those dates. So for anyone that missed it, she was last seen on June 16th, and she was reported missing on July 15th. Those are the dates.
Mr. Bias?
Yes, sir. We maintain our objections since I have withdrawn the areas that were previously at issue.
Yeah.
We just for the record.
Yeah.
Okay. Before I do that, I need to have the witness come in, and I need to make an inquiry of the witness, and then I need, before I formally impose.
The other thing. So the roll of duct tape, that was the very specific brand that was found with the remains and stuff. was there's other things about this duct tape. So George used the duct tape, the same duct tape, to put up flyers, missing flyers for Caylee being missing. He used that duct tape to put up flyers. When that happened, Caylee wasn't, oh my God, Casey was in custody, okay? And then further, so that, in other words, that roll of duct tape, and there's dates for that. You can find that in the different episodes when that testimony came out, but there's dates for that. And so that means that roll of duct tape, and it's before they found their remains. So that roll of duct tape still existed when Casey was incarcerated, and George is putting up these flyers. He's using this same duct tape. Now, what happens is after the remains are found, okay, and then with the remains, they find the duct tape. Remember, Casey is in custody. Once they go in through and go search and look for that duct tape, it's gone. They can't find it. There's a lot of stuff. The list. I've got actually a list going, by the way, guys, of the things that point to directly, like things that actually implicate, like according to the state, like the state's case against Casey. And I've also got a list of the state's case against George, even though they didn't build one, but based on their own case in chief and the testimony and the evidence. And there's more things that point to George. It's so.
Sanction. I need to make a three-pronged finding for purposes of
Caylee was like 2.5, I believe.
The record. So let's have the witness come in. I have a few questions I need to ask him.
She does have a responsibility to report her missing, and she actually admits that in her interrogation, that she does have a responsibility to report her missing. And I don't think anyone would disagree with that. For sure, she would have a responsibility. Having said that, her parents, honestly, you could make the same argument for them, because Cindy, like, both of them will say they thought it was weird they didn't see her, right? And anyway, whatever. That's neither here nor there. But the point being is that whatever that charge would be, like failure to report, that no one was ever charged with that in this case. No one, not even Casey. Again, they did charge with like the child neglect, but they didn't just failure to report. They didn't offer that as an option. Had they offered that as an option, I think it would have been fair to find her guilty of that, for sure. I don't think anyone would disagree with that.
File, this first item is the defense's proposed instruction, if I was going to give an instruction. The second item is the state's handwritten requested instruction.
Cassidy, okay, hang on. Cassidy, I don't want to be a broken record. Like I told you guys, I had no bias coming into this. I had no opinion. I thought what everyone else thought. I thought the jury got it wrong, right? I mean, I came into this, but because I try to keep an open mind and be objective, I'm telling you guys, if you guys don't have to believe me, go back and watch the whole trial. You don't have to take my word for it. But because some of you guys haven't watched the whole trial, I'm trying to summarize what the evidence has shown. I'm trying to not give my opinion. I'm trying to tell you what the evidence has shown from my perspective. But if you want to offer your perspective on what the evidence has shown, the only way to do that is to watch it, right? So, but having said that, it seems like there's many of you guys, and I don't blame anybody, but it seems like many of you guys have a bias of guilt, right? And many people have that. With most trials, there's people that have that, right? I try to be objective and open-minded and look at the evidence as much as I humanly possibly can. He did lose his job for being a cop. He did. There's a lot of sus things that they couldn't get into because it wasn't his trial. But he did lose his job as being a cop, and he was never able to be a detective again. Also, there is a time that comes up in one of the jail phone calls where George references that he knows what it's like to be in custody. And he talks about when he was like saying like, when I was in custody or when I was incarcerated, and talks about how difficult it was to get bail. So we don't know what it's for, but he was incarcerated for a crime at some point. And maybe that's related to him not being a cop anymore. I don't know. But we know that also when they moved to Florida, he was like saying like, I wanted to get a job with with law enforcement and I didn't. And so I became a security guard. Right. And he's like, makes it sound like he chose not to. Anyway, that was from day one of trial. Right. And it was like the way he talked about it was weird. And anyway, whatever. But, well, no, there's not. But why would anyone need to Google how to knock someone unconscious? Isn't it self-explanatory anyway?
You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth.
He did steal a bunch of money, right? There was also that whole thing. He got caught up in some Ponzi scheme and some gambling.
My name is Richard Eikelenboom, Eikelenboom. N-B-O-O-M, Eikelenboom.
Doctor, I'm Belvin Perry. I'm the presiding judge in this case. When were you first retained by the defense?
Okay, this is a proffer. Let me update my banner.
The first investigation was, or the first request, official request for the case was when we had to look over the evidence.
And when was that, sir?
That was on 13 July 2010. And of course, it was a couple of days before that.
July 2010.
Yes.
Sir, were you ever informed that you...
They couldn't, if that's the case, they couldn't bring that in because Cindy's not on trial. So I don't know. We wouldn't know. They can't bring in what the parents searched for because they're not on trial. So I don't know if that was reported in the media or whatever, but yeah, that can't come in. That's inadmissible. They can only talk about what they think potentially Casey searched for. Again, the searches that were made were also, well, I will say this, the searches that were made, they can't say who made them. They can only say who was home when they were made. And Casey and George were both home. But Cindy was at work when at least for the searches that came in at this trial, Cindy was at work because she was a nurse. She was not home. So
were required to produce a report outlining the opinions that you rendered in this case as a result of your examination of the evidence.
Except for the affidavit, I was not told that I had to render opinions or write another report.
Sir, were you ever informed of the following? Where expert witnesses have not prepared reports of examinations or tests, both the state and the defense are required to provide the following information.
What's going on here is because of the discovery violation where he was going to be testifying to a new opinion that was not disclosed. And they were fighting over it because the state was supposed to depose him and they never did. But right now they're having a proffer just to see what he's going to testify to and if there's going to be any opinions and then find a remedy.
Which shall be filed with the clerk of the court in form of a written pleading.
I mean, for that, again, you know, for anyone that did watch the whole trial, I'm glad you guys did. If it's been a long time, I know for me, if there's trials that I have only watched once, right? Or it's been a long time or whatever, I'm going to forget details. I mean, you know, it's all, of course, right? So, I mean, any of you guys that really want to go through this and assess it, like we've been talking about, I highly recommend going back through. You know, I have a whole playlist and everything again is time stamped. I would recommend going back through and watching some of this, some if not all, right? You know, you can skip past the scroll tangents, but if you want to. But anyway, that way, because it's impossible for me to address all of the different rumors / misconceptions / whatever was portrayed in the media, let me say, right? Or what maybe seems like it was the case. It's hard for me to address all of that because, you know, we're on day 24 of trial. And no matter what, if I say it, that's not as good as you guys seeing the evidence yourselves. I don't want to tell, like rather than me tell you guys what has been going on, that's what I've been doing, but I'm going to stop myself because rather than me trying to summarize what's been going on in this trial, I don't know that that's fair to you guys because it's nothing like seeing it for yourself, right? So I would rather you guys be able to watch the testimony and see the evidence come in and make your own opinions and be able to do that with being informed versus me summarizing it, right?
1, the expert's curriculum vitae or qualifications of the expert. 2, the expert's field of expertise or medical specialty. 3, a statement of the specific subjects upon which the expert will testify and offer opinions. 4, the substance of the facts which the expert is expected to testify. And 5, a summary of the expert's opinion and grounds for each opinion. Were you ever informed of that order of the court?
No, I don't recall that order.
Okay. I take it, sir, that you do not live in the continental United States?
Well, actually, since February, we're living in Kohberger. But before that, we were living in the Netherlands.
Okay. How were you communicating with the defense? Was it by phone, email, or by what other means?
Yeah.
By phone, email, and Skype.
Were you ever requested or asked between December 2010 and May 1st of 2011 to reduce your opinions and findings in writing in a report format as I've just outlined?
Sorry, reduce? You mean to write a report?
to write a report in the format that I've just outlined, sir?
No, I don't recall it.
Who was the principal person that you communicated with for the defense? Who were you getting your instructions from?
Mr. Bias, and we also had communication with Michelle.
Now, from May of 2011 up until today's date, were you ever asked to reduce your report in the written format that I've just outlined, which would include all of your opinions that you
That's
were
Judge Belvin.
asked to produce?
Last Saturday, I talked with Mr. Bias, and then after the deposition, or after we went to the district attorney's office to do the deposition where we were refused, it was requested that I would write a report. So last Saturday night, we wrote a short report.
Between December 1st in the year 2010 up until May 1st, 2011, how many times have you communicated with members of the defense team?
Well, I'm not completely sure about that. I know we had communication short before we had to do the inspection of the evidence, and short after. And then for a long time, I didn't hear anything anymore. So we more or less lost contact and lost track of the case.
From December 1st, 2010 up until May 1st, 2011, were you readily available to be contacted by the defense team via email, telephone, or Skype?
Yes, the defense could reach us if they wanted. Yes.
You didn't disappear during that time period, did you, sir?
No.
Okay. Either the state or the defense want to ask any questions along those lines that I've just asked.
Yes, sir.
You may proceed.
Mr. Eikelenboom, is this the first time anyone has ordered you to write a report on a case?
To write a report on a case?
No, not on a case, on that had certain parameters like this one.
Oh, in the Dutch courts, yeah, you sometimes get a request, and that's by an investigative judge, and they can order you to investigate certain evidence or certain reports, or and write an opinion about these items.
And that would be based on things you've done, correct? Like run certain samples of DNA, inspected certain pieces of evidence.
Can be both. Can be on investigations which we have performed, but can also be on investigations of other laboratories, and then they want a second opinion about the methods used or conclusions drawn in those reports.
Okay. And the contact with your company back in January of 2011, that was done through your wife and Miss Medina, was it not?
Yes.
It wasn't directly with you?
No.
Okay. And in fact, what occurred and how this order was, the information got back to you came originally from Miss Medina to your wife, and from your wife to you.
That's correct.
Objection. Assume the fact, not an evidence that the information about the order ever got to the witness. He's indicated it didn't.
I permit him to go ahead. Objection overruled.
Okay. Now, what you ended up doing is based on what your wife ended up telling you, correct?
Yes. You're talking about the very short affidavit.
Yes, the affidavit. Okay. And what you in turn ended up doing was filling out an affidavit of all the work that you had done up until this point, correct?
Yes, this is more or less about the evidence viewing.
Which was, you wanted to inspect a piece of evidence for your own testing, but it was denied, correct? Yes. And then also that you had actually gone and done an inspection of the evidence, correct? And took photographs.
That's correct.
Okay. Were you ever told in any way, shape, or form to narrow your report or to exclude things from your report?
No.
Okay. And the report or affidavit that you ended up submitting was based on what you thought was required of us?
Yes.
And you never spoke directly with Ms. Medina about what the court has actually ordered?
No.
That conversation actually took place with your wife and Ms. Medina, correct?
That's correct.
And then later on spoken to you, correct?
That's correct.
Do you recall exactly what your wife told you was required by the court? If you can remember.
No, I don't recall that.
Do you remember that conversation at all, only that maybe it happened?
No, I don't remember the conversation at all. And the affidavit, I remember something about the affidavit, but we were very busy in the time we were in the transfer, times we transferred from the Holland to the United States. So I didn't think much about this affidavit.
And the questions and the opinions that you raised and formulated on Saturday, they were
first broached on Saturday, correct?
Yeah, when we were talking about the case on Saturday afternoon after the court session, then the idea came up to write a report or to form ideas about the topics where you're talking about.
And these are not opinions that you held before and had discussed with us previously, and we determined that you were going to testify about these opinions prior to Saturday, and you just did not include them in your report, correct?
That's correct. On Friday, I made a PowerPoint presentation and just an average presentation for explaining contact DNA.
And Friday's PowerPoint presentation was just a general explanation of touch DNA and nothing more.
Yeah, and how PCR works.
They weren't specific as to any of the issues that were raised in this case, only an attempt to explain touch DNA.
Yes.
Okay. And upon our conversation on Saturday, you were then immediately asked if you would consider taking a deposition at the state attorney's office to now discuss these new opinions.
Yes, so during the lunch, we discussed the topics, and then about which I might be allowed to talk during court, and then we had an appointment with the district attorney's office to do deposit.
Okay, and what happened when you showed up at the state attorney's office?
We were refused entrance.
By who?
The district attorney.
Who? Is he sitting here?
Yes.
I'll stipulate with me.
Okay.
It'll help.
And what exactly did he say?
Mr. Ashton.
I don't recall exactly what he said, but as I understand it, I was at least not going to do a deposition.
So he showed up for a deposition. He was turned away by Mr. Ashton.
Got some kind of rude.
Okay.
Ooh.
And after that occurred, were you then instructed by Ms. Medina to immediately do a report?
Yes.
And you did that?
Yes.
And then you emailed that to me Saturday night?
That's correct.
Okay. I have no further questions.
Mr. Ashton, any questions?
May I just do it from here on?
You may.
Is there any opinion that you have expressed in your Saturday afternoon report that you could not have developed 4 months ago through the same conversation with Mr. Bias?
It depends on the information which was available at that time, but like DNA reports, that probably could have been, if asked, I could have written a report about that.
Did he give you any new information during, and you spoke at lunch on Saturday?
Yes.
Correct? Did he give you any new information during lunch on Saturday that you had not been provided with before?
Well, for me, it was new information because I didn't follow the case. So the case, when we left, we got a subpoena a week ago, or it's almost 2 weeks ago now. So the case for me was not really clear. And I know, of course, about the case, but I really didn't follow it. So for me, maybe the information was there, but for me, the information was not clear. And it was not clear which direction everything was going. So I needed that guidance during the lunch.
I understand you may have gotten new information about what Mr. Bias was interested in, but did he give you any new reports, any new factual information that you didn't have already?
I got, I think that was during Friday and Saturday. We got new information, so about crime scene pictures and some extra reports.
What new information?
Reports from the FBI and some extra pictures.
So you hadn't had the FBI reports before Friday?
Not all of them. No.
What new ones were you given? What new FBI reports were you given on Friday?
Oh, I just, actually, I got the whole folder, so.
Well, can you give me more guidance on what you had already and what you got that's new?
I've seen reports before. That was, I think that was during the investigation of the evidence. So I form an opinion about the case, and I know something about what was already then. And during last week, I requested for more information, digital, and I got all the reports, which were then, that's a lot of reports, of course.
And you made that request after you got the subpoena and realized that they were actually going to testify?
Yes.
No further questions?
Yeah.
Okay. Pursuant to Richardson versus State 246 7 771, a 1971 decision of the Florida Supreme Court is amplified in McDuffie versus State 977 312, a 2007 decision of the Florida Supreme Court. The court will make the following finding of fact. 1, whether the discovery violation was willful or whether or not it was inadvertent. On December 10th, 2010, the court entered an order. The order was entitled Order Granting State's Motion for Clarification / to compel compliance with order for additional discovery. On December 1st, 2010, the state filed a motion to clarify.
Here's what I think
at a subsequent
he's making a record. Here's what I think he's going to do. It's a big deal when you limit the testimony given from a defense expert due to a discovery violation. So he's making a record that because of the fact that there was an order, the order was clarified, and so therefore in his intent, in his in his opinion, Judge Belvin's opinion, from his perspective, this discovery violation was intentional or willful and not inadvertent. So he's making a thorough record for appeal, and the appeal if Caylee were convicted, right? That for him to limit the testimony of this defense expert, he's making that record. So this witness's testimony is going to be severely limited, or somewhat. I would think it's going to be quite limited. It sounds like he was given things to review just late in the game and whatnot, and so he won't be able to testify to those particular opinions.
Hearing, it was determined that there was some dispute.
Welcome if you're new, anybody. Shout out to Mass Dad. Happy to see you. I think you might be new here. At least I don't recognize you in the chat. So welcome.
Concerning a prior order that the court had entered and the intent of certain language. The exact language of that court order at the time provided as follows. The defendant shall also provide to the state a list of the
only DNA found in this case anywhere was the DNA on the duct tape that matched to the FBI forensic analyst who I was talking about last night, who somehow left DNA there, even though she was in full gear and even though the tape was in a completely sealed, like, I don't remember if it was glass or plastic. It was in a sealed enclosure, sealed. And she was on all the gear, and she's been doing this anyway. And then by the time it went back to the last person down the chain as they were testing it, they found DNA, and it was from her. That's the only DNA in this case.
The defendant's experts that shall include the subject matter as to what the expert would testify to and the area of expertise for each expert. The court goes on to say there was some debate about the word subject matter rather than substance. The court said, while the order included the term subject matter rather than substance,
there's nothing.
The court finds that the list of
nothing left. I mean, they DNA tested them to confirm it was Caylee. That's what they did. They took like samples from like Caylee's toothbrush and hairbrush. They confirmed it was her, but there's nothing else to be found. It had been exposed to the weather and in water, rain. It was in a wooded area that at times was kind of swampy. It was, the remains are torn apart by wildlife. I mean, it's just not. The odds of being able to obtain any DNA at all in that situation are slim to none, unless it's in some sort of preserved environment. But once it's been, hopefully that makes sense. It's just, there's just no way.
Provided by the defense does not comply with the intent of the order or the intent of the court as expressed in its November 29th, 2010 hearing.
No, they don't know.
In order to clarify this
issue,
issue,
don't know who the father is. No.
The court went on to order the following: where experts have not prepared reports.
For paternity. So they did actually test the brother, Lee. That came out, was that in the last episode or 2 episodes ago? They did actually do a test for the brother, Lee. And my understanding is it's not quite a paternity test. Like, okay. Well, they were fighting over it, right? According to it sounds like it was a paternity test, but the state was saying they didn't do it because to prove if he was the father. But anyway, it's kind of splitting hairs. But he was ruled out. But they did do a test that has been talked about as a paternity test with Lee. But yeah, her own, your bones are going to have your own DNA, right? So you can still do a paternity test. Now, did they ever do one against George? I don't know. There's going to be certain motions in limine, right? In every case. And, with George, it seems like there's a lot that the state was able to keep out from coming in that would point to him, right? For obvious reasons. So in other words, I don't know that there was ever a paternity test done for George. I can't say because it's just that we don't have that information. But there was talk, many people, friends and ex-boyfriends and stuff, they had heard stories about Caylee having been abused by her brother and her dad, in different ways. But I don't know, those statements came from her. So I don't put too much, I don't put those statements, I don't rate them any way or the other, right? As credible or not, because they came from her to them. I believe them that they were told that, right? But you can't, it came from Caylee. So yeah,
of examination or tests, both the state and the defense are required to provide the following
The meter reader has not yet testified. Yep. You're remembering things now. The meter reader has not testified yet.
information, which I have previously
This is Judge Belvin. Well, Judge Perry. I call him Judge Belvin because Belvin is his first name, and I just love it. This is Judge Belvin.
outlined. The court at that time thought that the matter was clear. In January, the court was back again to deal with this issue again.
And they ruled out, by the way, as far as the paternity. So they did do they were able to rule out some of Casey's ex-boyfriends and stuff. So like people were, in other words, for the paternity, they have to have a sample to test it against, right? You have to have someone who might be the father. So they tested it against, again, I understand her brother. I don't know about George, right? But we know the brother and we know like her ex-boyfriends and stuff, and they were all excluded. So we just don't know.
Going back to the December 10th order of 2010, the court specifically provided, with respect to all other experts, this information is to be provided by 3 p.m. on Thursday, December 23rd, 2010.
Yeah, so for skeletal remains,
there were some different
right, for skeletal remains, the DNA that they get comes from the bone, like they grind up the bone or whatever. It's like bone marrow, whatever. Fuck. So they can still, so in other words, there's always going to be your own DNA. You're never going to be without that. Like, at least not maybe in this millennium or whatever. I don't know. I'm just thinking like, I can't say never, right? I mean, who knows what'll happen with robots? I don't know. Anyway, I'm just saying, like, as we are humans, and this is true for any animal, right? You know, you can always get DNA, your own DNA from bones. But in terms of DNA to prove something else, that's depends on the environment and all these other factors.
It lines with respect to Dr. Fairgrave and Dr. Bach. That information was to be provided by December 14th, 2010. Again, we had the same problem again, and the court again specified what information and reaffirmed its prior order and assessed sanctions. The obligation are for the attorneys to see that their witnesses comply with the orders of the courts. It is the attorney's job, be it the assistant state attorneys or defense counsel, to make sure that their expert witnesses comply with the order of the court. The court will find that this violation is not inadvertent, that it should have been clearly communicated to the expert, and that the expert should have been required to comply, and the expert was not. Therefore, the court finds that the discovery violation was willful and not inadvertent. The next issue is whether or not it was trivial or substantial. DNA, even though the advent of DNA evidence has been around for a number of years, certain opinions that will be expressed by this witness as a result of the deposition, which is now on file, cannot be viewed as trivial when we start talking about rendering opinions with of analyzing decomposition fluid in a trunk. So the court finds that it is not trivial but substantial. The next issue is whether or not it had a prejudicial effect on the opposing party in the preparation of their particular case. The court has delayed the testimony of this witness in order to give the state of Florida an opportunity to take this witness's deposition. If the witness had authored a report, put his opinions, the basis for his opinions, and the data which he relied upon with those opinions, then this court would not have given the state an opportunity to take his deposition, because they chose not to do it. If those items would have been in his reports, then the state would not have had the opportunity. The question comes in as to whether or not I need to totally exclude his opinion about the possibility of a DNA analysis, which may have some fraud implications, and this court cannot, in this short period of time, make.
As far as the questions about the DNA, again, I'm watching this in real time, learning things as we go, the way you guys are if you haven't watched trial. And I we're about to hear from a DNA expert. I don't know what he's going to talk about because, so in other words, maybe there's some other suggestion of where they got I don't know. So I'm just speaking of the DNA evidence that has been presented so far, but it looks like they're going to say something. I don't know. That's why
that particular determination. All of the cases indicate that the exclusion totally of testimony is an extreme remedy to be utilized in rare circumstances. The court has decided to do the following. At this juncture in time, the court will not permit the witness to testify on this particular issue dealing with the possibility of a DNA analysis on the decomposition of fluid in the trunk of the car. The court will give the defense until next week by Saturday to file whatever potential motion it wants to lay out for a Friday hearing. And the court then on Wednesday evening or Thursday evening at the conclusion of the day's testimony, after a 1 hour break to give the attorneys an opportunity to get something to eat, then we will come back and conduct whatever Friday hearing we would need to see whether or not this testimony does meet Friday, or whether or not there is even a Friday issue involved in that particular testimony. That should give each side
I don't know that I greeted you
ample
well.
opportunity
Welcome as well.
to do what they need to do. And it is a remedy short of exclusion, but I will not permit this testimony at this particular time.
Remember, the most harsh remedy would be excluding the witness altogether, but that's a lot. So he's saying that, you know, again, certain testimony is not going to be permitted, but he's not excluding the witness altogether.
Anything else on behalf of the defense or the state?
Hey, he's almost done.
Not on this issue.
Okay.
I have a brief issue that I'd like to bring to the court's attention.
Never mind.
Yes, sir.
Today, we were handed by the state of Florida discovery.
Here we go. Did you hear his words? We're on day 24 of the trial. Today we were handed discovery. Okay, there's going to be another tongue lashing.
Which included 2 compact discs.
Okay, we'll take that up at noon on your lunch.
Incredible. The fact, you guys, the fact that the defense, or sorry, the state was successful in the sanctions here with this defense expert, and that, you know, some of this testimony is going to be limited, and judge, you know, they've been fighting over this witness for a while with discovery, or the past couple of days in terms of trial time. And the fact that then that same day, the state turns over or hands them more new discovery to the defense blows my mind. You've got to be kidding me. You've got to be kidding me. You've got to be kidding me. Just when the state finally, you know, the state, in other words, the state had a lot of discovery issues during their case in chief, and rightfully so, things were excluded and limited and whatever, right? And here they, you know, the state got something limited for the defense because of it. And now the state turns around and hands them more discovery. I don't have words.
Jawa.
Nope. What is Mr. Ashton doing?
We got a jury that's sitting in there.
What is he doing? Is he asking for punishment? Is this like a masochistic thing? Like what the fuck?
Yes, sir. Yeah.
And also make sure that he's removed from the PowerPoint any issue, anything related to the issue about DNA from decom fluid needs to be removed from the PowerPoint.
Sidebar.
I believe we're ready, Judge.
Okay.
Bring the jury. Bring the jury. Bring the jury.
All right, let's return to jury.
Sweet. Jury time. Okay, now they're getting into the regular testimony. Where's my thing?
Bring the jury. Bring the jury.
Here we go. Okay.
Okay, Madam Clerk, may you swear the witness, please? Okay, ladies and gentlemen of the jury, let me give you the following instructions. All expert witnesses were required by order of the court to provide reports of their findings by providing 1, a complete statement of their opinions, 2.
So we'll skip past this. We already heard him read this instruction from earlier. He's reading it for the jury now.
Good morning, ladies and gentlemen. Good morning, Mr. Eikelenboom.
Morning.
Actually, can you state your name for the record?
So now we're going to get into what this witness is here for, right?
Judge Eikelenboom.
And introduce yourself to the ladies and gentlemen of the jury. Sir, what is your profession?
I'm a DNA scientist.
Okay, and you have an accent. Where are you from?
Oh, I'm from the Netherlands, so I apologize for my accent.
Now, can you give the ladies and gentlemen of the jury a little bit of your educational background? Can you explain that to them?
Yes, I started working for the national lab in the Netherlands, which is at that time was the only laboratory doing all the homicide and crime cases for the Netherlands in early 90s. And I started on the Department of Serology. The Department of Serology later became Department of Biology, because in the early 90s in the Netherlands, we also started with DNA. So I started on the serology department doing protein electrophoresis and blood group typing, which is the front runner for DNA. So later on, I became more involved in trace recovery, so finding the stains.
What does trace recovery mean?
Trace recovery, well, actually for the biology department, is finding all kinds of biological cell material, which could be used for either electrophoresis at the time in the beginning and later on could be used for DNA profiling.
And have you had any other training
you guys,
on DNA?
So remember, again, this is so funny, the timeliness of the question about what DNA. So I'm wondering if what he's going to testify to is finding some other trace DNA or touch DNA on the remains that the state's DNA people didn't find. I don't know. Sounds kind of like it. And who it'll be.
Yeah, I went to laboratory school first, and that was analytical chemistry, so that was not really in the field of biochemistry. And then during my working for the National Laboratory, I followed an education on biochemistry.
Okay.
And that means biochemistry, you work with DNA and you try to decipher DNA. So it's all involving decipher DNA, so it's all about DNA.
Okay. I'd like for you to speak as close to the microphone as possible so everyone can hear you a bit clearer. Now, how long have you been working as a DNA scientist?
Around 20 years now.
Okay. And how long did you work for, was it the Federal Police Department of the Netherlands or?
No, the Netherlands Forensic Institute is under the Justice Department. Our system is a little bit different from the United States. So I was working for the Justice Department for around 13 years.
Okay. And after that, where did you work?
In 2005 or 2003, my wife started the company Independent Forensic Services, and I joined the company in 2005.
Were you ordered to do that?
No.
Okay. Now, sir, can you explain to the ladies and gentlemen of the jury what the difference is between regular DNA and low copy number DNA?
Okay, guys, did you all hear that?
Okay.
I'll pass over for qualification
Did you guys hear those words? Low copy number DNA? Did y'all perk up?
for the voir dire and then I'll continue.
Okay, they're going to voir dire. So here comes Mr. Ashton. So this is this is a voir dire in front of the jury. Sometimes they're, not in the jury's presence, but he's going to ask them about this. We heard low copy number DNA, guys. Woo!
Michael, take this. So take that. Mr. Eikelenboom, the highest degree that you have obtained is what's referred to as an engineer's degree in Holland. Is that correct?
That's correct.
And that engineer's degree is something between a bachelor's degree, but not quite up to a master's degree, somewhere in between those two, correct?
That's what you could say, yes.
Approximately. Your degree is in biochemistry,
No, it's very
correct?
different.
And your specialization for your degree in biochemistry was in the study of luminol, correct?
That's correct.
That's a substance that is a that lights up to show.
So what just happened was Mr. Bias offered him as an expert in, I forget what the first part was, but then my ears heard the part about the trace low copy number DNA. That's when Mr. Ashton said, I want to voir dire. So he's going to try to establish that this dude's not qualified to testify as an expert on that particular topic. And by asking these questions, and then we'll see what happens.
Show where blood is, correct?
Yes, it reacts with oxidized metals,
okay.
But it is used in CSI a lot for finding blood stains.
But you did not specialize in molecular biology or DNA in your biochemistry degree. That was not your area of specialization, correct?
That's not correct. Of course, biochemistry education has biology, all kinds of fields and training in.
Yeah, it happens all the time. This is normal. Like in every trial, when you've got an expert witness for either side, they're going to voir dire them. And because sometimes these witnesses are offered as an expert in more areas. Like, for example, you've got witnesses that might be really well qualified and they might offer this as an expert in like area A, B, C, D, and E, right? I mean, you guys will saw this went through this with Karen Reed, for example, right? You saw this with like the ARCA dudes and with Dr. Russell. But anyway, and so, but what'll happen is if it's not a Dauber hearing, if it's at trial, right? And they're like, okay, I'm going to offer them as a witnesses, and they list the things, or it could be whatever, it could be one thing. But if it's more than one thing, then the other side can object and say, I want to voir dire them, and they'll ask questions. And then they might hear and they might be like, okay, no objection, it's fine. Or they might say, and a great example of this is in Murdoch. In the rebuttal case, the state offered up this dude who was not qualified as an expert at all, as an expert in something regarding, I don't know. It was like the way it had to do with the way that phones tumble. And basically what they had him do, he was an expert in other things, right? But what they had him do is they had him like, you know, you guys probably heard this is because it's become like a meme, throw his cell phone around in the office or whatever. And anyway, but what happened was the defense wasn't paying attention and they did not object. And they didn't ask to voir dire him. So what happened was they said, okay, and the state offered him as an expert, and they said, that's fine. And then later on, when he started talking about this thing, they're like, whoa, wait, what? And it was too late because they didn't object. So again, they could have objected to him being offered as an expert in that one area, whatever they called it, you know, and they didn't. So anyway, that's just how it goes, right? And then the other things too, right? They could hear they could voir dire, they could hear the qualifications, and then they could still maintain their objection, and then the judge is going to have to make a decision if they are qualified or not. They might say objection overruled. He's so qualified to be an expert in whatever the fields are, right?
In DNA and biochemistry, and then as a part of the last year where you do an internship, which of course was
he literally threw the phone around in his office over the weekend. Like that's literally what happened. He didn't even try to hide it or lie about it. He was like, yeah, that's what I did. And it wasn't something that mattered at all. It was like, that's why I think the state just didn't need to do that. It wasn't something that mattered. It wasn't a huge, it was funny. It was funny, but yeah. And it was Mr. Barber who was supposed to be objecting that he was not paying attention, and then it was too late.
Then I choose for a luminol subject. So that subject didn't contain much DNA. Of course, we were finding out, so actually it did contain quite a lot of DNA. What we tried to find is to make a new solution of luminol.
That's nothing though compared to coroner armpits, right? The coroner who tried to estimate time and death for Maggie and Paul by sticking his hands under the armpits. I hope you guys have seen that because it's the funniest thing in a trial of all time.
Would not deteriorate DNA. So it had for sure something to do with DNA.
Now, when you were working at the same time you were in school, you were also working for the Netherlands Forensic Institute, Department of Biology. But you did not do DNA testing for that institution, did you?
I worked on the biology department, and the biology department is divided in sections. And during the time we're talking about my training, I became a coordinator, and that means that you coordinate cases, you get all DNA results, but it's all on paper. And I had you can have an accent on certain investigations. That could be a DNA extraction, that could be analysis. My emphasis was on trace recovery.
Not DNA analysis or extraction?
No.
And in fact, though you had some training in DNA with the laboratory, you were not certified by that laboratory to perform DNA analysis, were you?
That's correct.
You did trace recovery?
Yeah, that's an accent, and I coordinated cases and reported cases.
Coordinating cases means basically deciding which unit should get it first, how best to coordinate the various disciplines in examining an item. That's what you mean, correct?
And then you get all the results. So you have to know something about DNA in order to do interpretation. So analysis, in the sense you get the results, but you do the final comparison about
you see it,
suspect
Heather?
victims match or not.
Hopefully you saw that. Hopefully you saw that.
But you didn't actually perform, analyze, or interpret DNA cases during your period of time with that institution, correct?
I did a lot of interpretation. I did not do performing the actual pipetting of extraction or analysis in the unit analysis. But
I see. But in 2005, your wife and you opened a business.
Correct.
Called Independent Forensic Services.
Correct.
And you and your wife appointed you as, quote, director of DNA.
Correct.
No further questions, Your Honor. We would object to his qualifications as an expert in this area.
This is a great example of what I was just saying. They're maintaining that objection. I don't know what's going to happen. So Judge Belvin can either overrule it or you can sustain it, and he's going to make that determination if he can testify as an expert in that area.
More that I'd like to elicit from him.
Go ahead.
Okay, so now he's going to also voir dire, which happens. Right.
How many cases did you work where you actually recovered DNA and processed it?
And the reason this is done in front of the jury in this situation, right, is because the jury is entitled to hear the qualifications of somebody who's being offered as an expert. Because remember, it's really up to the jury. They can determine whether someone's an expert, qualified as an expert or not. As you guys know, you always hear this in jury instructions. They're allowed to judge the credibility of the witness as a whole, or just the testimony alone, and believe some of it, not all of it, or whatever. And so when you've got an expert witness and you're trying to show the jury, hey, this is what we should be listening to, listen to how credible they are, it's a big deal. That's why there's this whole process of showing to the jury. And that's why they go on and on about what they've done. Like for people that get up there as an expert witness and then they go and they say, I've done this and this and this. I mean, there are expert witnesses who brag, that is a thing. But like speaking just literally, they have to show why they are so qualified to be called an expert, because as an expert witness, you have advantages, right? An expert witness, they are able to, well, first of all, you're allowed to lead an expert witness. Now, like by leading, I mean ask leading questions, okay? Second of all, they're able to rely on other people's opinions. In other words, it's not considered hearsay. And they are able to like opine on things, again, assessing things of testimony from other witnesses. And I think there might be another benefit that they get as well, but those are the two main ones. I might think of more as we play this, and I might remember if they're what the others are, but yeah. And of course, obviously the main point is it's supposed to look good, you know, the jury, get the jury to pay attention. So, and in other words, the whole process of them saying all my qualifications are this, and then also the voir dire process, this is for the jury so that the jury, you know, regardless of which party you are, you want the jury to either see how qualified this witness is or how not qualified this witness is, right? So.
In the Netherlands.
In the Netherlands, yes. Process the DNA cases, so that was during independent forensic services?
Correct. Prior to opening up independent forensic services.
Prior to?
Yes, yes.
So what I said for the Netherlands Forensic Institute, I worked on, as a coordinator, I did work on a lot of high profile cases, but then as coordinator, you get the results from the laboratory technicians. During the time with independent forensic services, we started doing everything ourselves. We didn't have lab tech. So in that time, we did from trace recovery till the report writing and court testimony all ourselves.
And did you receive any training on how to do these, how to do both the trace recovery?
It would concern me if I was the defense in this case. It would concern me that his accent is a little bit difficult to understand. Not that there's anything wrong with accents, but you know, again, if you're the defense attorney, you're paying money for you want to make sure your expert witnesses can be understood by the jury, right?
And PCR process and everything else that is required when running a DNA sample.
Yes, of course. We had during the biochemistry lessons, you get to know the DNA extraction. And in the Netherlands Forensic Institute, I followed all courses which were aligned to become an expert witness there.
Okay. And was your lab, Independent Forensic Services, accredited by any organizations?
Yes.
Which organizations?
In Holland, we have a Dutch accreditation board, and that is similar to what you have over here as the SCLAD accreditation. That's
SCLAD, we know that.
A board which accredited DNA laboratory over all kinds of laboratories, but in this case, DNA laboratories.
And do they require certain proficiency testing?
That's correct.
Okay. And what is proficiency testing?
With proficiency testing, you actually you get a blind sample, and in this case, or in our case, we used CTS because we know it's an American-based company, collective laboratory testing, and they send out a sample or more samples, reference samples, and as a crime sample, and then the laboratory has to perform DNA on that, and then send back the results without knowing whether or not they were right. And after you send that in, a couple of months later, you get results back and you can see whether or not your test has been performed well according to 160 or more laboratories which were participating in that test. And till now, we always met the criteria of the other laboratories.
And have you, has your laboratory been contracted by law enforcement from your country to do DNA samples?
Yes.
How many times?
Over 100 times.
Okay. And in addition to that, have you ever been asked to testify as an expert witness in the area of DNA analysis?
That's correct.
How many times?
Over 70 times.
I'm sorry?
Over 70 times.
70 times. Okay. And to get this accreditation, are there any other requirements that they monitor your laboratory and its employees?
Well, the CTS testing is a very important one, of course, but also when the Board of Accreditation does a visit over here, I'm not sure, in the Netherlands that's every year. I think over here it's once every 2 years. But in the Netherlands, every year they come by and they also bring an expert, a DNA expert, a forensic DNA expert who can say and review reports. They can actually ask anything from you. So in that way, you're reviewed very thoroughly.
Are you referring to audits?
Yeah, the audit.
Okay. And how did you become involved in cases in the United States?
Well, the first case was the Tim Masters case.
Okay.
Objection to reference to specific other cases.
The counsel's on this question, this qualifications.
Ooh, interesting. Look at his face. Does anyone know that case?
Sustained, you can ask him whether or not he's testified, but don't talk about a specific case and whether he's been qualified in courts over here.
Yes, sir. Mr. Eikelenboom, try and answer just my question. So you were contacted from a case from the United States, correct?
That's correct.
And what kind of case was it? Would you call it?
Objection doesn't go to qualifications.
I think it does.
Sustained, rephrase the question.
Were you sought out for your unique expertise in any?
Move to strike.
Sustained.
Were you sought out for what reason, sir?
Objection. Relevance. Can we approach you on?
Yes.
Oh, boy.
You may proceed.
Thank you, Your Honor. Mr. Eikelenboom, have you been sought out to handle cases in the United States?
Objection. Objection.
Sustained.
Have you testified as an expert witness in the United States on some cases?
Yes.
That's the question.
Where and how many times?
State of Colorado, 2 times.
Oh,
Okay.
Colorado,
And,
guys.
Were these by law enforcement or defense or both?
Interesting.
I have to correct that. It's 3 times.
Who here wants to go find out what cases in Colorado? Interesting, right? Because Heather just a second ago had mentioned something about Cyray in Colorado. I wonder what cases.
Twice by defense, 1 time by law enforcement.
Okay. And you now have a laboratory in Colorado?
We're setting that up.
Wow.
And
interesting because what's her face? The lady, the botanist, I was going to call her the flower lady. The botanist lady also came from Colorado.
the training that you've received in DNA analysis, where did you receive that training?
A lot of the training was in the National Lab in the Netherlands Forensic Institute.
Okay. What kind of courses?
All kinds of courses. It's on laboratory training. It's about interpretation, analysis, statistics, mood courts. So the whole field.
Would it be fair to say from the actual recovery of a collection of evidence all the way through the statistics of being able to interpret results you've received training on?
To the court, yes. So statistics
actually even through the court. Okay. And was this accredited training?
Well, I think it's part of the accreditation procedure. If the training itself is accredited, I don't know.
Okay. And did you also have experience in all different aspects of DNA analysis?
Yeah, maybe I should explain that the reporting officer, I was in training for reporting officer. And then you, of course, have to know everything about the topics about DNA, which you have to testify in court. In the Netherlands, because the laboratory or the biology department became so big, it was separated. So you did not, as a reporting officer, you don't have to work at DNA extraction or DNA analysis. In this stage, they have reporting officers which have never been in the lab, I think. So become a reporting officer, you have a different training than if you only do trace recovery or you only do DNA extraction. That is done more by lab techs. So the difference was that I went from trace recovery to become a coordinator and to become a reporting officer.
Okay. So is it fair to say you've received training on all aspects of DNA?
Absolutely.
Okay. And that you have over 20 years experience on being able to identify issues on all aspects of DNA?
That's correct.
And you've been certified both as an expert witness 70 times in the Netherlands and 3 times in the United States.
Yes, that's correct.
So the point
And you've
of
been
all
certified as an expert witness in DNA.
the jury doesn't think, oh, well, 70 times in the Netherlands, whatever. We don't care about that. We only care about U.S. testimony, right? In other words, because usually expert witnesses have testified more than 3 times in the United States, right? So that's the point, is like, it's not due to his qualifications, right? But like, it's just, that's, very strong.
DNA analysis.
That's correct.
At this time, Judge, I would submit Mr. Eikelenboom as an expert in DNA analysis.
Objection.
Witness would be accepted as an expert witness
All
in
right.
DNA
So that
analysis.
went in the.
Judge, would this be a good time to break for lunch?
It would be a good time, Mr. Bias.
Oh my God. You know what's going to happen now? They're going to talk about the state just disclosing more discovery. Oh my God. Get ready. Y'all. I feel like there could be fewer people at the end of this that makes it out alive after whatever is going to happen here, because yeah.
Okay. Ladies and gentlemen, jury, we're going to recess for lunch. I'm going to ask that
yeah.
you return
Oh,
here.
yeah, DNA is the same in the Netherlands. It's just that some jurors might really care. You know, some people may think that, oh, in terms of how do you vet someone as an expert, right? There's some people who are like really pro USA that might be like, oh, if it wasn't in the USA, it doesn't count, right? Even if DNA is the same, your qualifications as an expert, you know what I mean? You have to prepare for every type of perspective when it comes to like whoever's on that jury, right? Similarly to last night, we were talking about like Ann Taylor using the words, you know, like dirty and nasty, whatever the word, ugly. And we were talking about how, you know, if you're in front of a jury, of course there wasn't a jury there, obviously, but you have to think the potential to alienate a jury, right? And you never know who's on that jury, so you want to err on the safe side. Same sort of thing, right? Because you just never know who's going to be like, oh, if it's not USA, it doesn't count. You know, there's people that are like that, you know.
At 1:30, do not discuss this case among yourselves nor
Oh
with
my
anyone
God.
else. Thank you.
Get ready. I need to do a swoop. Okay.
Okay, Mr. Bias, you said you had another issue you wanted to raise.
Yes, sir.
Sir, you may stand down. You can go to lunch.
Stand down.
Be back by 1:25.
Sir, Judge.
Let's get the witness out. Make sure your staff tells him what time he needs to get back. You may proceed, Ms. Bias.
So, Your Honor, we were given this morning, which is the date, June 21st, 2011, some discovery that was provided to us by the state. In reviewing just a crude, rough peruse of what was given to us, it appears that many of the documents that were turned over were items that have just recently come up and certainly beyond the state's control as to being able to turn the items over, with the exception.
Interesting. Okay, they were beyond the state's control. This would be like kind of like the GMC data coming in last minute in the Murdoch trial. Interesting.
Of one compact disc. This has to deal with some material from the desktop computer from the Anthony home, specifically.
Oh, fuck. Interesting.
Ones that were taken from June 16th, 2008.
Interesting. June 16th, that's the last day Caylee was seen alive.
This report was completed on April 26th of 2008, but yet not turned over to us for 2 months later, after the time that the state's experts have already testified, computer experts, that is, specifically. In reviewing this also, I also noticed some photographs that appear to be some internet searches for what would be considered, and this is just one example. It's not the brunt of our objection and issue, but it appears that there are photos of shot girls, which may have been at one time viewed on the Anthony home computer. I found this particularly interesting because during Mr. George's direct examination.
Shot girls, by the way, just to clarify, that's a term I'd never heard of until this trial. That doesn't mean people that have been dead or whatever shot. You know, he means people at the bar that are like, you know, like in Florida, right? Like model, I don't know what you call them. They're like to get you hyped for the party, and like girls wearing whatever and like drinking, taking shots. I don't know, or they sell shots, something like that. That's what he's talking about.
He, on multiple occasions, referred to Miss Anthony organizing or trying to collect or give advice on the clothing that the shot girls should wear, which also leads me to believe that the state had prior notice of this discovery.
Okay.
And that's the point why I bring that up. This is the law enforcement had this computer since July 16th of 2008.
Yes.
Going on 3 years now. And this report after is now given to us subsequent to the state's experts already testifying.
I've never even been to like a legit club, because where I live, they don't like exist like they do in Florida. Like I just know what I've seen like on movies or whatever, like other club, you know, people like I've seen it, but like I've never they don't exist where I am. I mean, maybe I don't even know if they exist in North Carolina, maybe in Raleigh. I have no idea. There's not like a club scene, you know, like there are in other places.
We would object to any presentation having to relate to these items and I'm specifically referring to the computer items, not to what was disclosed previously, or what was disclosed of recent events that don't appear to be relevant to this case, unless of course they do become relevant at some
No,
time.
it is funny. I wish I would love to have. I mean, I'm not opposed to it. I mean, I would love to be able to go just because to see what is that like. Like, I would be probably like, you know, it's like people that are there because it's like they're like well versed in like what you do at a club, and I would probably just be like, I don't know, I would just be squirrely. I would just be scrolling. I mean, it would be anyway.
But we would certainly object to that, and I guess I ask for a Richardson hearing on that, unless the state does not intend on using this newly found, well, not so newly found evidence.
Richardson hearing. You guys remember that from Sarah Boone?
Ms. Burdick?
Yeah, but again, Twiz is right that I didn't drink in college. But however, you know, in Boone, right? Again, we didn't have clubs, but like I partied harder than anybody, right? But just, you know, without the drinking. I went hard.
Your Honor, the first several items on the notice of discovery deal with a brief investigation that was conducted at the end of last week. Apparently, a citizen called the Orange County Sheriff's Office, left some information about an inmate who may have had contact with Miss Anthony at a point in time when the inmate was in the Orange County Jail. That matter was investigated Thursday or Friday of last week. The report was generated. A statement was taken over the phone from.
This is a hell of a thing of new information in the middle of trial. Wow.
Sheriff's Office left some information about an inmate who may have had contact with Miss Anthony at a point in time when the inmate was in the Orange County Jail. That matter was investigated Thursday or Friday of last week. The report was generated. A statement was taken over the phone from this witness. That transcript was produced immediately. I received all of that information yesterday.
What was the name of the witness?
The name of the witness is April Whalen. Apparently, her child died in a swimming pool and was found by the child's grandfather, who immediately administered CPR and called 911. Ms. Whalen was in an adjacent cell to Ms. Anthony for a very brief period of time. Ms. Whalen indicates to law enforcement she did not talk to Casey Anthony. However, she doesn't remember if she talked to other inmates. So at the present time, it's being explored whether or not there was indirect contact. Be that as it may.
So this is like, in other words, hearsay, like quadruple? No. This is like 8 times removed hearsay. And we're talking about inmates listening. Yeah. Bias is very smart. He's my favorite defense attorney of all time. And that's also why I'm covering the Shanna Gardner case, because he is the best.
As soon as I received the reports verifying that, in fact, Ms. Whalen's son did pass away in a drowning incident, as well as the reports from law enforcement of the follow-up on the information obtained by or delivered.
One thing that's interesting too is we learned in opening statements that in Florida, by the way, the number one cause of death for children is drowning in a swimming pool. And he gave the statistics, and it's astonishing. It's like, I don't remember what the percentage is, but it's like, it's crazy. It blew my mind. It was like, whatever. It was just a lot. It was like the vast majority. And it's so funny because, like, you know, here in North Carolina, I mean, very few people have a swimming pool. I mean, I'm sure there's some houses, but it's just not a thing. But it's so funny. I guess in Florida, swimming pools are so ubiquitous that it's just like a common occurrence, which is insane to me.
A concerned citizen that was provided to Mr. Bias in the event that it does become relevant in relation to the subsequent investigation or the investigation that continues. The last item that is on the notice of discovery is simply a filtered copy of items from the hard drive that Mr. Bias has had for years. My use of these items, or our use of these items actually, would be exclusively in rebuttal if Ms. Anthony or another witness were to testify about specific activity occurring on June 16th. An examination of the hard drive indicates there was substantial computer activity that would rebut a lot of what Mr. Bias said in opening statement. Therefore, even though he had this information for years himself and had more than one computer consultant during the pendency of the case, as I recall, I decided that if we are going to use a demonstrative aid during the course of our rebuttal or even Ms. Anthony's cross-examination, that we would give that to counsel. and we have done so, rather than holding it for rebuttal.
Let me ask you these questions. I take it so we're all on the same page. This is contained in notice of provision of supplemental discovery
Okay.
dated June 21st, 2011, which bears your signature.
It does.
And items 1 through 6 all have to do with Miss April Whalen.
They do.
Oh,
And
I
that
recognize
information was
name.
provided
I
to you by
recognize that
law
name. I don't know
enforcement
why.
when?
The fact that they were conducting an investigation was communicated to me last Thursday or Friday, perhaps even Saturday. I believe they worked on this over the weekend. The written reports were delivered yesterday afternoon.
And so you delivered it as soon as you
Love Tina, welcome. I feel like you might be new. I don't recognize your name, but welcome, welcome, welcome. Happy
became
to see
aware
you.
of it and it was ready to be delivered.
That I did.
He's going to side with the state because he usually does.
And the last item, item 7, is just a redacted version.
That's another
or
thing.
demonstrative.
Another thing that's interesting in this case is that he was so, as we see oftentimes, prosecution biased. Judge Belvin was, as many judges are, prosecution biased, that had she been convicted, their number of issues on appeal they had a very strong issues on appeal. Like, not every case has that, right? They had it had she been convicted because he was that. And it's interesting because even when you consider, unbeknownst to the jury, right, there were these rulings that were happening that were just really, really, really questionable. And even still with the defense being handicapped in a number of ways, they still got an acquittal. So.
Aid of an item that
Of
you had
course,
previously
we love
given
having
to
everybody.
the defense.
Girlfriend.
The defense had their expert actually travel to the Orange County Sheriff's Office or provide a hard drive to the Orange County Sheriff's of the HP, the desktop computer, and the
I do enjoy seeing a different type of blazer though, like what she's got on. That's I don't know about the color being the most flattering for her, but I do enjoy seeing a different style.
Home over 2 years ago, and the information contained on the hard drive is of course voluminous. I would have expected that counsel would have concentrated on the items on the computer on June 16th. However, since we did that and would like to use some of the items on the computer as a demonstrative aid, rather than having the sanction of exclusion that was suffered as a result.
A demonstrative aid. So this is a middle ground. So she's saying instead of including it, can we use it as a demonstrative aid? So just for anyone who's unclear, there's a difference, right? Because a demonstrative aid is not going to be sent back with the jury for deliberations. So a demonstrative aid is not going to be entered into evidence, right? It's just going to be a demonstrative aid and that's it. Versus something that gets, gets offered into evidence and is then published to the jury. Now, interesting side note for anyone who hasn't watched this trial. Earlier, towards the end of the state's case in chief, I saw something I've literally never seen before and probably never will again. This lady right here, Miss Dream Burdick for the state, tried to sneak a doodle evidence in front of the jury. And I'm going to get goosebumps talking about this because talk about jury, like, oh my God, the jury. She tried to sneak a doodle this crucial piece of evidence. It was the sticker. It was a piece of evidence that was crucial. Again, this is at the end of their case in chief. There'd been a lot about this sticker. And finally, when they get to it, right, and the jury's present and she's admitting it into evidence. So she admits it into evidence and does not offer to publish it to the jury. So they don't ever see it. They don't even know what they just know that the jury paid attention and memorized the exhibit number. So when it was talked about, this piece of evidence, this heart sticker was talked about, it's exhibit 313. Okay. When it was talked about, they kept hearing exhibit 313, right? And then there's an envelope, a sealed envelope. And she's like, okay, admitting 313, right? And they recognized the number. So they knew what it was. Talk about underestimating the intelligence of a jury. Okay. Then the jury is sent out and they have whatever, some things happen. Then they go and they call Cindy Anthony to the stand again for the millionth time. Then they go take a break and the jury, I've never seen it, sends a note during trial to Judge Belvin and says, hey, we noticed the state admitted exhibit 313 into evidence and didn't publish it to us. May we see it? Unbelievable. Unbelievable. Unbelievable in a number of ways. Unbelievable the state did that. I understand why, because that was not good for them, because that whole thing was fucked. But also unbelievable that a jury called them out. It took the jury to call the state out. Incredible. Incredible. So And then the crazy thing is that when that happened, Miss Drain Burdick tried to act like, I mean, talk about being like caught, like, you know, with your hand in the cookie jar or whatever you want to call it. She tried to act like it was a mistake or whatever. Dude, that episode was insane. And of course, the result was it was published to the jury. So.
Result of not providing a PowerPoint, I provided this information at this juncture.
Absolutely. 100%. That is the most fucked up thing I've ever seen the state do in a trial, ever, period. I couldn't fucking believe it. It's beyond. Talk about trying to gaslight the jury. I feel like that's an understatement, honestly, with that.
Now, do you plan to utilize Miss April Whalen?
Based on her statement, I would say no. However, as that information is investigated, there may be something from it that would be suitable for a rebuttal case. But at this juncture, as I've told Mr. Baez, that would be no. The court may not know. We continue to get phone call after email from concerned citizens, as I'm sure they do. We have to cull through that information to determine what are just fashion suggestions or prosecution suggestions and what is actual fact or Brady material. And we have been doing that on a regular basis. This was one of those items that was investigated. If it turns out to be something relevant at this juncture, I would say no, but it could before the end of the case.
Okay, as to items 1 through 6, Mr. Baez, any additional comments?
On those items, no.
Okay.
But I do have numerous comments on 7.
Okay, let me finish 1 through 6.
Wow.
The court will find that this is not a discovery violation. The court will specifically find that under Rule 3.220 of the Florida Rules of Criminal Procedure, that the state has a continuing duty to disclose information that becomes available to them. And also, under the case of Brady versus Maryland, they also have that duty, which they have complied with. Now, let's move to item number 7, Mr. Baez.
Yes, sir. If I understand Ms. Drain Burdick's position, they gave us a copy of the hard drive.
He's always so well dressed too. Look at that tie.
So therefore, they gave us, this is a filtered version of that. And I would equate that to giving us 50 phone books and telling us pick out page 700,631. The reports issued by experts in this case, and I guess we're going to get back to your order again, issued certain opinions, laid out certain dates, laid out issues that may or may show up or may not. As it relates to this date, the only thing that was issued by an expert witness was Sandra Kahn's testimony or report that states the hours of inactivity for the times of the computer searches, computer activity on that day. Not who was on, not who may or may not have been on the computer, who may or may not have been home. And what exactly, what page?
Okay, so what I wanted to say, because it's funny, because we were just talking about this. I mentioned earlier, again, this just to reiterate, if for anyone who thinks that I came in here biased, I think as I said, I hadn't watched the trial before. And I think, you guys are seeing me learn things in real time because I hadn't watched this before. So remember when I was just saying not that long ago, how as far as the searches go, they knew that Cindy was at work and that George and Casey, well, I guess they couldn't actually say for sure that Casey was at home. Really, they only couldn't say that Casey wasn't there, but they could for sure say that George was there because he was out of work and it was confirmed he was at home or whatever, right? But anyway, so I just wanted to say, as new information comes in at trial, right? I'm learning it just like with the DNA dude, right? It's like, well, maybe we'll learn something else. So anyway, I just wanted to make sure, I said that as in, I should have clarified, at this point in trial, I only know what we've seen so far, right? So it sounds like they're about to discuss further, though, about who was home with the computer searches.
He just came up and so on and so forth. There's so much data that we could be referring to that it now appears that the state of Florida has decided to focus in on or use some evidence during their rebuttal case for which they had before the trial even started. In addition to that, there's no way when we retain someone to verify the work of the prosecution in this case.
Is this not exactly like what we saw with the issue with the motion to compel with the experts in Idaho? With that, are you guys are hearing this exact same thing? where he's like, we have our experts because of their experts. And this whole thing, it sounds like there's this weasel room, right? The weaseling when it comes to the rebuttal of the state. And it was funny is that you don't always see rebuttal, right? In cases, it's not all that common in trials for the state to have a rebuttal case. I mean, it does happen, but it's on the rarer side. But it seems like this is a thing of like, potentially, if you've got prosecution that is really maybe not the most ethical and maybe a little bit weaselly, that they could be using it as an excuse to then bring in other witnesses and whatnot. That's why this discovery is so important, so that you understand, so that it's confirmed that, that there's no question if it's done above board. But anyway, I'm sensing some weasel activity potentially from the state.
If they're going in a different direction and they issue other reports, especially given Your Honor's admonition and order, that's the area that we asked them to focus on, of course. And after determining that we would not be in need of a computer expert, we withdrew them from the witness list. So here we are without an expert witness on our case. They have had this information.
Just a second. Okay.
They've had this information for almost 3 years. And Ms. Drain Burdick's response is, we've had a copy of the hard drive, so therefore we've had the information. And that's not quite accurate, given the circumstances of how much data a computer contains.
I know you haven't had an opportunity to review it, but Ms. Burdick, what's on this disk for 61608?
Contains all of the computer activity on the desktop.
From what I can see, it's scribbly data. Some of them have photos.
Items created and accessed on the on the HP, the desktop, on June 16th of 2008. Data that was available on the hard drive if they chose to filter it out themselves. Mr. Bias's opening statement focused on activity occurring in the morning hours of June 16th. The computer activity, as well as instant messages that were also sent in discovery years ago, negate that timeline.
Well, let me just simply ask this. Was information provided to the defense by the state of Florida on the computer activities on June 16th, 2008?
No, sir.
So you didn't get the hard drive?
We got the hard drive, but that's everything, Judge.
Well, but they gave you all of the information, correct?
They gave us a copy of the hard drive, which contains billions of pieces of data, and they issued reports.
We hear this all the time in cases, right? It's like, you remember we even saw this from that with Judge Hippler. Like, you have to tell people where to look. If you hand over something with like bazillions of terabytes or gig whatever, because the thing is this, the state, because this all is the state's responsibility, right? I mean, of course, both sides have to turn over discovery, but the majority of discoveries can come from the state. Why they brought the charges is their case. This can be done on purpose to be a dick, right? Where if you've got the defense that's like, please, can you turn over the discovery? There's motion to compel or whatever. And it's like, fine, you wanted it, here you go. And they just dump it on them in a way that is completely useless, right? That can happen, right? And that way it's like, oh, we're complying, we turned it over. But it's like, now you've just literally fucked them, because how are they going to have time to go through all of it, right? And so there's got to be a balance of like turning things over, but doing it in a way that isn't on purpose to fuck them. Anyway, but we hear this in a lot of cases, and it sounds like this is what potentially happened here, where they turned it over, but they couldn't find the thing that they need. And honestly, that happened recently in, wasn't it, even with Richard Allen, right? Wasn't that one of the things that went on with that, where that tip was like buried, buried in the discovery, right?
Of what opinions their experts were going to render and what information they had.
Well, let me ask you this, and
if I may clarify something else, Judge. And as it relates to my opening statement, I specifically said the exact hour is unknown. So for the state to allege that this is
interesting, the exact hour
information that would directly rebut that. Again,
it would seem to me, as an outsider looking in, that June 16, 2008 was the last time
There you go.
that the victim in this case was viewed by her grandparents. It became quite evident, even though it is not evidence, that from the opening statement of the defense, that the 16th was a day of great importance, and that a so-called timeline of activities dealing with Cindy Anthony as to
I drop my phone on my face all the time.
how she spent her day on the 16th, Lee Anthony as to how he spent his day on the 16th, George Anthony on how he spent his day on the 16th, and last but not least, how Casey Anthony spent her day on the 16th, and whether or not what, if any, activities took place on the 16th of June, on the 15th of June, and on the 17th of June, both on 24-hour cycles.
So I think what he's getting to is because to really even pinpoint the time when she went missing, because remember, it's really kind of up in the air, right? Because they're kind of relying on George's testimony, which is questionable at best. But even if you were to say, oh, it's credible, he's like, all he can say is the last time he saw them, right? Like, in other words, it's hard to pinpoint when someone was missing, because if they're missing, then they're missing, right? So this is interesting. This is all interesting. I'm surprised he said the 17th. The 17th, interesting, huh? Let me just
would have been at least of a minimum requirement of review. And I take it at some point, you did have a computer expert, I guess, regurgitate whatever was on that computer on some of those days.
Yes, sir.
And his memory call.
That's why I've never gotten a black eye from dropping my phone on my face, but I've gotten, somewhat hurt. But I did get a black eye kind of recently from trying to rescue a spider in my bathroom and smacking my my face on the porcelain part, underneath part of the protuberance of the sink. That was a good one. Yeah, I looked like I was disfigured for quite a while with that. Well, actually, so it was actually my head, right? But it was such a bad bump on my head where it was like a huge, they say the egg. It was like so huge though that it ended up turning into a black eye as it progressed from the forehead to the eye. Anyway, so I ended up with it. In other words, it gave me a black eye as well, but I hit it on the forehead. Anyway.
If my memory serves me correctly, didn't the state's expert talk about various entries on the 16th when his testimony? He testified to certain events, didn't he?
He did not.
No, he did some event searches for chloroform and other things on other dates.
Correct.
But all of that information came off the hard drive? It did. Well, if the hard drive was provided to you, then it was left up to you to decide whether or not what searches you wanted to do on that hard drive.
No, I didn't smash it.
And it was.
I saved it. I wanted to collect it and take it outside. Now, having said that, I don't know that I ever found it again because I think that kind of like knocked me out for a second, and then I was like, I had like a mild concussion. So the spider just stayed in my house, but I was trying to take him and put him outside because he would be happier out there.
It's not denied access to the defense, and it was up to you to determine what days you chose to look at and what days you chose not to look at. And I'm trying to wonder, how could it be the fault of the state of Florida that you chose not to look at any particular date when you were given the entire hard drive and you all knew what dates had some relevancy to this particular case?
I can tell you that we took your order to mean that all opinions that experts intend on rendering must be in a written report, and the basis for that opinion, all of this must be turned over to the defense.
Well, tell me what someone out of the state of the defense enlighten me as to what is the expert going to tell us other than extract, because most folks are not computer savvy. Some people are, some people are not, that can go in and tell us. All they're going to do is bring it up on the screen as to what activity occurred on that particular date. Generally, computer experts when you want to render opinions, basically render opinions about whether or not somebody has tried to hide something or somebody has tried to doctor something. And, you know, that's what they generally do. But
can I add another
oh,
point?
right.
Yes, sir. Remember, y'all take as much time as you want to, because we're going to start back at 1:30.
Oh,
Yes, sir.
he's saying if you keep talking, you're taking away from your lunch break. Oh boy.
By
the way, for anyone who didn't know this, oh my God, why Court TV? Why? For anyone who didn't know this, this jury was sequestered for the entire trial. It was a 6-week trial. They were sequestered the entire time, and so they went Monday through Saturday. And initially, they were getting done with court on Saturdays at 1:30. But due to discovery issues for the most part, but other issues, ongoing issues, they now are working until they're like 8:30 to 5:30, 6 days a week. And they also brought the jury in from Pinellas County. So they brought over the jury from Pinellas County and again, subpoenaed. And then anyway, but my point being that he's saying like, you can keep talking, but like, you're not going to get lunch basically.
The issue here as well is we're giving computer information after the state has rested. We have withdrawn our computer experts from the witness list because we expected them to testify to what was in their reports and not to new evidence that was now given to us. So if the court's even considering this, allowing them to testify, we would certainly ask to have our experts, given the opportunity for our experts to review this material and see if at all it's.
They can look at it, but it's not new evidence. I don't know how something can be new evidence when it was given to you. Now, what you choose to do with it after you get it is your business, but it's not new evidence.
Well, I disagree, but we can argue that issue at a later time, Judge.
Okay. He wants to have his lunch.
I would like more time to review the material, give it to our experts, and then
you're free to do that.
See if we have further points to make.
Okay. Anything else y'all would like to discuss?
Nothing further.
Okay. See you.
He's so fucking funny. He's like, how much do you guys not want to have lunch, basically? So okay, hold on. Give me just a second. I'm gonna pull up next part here. He's gonna say, see you after lunch, essentially.
Okay, let the record reflect.
Okay.
The defendant is
You also
present
like
along
it.
with counsel for
Okay.
the defendant, assistant state attorneys. Both sides ready to proceed?
Yes, sir.
Let's return the witness.
While we're doing that, Judge, can I make a
Oh,
humble request?
oh boy.
Yes, sir.
Humble
I
request.
realize we have a short day
Your
tomorrow,
request time.
but we would request that the court inform the jury that it is due to your honor schedule, not the defense. So
I
they
will
don't hold it against
happily.
us.
Did I tell him the reason why? When I
No, you didn't. No, you didn't.
no.
Funny, because I was just saying that, right? Remember when I said they're going longer on Saturdays now? So that's funny. So he had told the jury that they were going to be going longer on Saturdays. Mr. Bias is bringing it to Judge Belvin's attention that he didn't explain why they're going longer on Saturdays. And because it's the defense's case in chief, he doesn't want the jury to assume it's the defense's fault, which it's not. It's really the state's fault. But anyway, but if anything, what judges usually do in this situation is they put the blame on themselves, even though because you don't want either party to be blamed for this. So this is what he's talking about.
I would gladly do that.
Thank you, sir.
It also occurred to me that the court had discussed at some point saying something to the jury about witness Rodriguez and his not coming back. And I didn't know if you recalled that, but I think at some point we do.
At some point, we're going to need to do that. So y'all might want to consider crafting some language.
We have probably some further inquiry that we'd like to approach on that topic. We're discussing that
Okay.
as a team now. So
You want me to explain to them about the half a day when they come in now? Because I may forget later on. Okay. Let's return to jury.
Bring the jury.
Okay.
Yeah, that's normal, Heather. It's for a jury instruction. That's what they say in every court, crafting some language. Because in other words, that's on purpose because you don't want to just let the state write. Like whenever there's a jury instruction like this, there's the standard, right? And then just like with regular jury instructions at the end of the case, there's your standard, right? But then both sides usually want to have it tweaked in some way. Now, it's just like with this, right? So in other words, this is just the language that they use to say, what is it that you'd like me to read? And then both parties agree to it or don't agree to it, but usually, hopefully they agree.
Okay, good afternoon, ladies and gentlemen of the jury. Did you read all of my
Just making sure. I understand how that could be taken in certain contexts, so that's why I wanted to specify, because I see.
His admonitions. Okay. Remember tomorrow, which is Wednesday.
It definitely is interesting because it's so funny. I mean, you're right. It is an interesting word to use, but it's used everywhere. I mean, I don't know. Yeah, I mean,
we will only work until noon or shortly thereafter. The reason for that is because I have a long-standing commitment for tomorrow at 1. And to give you a brief explanation, it deals with the state.
Oh, so what it is sorry, he's not having to apologize for going longer, although he already had to do that. He's apologizing for having a shorter day because, when you've got a sequestered jury, the thought is that the jury's going to hate it if time is wasted or whatever. But so this is the judge they had already talked about this. He does have a commitment. And so they have to end court early. So he's just laying the jury now.
Trial court's budget, which I serve on the executive committee of the Trial Court Budget Commission, which is having a meeting here. They have a meeting the next day, which I will miss. But that meeting is very important for the well-being of my circuit. That's where we discuss the distribution of funds for the next year. So I just want to make sure that we are represented when the bargaining begins. Okay. Mr. Bias, you may continue.
Thank you, Your Honor. May it please the court. Mr. Ashton. Good afternoon, ladies and gentlemen. Good afternoon, Mr. Eikelenboom.
Hello.
Okay, we're going to talk about DNA. Now, sir, can you tell the ladies and gentlemen of the jury, give them an example of what touch DNA is?
First question, right out the gate.
Well, touch DNA means you have all kinds of DNA. Now, everybody knows about blood, saliva, semen. Touch DNA is DNA which is transferred mainly through the hands. So if I touch an object, I will leave DNA.
Is there different types of touch DNA, or actually, let me rephrase that. That's a poorly asked question. What affects how much DNA when you use touch DNA is left?
There are different factors which will decrease or increase the chance of obtaining a DNA profile. If I touch,
y'all, I have to just say, for anyone who's because he's speaking and he's an accent, which is great, but it's a little bit. So right now, he was asked right out the gate, what is touch DNA? And he's just been asked now, what factors would determine whether or not how much DNA you're likely to leave behind when you touch something. So for anyone who's interested in that, just letting y'all know.
Touch this table here very slightly. The chance of obtaining DNA profile is very, very remote. The upper layer of my skin contains DNA cells or contains cells, skin cells. But these skin cells are dying cells. I actually have this in the presentation. I'm not sure.
Your Honor, may we, the witness has a PowerPoint presentation that would assist him as demonstrative aid. When we publish that?
You may, what's the exhibit number for the demonstrative exhibit? Attach the exhibit number.
A demonstrative exhibit.
Need to have an identification number, Madam Clerk.
So, actually, it's on his. It's a disc. I can.
Okay.
Give you a
just
disc.
need to reference it at some point.
You're getting the number
Go ahead and
correct.
bring it up.
Okay.
Just without the slides then.
No, you can bring up your PowerPoint presentation if it helps you. Hold on a second. We're going to make sure they can see.
So yeah, the first slide was the slide was the common types of DNA everybody knows about. And here's about the second slide is about skin cells, epithelial cells.
My God. Okay, let me pull the banner down. You guys, we're going to learn. Yay. Look at this. I'm going to leave the subtitles up though. Well, let me see. What happens? I can't move them like you can on YouTube. I just didn't know if there's something down there. Okay, it's just, he's just explaining that's the slide. I think maybe the closed captions are helpful, so I'll leave those. But let me know if you have if y'all want me to turn them off so we can see this better.
And these epithelial cells are the covering cells of the organs. But mainly when we talk about touch DNA, we talk about, of course, skin cells from the hands. If we go to the...
So when you say epithelial cells, you're referring to skin cells?
Epithelial cells is every covering cell. That could also be the mucosa from the mouth or the covering cells from the lips or vagina cells.
Oh boy.
But for touch DNA, yeah, we mainly
Vaginas.
talk about skin cells from the hands.
Okay.
Where we are.
Okay.
And what are we?
Interesting.
That's important.
What-
He was drawing a distinction there between epithelial cells and touch DNA. That epithelial cells can come from all those other things, your lips, your vagina, whatever, all the things. But that, or your hands, right? But then touch DNA is usually specific to hands. As we know, that's kind of just, that's the reason it's used. So, so touch DNA I guess touch DNA is a type of epithelial, right? But not all, so all touch DNA is epithelial, but not all epithelial is touch DNA.
What are we looking at here?
In this slide, you can see the top layer of cells doesn't contain any nucleus. That is the part of the cell where we do get our DNA from. So that means that if I touch something, I will leave this top layer mainly, which is hardly containing no DNA material. And of course, in order to obtain a DNA profile, we need cell material or cells which contain the DNA. If you look a little bit lower below the top layer, you can see that there is, well, you see these kind of square bricks.
And that's this section here that I'm highlighting.
Yeah.
Okay.
So under the pink and under the blue.
That's helpful. So I think the pink, let me pull these off real quick in case there's a thing. Okay. So the pink, so that I think is supposed to be your skin, your top layer of skin, right? Your skin cells. We don't know yet what's on the right, but maybe that's your other types of DNA. But anyway, so this is, so he's going down. I'm glad that Mr. Bias highlighted that part. But here, let me put this back on. Okay.
Once you see this section below that, and in the square, those are cells. In the squares, you see a small oval, round.
Sorry, thank you, Heather, for quoting Ashley Jennings back to herself, saying the logic is
That would be this section here, the spiniest layer.
Yeah, but also in the granular layer, you see a round circle, and that's what we call the nucleus. And that nucleus, that contains the DNA which we need in order to obtain a DNA profile. So in order to get DNA from skin cells, you can see that if you only have a slight touch, the chance of obtaining a profile is very, very remote. If I apply more force, and of course, that happens more often with violent crime than a casual contact where you just touch somebody on the shoulder or touch a doorbell, then the chance of obtaining a DNA profile increases. With blood, saliva, and semen, we all have presumptive tests. These are tests which gives us an indication that blood, saliva, or semen is present.
Would that be like a phenolphthalein test?
Yes, that's correct. Okay. But there are lots of tests like luminol or fate bias for saliva, or it's like phosphatesmo for enzymes which are present in semen. So you have all kinds of tests. The problem for the epithelial cells is that there's no test. So we get into a problem in detecting these cells.
That's interesting. So remember, epithelial isn't just touch, as in it's not just from hands, right? Epithelial, again, lips, other things you guys heard. So that's interesting. No method. Now that I don't know, this may have changed since then. I wouldn't be surprised because this is 2011, right? But this is what it was at the time. Let me know if you guys know for sure if the technology is such that well, having said that, I'm like, well, maybe that's why they do the thing where they expand the file size or whatever, right? I mean, I don't know. I'm sure we'll learn more. But at least at this juncture, right, he's saying that oftentimes, so epithelial cells, which would include all the cells we've talked about and would include touch DNA, so epithelial from your hands, at this point in time, no method of detection, alternate light source, right, difficult to obtain, right?
One possibility of detecting the cells is using an alternate light source. You see this on CSI all the time. They use
oh, well, fucking hell, don't
a darkened room with the blue light.
Goodness.
Well, that's what we call an alternate light source. And then if you wear orange goggles, then body fluids can fluoresce. And especially body fluids like saliva or semen or urine will fluoresce very well. A little bit less or less than these three I just mentioned is the sweat. Sweat also fluoresces. If you will look under the armpits of a t-shirt, you can see that very well. But sweats from the hands are a problem because there's not coming so much sweat.
Think about it, guys, from like an evolutionary standpoint. Imagine if our hands got really super sweaty, we would drop shit all the time. Now, some of us are clumsy and drop things like me and Meg P dropping phones on our faces, but whatever. You know, that's just because I think us as people. But, you know, imagine if your hands sweat as much as other places, like we'd be in big trouble, right?
But from then, so if you touch someone or an object, there will be sweat there, of course, depending on conditions, like it's warm outside or I'm heavily sweating.
What about sweat from the face and the forehead? Does that show up fairly well?
Interesting.
Well, it depends. If I just touch it once, it's very difficult. So in a lot of times you don't see it if you if you use the alternate light source. But at least we always try first, also in this case, see if we see certain stains with the alternate light source. And if that is sweat, then that could give an indication.
Here's where I think this is going. This is just, again, I don't know yet. Here's where I could see this going. Where I could see this going is, so I just put in the chat, but I'll just say it out loud. So prior to now, there'd been whiffs outside the presence of the jury when they've been discussing things about, I'd heard mention of something like maybe DNA on the shovel, but it came up once or twice and that was it, right? I didn't know any, in other words, that hadn't come in yet. I didn't know. So in terms of things that I'm already like, that's all the thing I could think of, right? In terms of like, what could this be? But given these questions and the talk about sweating, I'm wondering if what they're going to get into is touch DNA, as in on the shovel. That would have been somebody with their hands using the shovel and getting sweaty from the work and then touching their face or whatever, or wiping away the sweat, right? Maybe getting sweat on their hands and then touching the shovel again. I wonder if that's where they're going with this.
That somebody touched the location and maybe left also skin cells there.
There it is.
So you're not detecting the skin cells then, but you're detecting
the sweat.
You try to find sweat.
Yeah.
And then
there it is.
You assume, or you make a working hypothesis where you think, okay.
So he hasn't said shovel yet, but already I think that was a really crystal ball moment. So let's roll that one real quick. Where is it? Yay!
Where there's maybe sweat, there's also could be skin cells.
That's a good point.
Well, if you don't have that, and in a lot of cases we don't find that, then you have an alternative way of taking samples, and that's why you use a working hypothesis, and you look for locations where force was applied. If, for instance, you have a rape victim and the shirt was torn apart, then you can look at certain locations where you can see, okay, it is very likely, or there's support for hypothesis that this is the location where a perpetrator might have grabbed the shirt and torn it apart. So force was applied, and that also means that the chance of obtaining a profile is bigger. So that's not a possibility. Still, you don't know for sure that there's skin cells there. So you have to do the testing in order to find out whether or not you get a profile. Then the second problem which you encounter, it's difficult to find, but it's also very difficult to obtain a DNA profile. As said, these dying cells hardly give a profile. There's blood, saliva, and semen.
From this is that he's saying that, like, for example, with the challenges you would have with touch DNA, if you've touched your forehead, for example, wipe sweat and then touch something, that like now that's different, right? Because you're going to have maybe both, for example.
More than 95% of the case, you will get a profile. With the skin cells, that's different. It's far less depending per laboratory, but well, I think you.
King's asking a great question. Is yes, this is just where we are in the Casey Anthony trial, and just by happenstance, right? I love learning from other trials, like I will say, because it's always relevant, that this is day 24 of the defense's case, or day 24 of the trial. We're on the defense's case in chief, witness number 13, and he's here to talk about touch DNA. And earlier we heard him mention, outside the presence of the jury, low copy number DNA, but I don't think he's going to be allowed to talk about that specifically. But he did mention low copy number DNA, and right now we're talking that we're getting a lesson on touch DNA, and he's got a PowerPoint presentation. It's been showing periodically.
50% would be a high score if you.
Oh my God, that's fucking hilarious! Please, can you make one called Tweezle Stick? I will die.
Make it as a laboratory. So
let me stop you there. How do you combat these problems? How does a forensic scientist actually find these types of cells and this types of DNA? What kind of tools are available for that?
Well, as I was going to explain, we form the working hypothesis, and then you can use a number of amount of methods in order to obtain cell material or DNA from those cells, even though they're broken down so much.
And how would you go about that?
That's the next slide. The point I want to make here is that the type of contact of force is very important in order to on the chance of obtaining a profile. And then we have three different types.
So let me see if I understand what you're saying.
Wait.
Is
Go back to the picture.
On the chance of obtaining a profile.
So type of contact. So contact due to wearing, contact due to forceful grip, contact due to touching. That is important. I love this. I love it when they just teach us. Like Matthew Wild last night, we were watching for the cast, and like this. I just love it. I love getting educated. I love learning. And look at this. I mean, and not, you don't get this. You don't get in not every trial do they do this. I don't know why, but they just don't always do it, and I freaking love it.
Oh. And then we have three different types.
So let me see if I understand what you're saying is you end up developing a working hypothesis by taking a look at the scenario and the type of contact and the location where that contact would be. Is that a fair statement?
Yeah, that's correct.
Okay. And starting from there, what do you do next?
Well, this is going into, you don't want to see.
Nancy Grace didn't watch this trial. I don't even think she showed up, not even once, maybe outside the courthouse, but I've been watching it every single day, and it shows the gallery. I've not seen her in the gallery.
This about the three types of contact?
Sure, go ahead.
Okay. Because I think in the Netherlands, at least, we use three types of contacts. And then you have due to wearing, which of course is very often people wear clothing for a longer time, prolonged time, and watch. And then you have the forceful grip, which is of course more related to crime scenes and crimes. And then the contact due to touching.
That made me realize something. So if you think about that, if you think about a watch, like a wristwatch, or jewelry or something like that, I wonder if that could be a really good source, because if you think about it, you should hopefully wash your clothes, change your clothes, right? But something that you leave on, or like a wedding ring, something that's been on you for like decades or whatever, I wonder, I know it's probably more difficult with a hard surface like that. Although I do know that there's new techniques that make that they can collect that better than they used to. But just making the point, like, that's an interesting concept, right? If there's something that you've had on you for a long time, it's like got to be saturated, right?
Due to wearing, you can understand that there's not so much force applied, of course, when you're wearing your clothing, but there's a prolonged time, and these clothing or items are
it's awful.
More or less rubbing against the skin for a prolonged.
You guys are hilarious. That's exactly right.
Time, so you can understand that
she sure doesn't
over time.
And the thing is I would say that Nancy Grace is the single reason why, again, I showed earlier for those of you guys who were here, people to this day with other cases are in the chat like, I hate Casey. Not even relevant to anything, and just literally the most hated woman in America still. And this crime, allegedly was in 2008, right? And then the trial was in 2011. Everyone knows how rare it is to acquit, right? And here we are 24 years later, 14 years later. Anyway, and it's like, people haven't moved on. And it was really the Nancy Grace effect is what they call it. And she doesn't watch the BK. I would say that anything that she's reporting on, she probably doesn't watch the things. But that I will say, she's not the only one that's true about, but she single-handedly had a huge part in the Mandela effect of misinformation regarding to this case. And honestly, Vinnie Politan said as much. We watched a clip of that kind of recently of him on a Courtroom Confidential talking about just his story of how he is doing what he's doing. And anyway, he actually referenced Nancy Grace with this trial, and how he even says she didn't cover a trial. She told a story. He literally says that. And that's why I played the clip, because I was like, accurate. accurate. He's like literally like, she doesn't cover a trial. She tells a story. I'm like, yep, that's right. That's right.
So the longer that takes, the more DNA will accumulate and you get a profile. And then these are a couple of examples like knife handles, clothing, watches,
Yep.
which good
He said watches. Huh.
give profiles. So this category is the highest category of chance of obtaining a profile. The second category is important for crimes, because if a suspect doesn't know the perpetrator, then or a victim doesn't know the perpetrator, then of course it would be interesting to know whether or not you could find DNA on locations where a perpetrator might have touched the victim.
Y'all, right?
This is talking about forceful contact. So now I'm not only touching it, but I strangulate someone, or I grab somebody very hard by the arm, or by the shirt, or by the trousers. So I go through the upper layer of the skin cells, the dead skin cells, but then now I come into a layer of skin cells which contain DNA. And then the third one is, I already explained, just a slight touch, a doorbell, a pen in a bank. Those are.
This is really interesting when we think about other cases where touch DNA is involved.
Worst category of chance of getting a DNA profile.
Oh boy.
There are a couple of factors which are also important. Some people shed more DNA than other persons. It could be that somebody has a skin disease, or somebody is just shedding a little bit more. So a good and a bad shedder means that some people who donated more cell material when they touch something, we call it a good shedder.
Donated.
You also have people which, if they touch something or they even apply force on something, you don't get a profile from. They just don't give enough cells with DNA in order to obtain a profile. As explained earlier, long and short contact, the longer the contact, the bigger the chance of a profile.
Mm-hmm.
Strong, weak, also explained. And of course, you can imagine if you have a very rough object, it's almost etching your skin, then of course, you will also go to the top layer of the skin cells and you will grab material from the skin which contains DNA.
The point here, and what an interesting distinction is thinking about this idea that the top layer of skin cells is dead, right? So the point is, like, you have to get below that layer of dead skin cells. So that's where, if you're a frequent shedder, right, then you're going to shed dense dead skin cells more frequently and get to that underneath layer where there's more DNA available. Same thing with like the rough contact or the long, because, that's just interesting to think about. Like, I always understood how, obviously if you touch something longer, it goes, like, it seems like it makes sense. You would assume that the odds are better that you leave more DNA. But the part that I hadn't thought of, this is just me thinking out loud, right? Thought that I had factored in the dead skin cells thing, which is interesting because when you consider that, then it makes sense that there's these different circumstances where, like, essentially what it is you just have to have enough time go by or a circumstance happen that will get rid of the dead skin cells, or you shed them on your own to expose the, again, what would give you a better sample.
Hey. Of course, two separate parts is that a sticky material, for instance, and we have a method in which we use tape to collect DNA from clothing. So sticky material, of course, will also help to collect DNA better than just a smooth object which touches something. And
okay, let me stop you there because I want to try and tie it in a little bit to this case. So let's take a piece of duct tape, for example.
Oh, the duct tape.
Yes.
If a person were to cut a piece of duct tape, would they have to grip the non-sticky side in conjunction with the sticky side to cut it?
Yeah, if you cut it with your bare hands, then you get two locations. Of course, the sticky side where you have one finger and the other side where you have the other finger.
What type of pressure would be required to cut duct tape?
Well, it's more than a slight touch.
Objection outside is very, very expertise. Pressure change.
Sustain.
Have you had to ever?
I mean, that's no different than in the state case in chief. They had one of the forensic etymologists, aka a bug expert, on the stand, and the state went into questions about like how often he takes out his trash, and if his wife asks him to take trash and types of trash back, and it was like, what fuck? Anyway, but things that are just like human questions. As a human, can you weigh in on this type of thing? Which is basically what the question we just saw here with cutting scissors, duct tape with scissors.
Cover DNA from duct tape before?
That's correct.
Okay. And do you find in your experience that you can sometimes get DNA from the non-sticky side?
Well, you have different types of sampling.
Mm-hmm.
And
here's what I would say to that. I would say that I would expect that, and here's why. Well, I mean, you're probably going to get more from the sticky side, but my thought is this: is like the top of it, right? Versus Scotch tape. If you take Scotch tape, for example, the non-sticky side is really smooth, but if you take duct tape, the non-sticky side it's actually, I mean, I wouldn't say that it's rough, but it's got a texture. You guys know what I mean? To where, like, if you're holding it to cut it, I can see why he's asking these questions that you could leave DNA.
Duct tape, if we know a location where, or we have in the working hypothesis location where it was torn off, and you can see that every now and then, because the tape is more or less worn out, it's like stretched.
Mm-hmm.
Then we take a sample, and from those locations, we are able to obtain a DNA profile.
Okay. And which side of the duct tape would be the most prone to being able to retrieve a DNA profile from? The sticky side or the non-sticky side?
Well, the sticky side, together with the force, of course, is the best location, because then you not only have the force you apply, but also the sticky material, and especially with duct tape, which is known to be very strong adhesive. Yeah, you will collect more DNA, of course.
Now, given the hypothesis that the sticky side of duct tape was applied to someone's face, what would you expect to find in regards to DNA on that?
Objection to hypotheticals not involving all the facts of this case.
Overruled.
Oh, that was a great objection.
Yeah, we had several cases where duct tape was used in robberies and that kind of and homicides as well. And the duct tape, or the tapes, because it was not only duct tape, were fit for DNA.
What kinds of cells would a face, if it were covering a mouth and a mouth area, would you expect to see? What kind of cell material gets on that tape?
So if you cover the mouth, then of course the skin around the mouth. But then, as I mentioned earlier, if you cover the lips, the lips are wet, and there are also epithelial cells there. And of those, you all heard about the buccal cells, which are used for reference sample. So there's a lot of DNA in the mouth area. So those buccal cells are also very good for obtaining a DNA profile.
Now, given the scenario and the facts of this case, have you formed an opinion as to whether if duct tape was applied to this child's face, given the fact that it would have been applied forcefully and the stickiness, do you have an opinion as to whether you think DNA could have been collected from the sample?
Objection, compound question, and there's no clarity as to what facts this witness knows about this case that counsel is asking about.
Overruled.
Wow.
Go ahead and answer.
Good.
Yeah, if the tape was put on the mouth and then was removed, it's about the case where it's just in common now. If you would put tape on a face, you would get, it's very likely you would get a DNA profile.
I mean, this jury came for your neck of the woods. I think you might have not been here when I was saying that the jury was shuttled in from Pinellas County to be sequestered for this trial.
Counsel, the answer is not responsive to the question about, I could explain more at the bench. He indicated tearing it off, which is not the fact of this case.
Yeah, that's his answer.
Let me ask you it in this way. If you had duct tape placed over someone's face and mouth.
That shouldn't have been non-responsive. That should have been misstates the evidence, but whatever. Stupid.
And that person died and was placed in a wooded area, even with the elements of an outdoor area, would you still expect to find DNA on that duct tape?
So at the start, of course, if you put it on the face, you would expect quite a lot of DNA there.
Okay.
Of course, the circumstances of in which a sample is contained, and of course I'm talking about the whole duct tape now, if it is in bad conditions, then DNA could break down. But, well, I had it later in the presentation, but of course with the PCR techniques, which are very sensitive, you could expect still to find DNA.
Okay. Go to the section of your presentation, because I want to try and keep it as directed to the issues for the jury. So let's go straight to that portion of your presentation, so you can explain to the ladies and gentlemen of the jury why you have that opinion.
Kane, maybe you're making a joke. Did you look at the thumbnail?
This is Casey Anthony. Well, the face says it all, right?
Yes.
It's all good.
So what we do is DNA investigation. We investigate certain locations on different chromosomes, and those chromosomes contain information in which
question for
you
you
and I are different. So because of these differences,
okay. I'm going to pause it on this. I'm going to pull down the banner, and I have a question for you guys. I was just thinking about this, and this is just me being curious. Like when you guys are looking at I guess anything on YouTube, right? Do you think that it's the thumbnail that catches your eye to know what the thing is, or do you think that it's the title? Like, do you think that you have a preference, or I mean, it's probably a subconscious thing, but like, are you looking at the thumbnail to figure out what the video is about, or are you looking at the text in the title? If you guys have thoughts on that, just out of curiosity.
we can make the difference between certain donors of DNA material on a crime scene, for instance. We don't. We amplify DNA, so we don't completely clone a person, but we look at small locations. And if you look at this picture, we have these small locations in the nucleus, on the chromosomes, where we do DNA investigations on. And what we do is we amplify those small locations. So now we have, with standard conditions, millions of copies of these couple of DNA or fragments which are present in the sample. So you start out with taking a sample, for instance, from the tape. You cut out a piece, or the FBI did swap a location, and then
we have
very little DNA
in a while. I haven't.
So what we always do is we amplify the fragments of interest, and that's what you see over here. You get all these fragments, and we amplify them. Normally, that's done between the 28 and 30 cycli, which means we have 28 to 30 amplification steps of these small particles of DNA. And then at the end, if there was DNA present in your tube, this DNA is amplified. Is that answering your question here?
Yes, go on.
In order to make it a little bit more clear, is that we can theoretically, one cell is enough to get a DNA profile, not the standard conditions. So let's say 52 between 50 and 100 cells are enough under standard conditions to obtain a DNA profile. That means that you cannot see it. So in this picture, you see a slide. Well, you don't see, you cannot see what's on the slide, but still, if you look under a microscope, you would see cells, and that would be more than enough to obtain a DNA profile from.
Now, let me stop you there because I want to stay on the duct tape for a moment. Now,
did you guys know that? Did you guys know that one cell was enough to get a DNA profile? I did not know that.
Were you made aware that there were 2 partial profiles on this duct tape, specifically the Q63 duct tape that's been admitted into evidence?
So interesting. What's come out so far in this trial is that the DNA on the duct tape came from the FBI analyst. So this might be the first we're hearing, unless it's a different piece of duct tape, because there are 3 pieces. This could be the first we're hearing, though, of a second partial profile. So this is a big deal.
My question to you, there were 2 partial profiles, one on the non-sticky side and one on the sticky side. Take this hypothetical for a moment. If on the, and now I'm only speaking about the non-sticky side, if the non-sticky side was contaminated, is there a possibility that that contamination could override DNA that's already there?
So you guys knew more than I did about that in the nucleus, right?
If you have large amounts of DNA, then it is possible to that you don't see peaks or alleles, what we call them, from small amounts of DNA.
And did you have an opportunity to look at how much DNA was there from the contamination?
The contamination peaks were around 150 RVUs. I have that in explanation later, but that's the RVU is a measurement which DNA scientists use in order to get an indication about the amount of DNA. And 150 is not very high.
Okay. So is there the possibility that there could be lower DNA masked by that, or does that rule that out completely altogether?
No, it's never ruled out. And what you see is that there's some disbalance in some of the peaks, which can mean that DNA of another person is present. But this disbalance can also be there because of the low amounts of DNA.
Do you have an opinion on that at all, as to whether that's possible, likely, or anything like that?
Well, I would have investigated the evidence a little bit further.
Questions?
Okay. All right, let's go to the sticky side. Are you aware that there was a 17 allele identified at the D3 marker?
Yes.
Okay. And when I say marker, I'm referring to a location that is tested for DNA, correct?
Yes.
Okay. And a 17 allele, can you tell the ladies and gentlemen of the jury what that is?
Well, an allele could be described as an appearance on certain locations, what already mentioned, a marker location on a chromosome. And the alleles are the appearances in which you and I differ. So, and that's written down in reports very often as numbers. And you and I have different numbers. So that's what it more or less contains.
Now, do you show how much DNA, how many RFUs are at from that 17 allele?
I have it in the presentation.
Okay, can you bring that up now?
Finding his slide on the PowerPoint.
Okay, what are we looking at here? It looks like some kind of a heart monitor.
Yeah. On the picture, you see different peaks. And the peaks which has a number, or the amylogenin, which is the
sex chromosome.
Yeah, the location where you can see the sex type of the donor of the DNA.
Okay.
So the computer is analyzing the data and is assigning these data. And what happened is that there was an assignment with the 17 and with the X location on amylogenin.
Now, because these are at such low amounts, is there limited information that you can get from this?
Yes, of course. What we try to do is to obtain full profiles.
I have a question. Does anyone know, for people that are transgender, I would assume the answer to this is no, but I don't know for sure. Like, if someone's transgender, would their DNA then show, the gender that they have transitioned into? Again, I feel like that answer is no, but I was just thinking how that could complicate a crime scene, right? Where if they're looking at it and it's like, yeah, it's male DNA, but like, they can rule out a suspect, say, or whatever, and the suspect is maybe a trans female. Anyway, just how that could complicate it, maybe. I don't know. Let me know if you guys know.
The more information, a normal peak profile or electropherogram contains much more peaks with much more numbers below them. And that would, of course, give much more information about the donor of such a profile than if you have only one or two alleles.
Do you have an opinion after examining
So
this
that's interesting, because
electropherogram
people can get away
whether
with
this
crimes,
is
right?
what is called an artifact, or is it or can you determine whether it's human DNA?
It's a small amount, but looking at this electropherogram, that I would say it's caused by human DNA.
Okay. Now, have you ever had the experience in being able to extract DNA from maggots or flies?
Yes.
Explain to the ladies and gentlemen of the jury how that's done.
When the maggots feed on human material, then it's possible, of course, that in the digestive system, if they feed on, for instance, blood, then of course there's cell material in there which contains DNA. If they consume that and it's in their system, then it's not completely digested at the beginning. So when you dissolve or extract the DNA from this complete insect or from the larvae, then it is possible that you obtain a DNA profile.
Okay. And tell me what kind of effect chloroform would have on being able to extract DNA, or would it degrade DNA in any way?
One of the methods used for DNA extraction is the phenol chloroform extraction. It's not so often used in Europe, but it's quite often used in the United States. And in that method, DNA is extracted with the help of chloroform and phenol.
Okay. So chloroform would never be able to affect being able to actually extract DNA that may be there.
I would not say never. Of course, if you put DNA in a bottle of chloroform, that wouldn't help the DNA. But it's not that if you apply a little bit of chloroform, which is of course a volatile substance, that your DNA would be broken down like you have with chloride. So that's the difference.
Okay. I have no further questions, Judge.
Cross-examination.
Sir, you can just leave that. Sir, do you have a PhD?
No.
In fact, you're presently a student.
Overall.
You're presently a student at the University of Denver seeking your PhD. Is that correct?
Correct.
Under the supervision of two other professors who are experts in the area of touch DNA, correct?
They're not experts on the touch DNA.
Oh, what is their area of expertise?
They're in the biology department.
Well, I mean, I assumed that, but what is their area of expertise? They're your PhD advisors, right?
Yes.
What is their area of expertise?
Well, Dr. Phil Danielson does forensic DNA and is mitochondrial DNA, for instance.
Right. And you're under their tutelage trying to earn your PhD.
Yes.
Your laboratory that you've discussed, the one in Holland, the one that you became the director of, you and your wife started that, correct?
Correct.
Sort of a mom and pop situation, just the two of you. I'm sorry, that's an American expression. In other words, the two of you started it and you were the entire company, the two of you.
No, actually, the IFS was started with my wife and a coworker from the National Lab.
So,
and I joined in 2005.
Okay, so three of you. Okay. And your laboratory is actually in a converted barn. Is that correct? Correct?
Part. We bought a farm and we rebuilt the farm.
And you converted and retrofitted it, the barn, in order to make it into a DNA lab. You have secure facilities and all that kind of thing.
Yes, so we changed everything into a normal DNA facility, which is accredited as well.
Now, in 2008, approximately, you and your wife decided to expand your business to the United States, correct?
Yeah.
And this was a business decision because there's a great deal more work potential in the United States than there is in Holland, correct?
You have more homicides over here, yes.
And you would agree, would you not, that the exposure that your company, that hasn't started yet, will get in this case is going to be extremely helpful to the future of that business venture? Wouldn't you agree?
Well, I'm not so sure about that, but we already work in the United States, in more than 7 states, and we're very busy with cases, so we're not really waiting on cases. The cases have to wait till we are finished. Our turnover times are more than half a year. So,
yeah,
no, we don't really need a lot of more attention.
But your laboratory isn't even open yet, is it?
No, in the United States.
In the United States?
The cases which we work on in the United States, we still do that from the Netherlands.
Right, and when you open your laboratory in Colorado, in the United States, it would be really nice to have a lot of work, wouldn't it?
We already have a lot of work, so actually we're trying to downscale it a little bit.
I see. And you're, the more work you get, obviously the more money you and your wife make on the new project, correct? And that's why you opened it.
Well, we're not really working always for the money. We have cases which we did for free, and so we rather work for in the way that we can work like we want to work. So we want to be able to work the way we want to do. And if we if we wanted to expand, we could have expanded way much more than we did now. But the problem is, it's very difficult to get good DNA scientists which can do this contact DNA, which we do a lot, in the way we want it. So we choose to be not too big.
Do you do something that's different than other laboratories? Let me strike that and ask another question. How many laboratories are there in the United States that do the same thing that you do?
I think it's growing now. I know that Body Technology tries to do something about contact DNA. I know that the American New York laboratory started to do contact DNA, also use low copy number DNA. And also the laboratory in Denver is start using more sensitive methods like we use.
Now, Bode Laboratory, that's a large laboratory. That's not a laboratory in a barn. It's a large concern.
Yes.
Okay. So there are a number of laboratories in the United States that could do exactly the same thing that you do.
I don't agree. I think we have more experience than the other labs.
Explain to the jury what you mean by that. I mean,
well, with this contact DNA and touch DNA, objects which were worn by victims, what happened is that in, I think the first time we started with it in the Netherlands was 1997. And in 2000, the United Kingdom, or before 2000, but in 2000, we started research on low copy number DNA. The low copy number DNA means that you have the amplification, but you do.
We'd heard this from a different witness as well. In Europe, they were ahead of the United States in terms of the DNA science.
More amplification cycles than the standard methods used. In the United States, this method was well, actually not used, I think, till
There you go.
recently.
Yep.
In 2002, we validated the method, and in the national lab, I was working on high-profile cases, and I used it in every case which I couldn't not solve. So if we don't have DNA results, and very often then, if there was contact between a victim and a perpetrator, what you start doing is looking for contact DNA. But in order to do this contact DNA, you needed low copy number, especially in that time, to work more sensitive. Well, that didn't happen in the United States. And therefore, I think in the United States, the main state laboratories used mainly DNA from blood, saliva, or semen. But at that time, because I worked all these difficult crimes, we got a lot of experience with this contact DNA.
Did you invent the protocol and process of low copy number DNA?
No.
Where was that invented?
I think the Forensic Science Society laboratory, which is currently closing, I think, but I think they started the experiments.
Where is that?
United Kingdom.
You use a particular, do you use a particular kit or protocol that you purchase from some location in order to do this low copy number DNA you're talking about?
Well, in principle, you can use every DNA kit because the method is only amplifying more than the standard number of amplification cycles. So you can do it with every kit. We use different kits, especially the last couple of years, some new kits came on the market which are more sensitive.
And you buy those from Applied Biosystems Incorporated?
That's correct.
Which is an American company, correct?
That's correct.
Now, let's talk for a minute. You said you can do things other people can't. Explain, let me strike that. The only thing you do extra is you run additional runs of the, let me start back again. PCR is the process of replication of DNA, correct?
Correct.
Normally, you said, I think in one of your slides here, normally it's a run of 26 to 30 runs of this replication process.
20 to 30, yes.
Okay, 20. And the way that works is it takes, basically the first run takes one intact cell of DNA, one intact strand of DNA, and creates a copy. So it makes two.
Yes.
Right. Next run, 2 becomes 4. 4 becomes 8.
Yep.
8 becomes 16.
Yes.
And beyond that, my math skills fail me.
32, 120.
Right, exactly. So by doing this 20, 22, 25 times, you make hundreds of thousands of copies of this DNA.
Idealistically, of course.
That's what, I'm sorry?
Idealistically, of course.
Idealistically, right.
The problem with forensic samples is very often they're not like in a hospital. They're more difficult. There's debris or dirt in there which can inhibit the reaction. So you have to take that into consideration. That's why I also say they already laboratory were able to get a profile from one cell, but forensically that's not really realistic.
Right. So theoretically you could get it from one cell, but realistically you can't.
You need more forensically.
More than that. All right. I'm just trying to figure out what is there in that process that any laboratory with the PCR equipment can't do.
Well, it's the whole process. As I explained when we started the presentation, is what happened in the 90s was that a lot of emphasis was laid down on the DNA, this technique, and it was under scrutiny, and you were the first person to get DNA admitted. So there was a lot of problems around the DNA itself.
Sure.
Later on, after the techniques were refined and it was accepted in court, the problem became, okay, we have this very sensitive technique with the amplification, but we don't have the stain. So we have cases which we know a perpetrator had contact with the victim, but we didn't find semen or saliva or blood from this possible perpetrator. And that's when we started with the DNA, because we know there was a violent crime, the victim was killed, and in Holland that often doesn't happen with knives or bats. We don't have so many guns. So in a lot of cases, there was contact between the victim and the suspect or the perpetrator, and we had to find this DNA. And then you come to the contact DNA.
Right. Now, you said that your methods were validated in 2002. Were these methods, or maybe I misunderstood you. I thought you said 2002.
I think that was in the national lab. So they did a validation study in 2000 already. And actually, when they were busy with the validation study, I used it in a high-profile case already. Okay. So from that time on, it was in the Netherlands, it was used in difficult cases, cold cases. I was project leader on cold cases. So yeah, I used it in a lot of my cases at that time.
My point, I guess the original question I asked was that the only additional step that you do is you just take additional runs of the PCR method to make additional copies. That's the, is that correct?
No, I didn't answer your question correct, so I apologize about it. No, the problem, the point I wanted to make was that With the sensitivity of the techniques, it is possible to get DNA. It became more important to find the DNA. And till the day of today, that's still the problem. In a lot of cases, it's certain that the perpetrator had contact with the victim was dragged, but they don't find the location. So at that time, in 2000, it became clear that the technique was very sensitive, but you had to find it. And if you find something or you had a location where you think, oh, this is a very likely location where the perpetrator touched it, you still, by a normal sampling method, you were not able to get a profile. So you had to play with the way in order to take a profile. For instance, over here, I know the swabbing of clothing is a common sampling method. Well, in Europe, it's hard to use because the results are not so good when you do swabbing. So we use a cutting method where you really pinpoint and you cut out a piece of sample and you dissolve the sample in the tube. And that's where we had a lot of success with cases that we were able to find the right pinpoint location of DNA and then extract the DNA from that. But then, of course, the problem there is that if you have a piece of clothing, it could be that you need, if you don't know where to sample, you can take thousands of samples. And of course, as a state laboratory, you always are bound by certain amounts. You cannot do 1,000 samples in one item. So that was a big problem. And also in the national labs, you have to take the right position.
Well, my question really had more to do with the actual testing of the DNA, not the sampling. So I wasn't asked about the sampling, but the idea of running the test itself, it's simply a matter of running the PCR amplification for additional cycles.
For low copy number, yes.
That's the only difference in that part. Okay. Now, let's talk specifically about a couple of the areas you talked about. Counsel asked you about finding DNA in insects. Have you ever tested a particular insect called Megacelia scalaris, a fruit fly, a very tiny fly, and successfully obtained DNA from that type of fly?
No.
You indicated in your testimony that those situations where getting DNA from an insect is successful are situations where the food, that is the blood or flesh, has been recently ingested. And that if it's recent, that sometimes you can still find some DNA that hasn't been ingested yet by the insect, correct?
Yeah, well, I think I have to adjust that a little bit because the case we worked on and where we got the result was a 5-year-old case. So it's the remains where we got DNA profiles from. Whether or not at what time the insect died and or the pupae, the leftovers of the cocon, how you call it? Cocoon, where the insect is coming out. If they contain DNA, I don't know. But it could be in different stages. It could be that the insect or the larvae was dying at a moment, for instance, by drying, that the DNA stays in there then.
Okay. But you did say in your direct examination that it has to do with some recency between the consumption of the food and the test, because obviously, eventually, the DNA is digested by the fly and is no longer. Right.
If it's digested, of course, the digestion of DNA, the digestion of DNA would break down, and the further the digestion goes, the more the DNA breaks down. And we measure small pieces, but of course, also with UV light, for instance, if you break the chain, you cannot amplify it.
So basically, even if you were able to obtain DNA from a fly as small as Megacelia scalaris, if it had been a month or more since it had consumed whatever human food it consumed, it would not most likely be available. It would have been digested.
If the fly consumed the blood or other cell material and then lived through and died at the end of the cycle, then the chance of DNA obtaining is of course small. If it died in between, before the consumption or the complete breakdown of DNA, then that's what I assume where we got the profiles from is that, okay, then the digestion is halted, and then it's a way where the DNA could survive.
Have you ever done any published research studies on environmental effects on DNA?
I myself didn't.
You yourself?
No.
What is the most destructive environmental effect? What has the most destructive environmental effect on DNA? Number one enemy of DNA.
Well, it's a combination, I think, but moisture and temperature is a combination of moisture and temperature is a really detrimental effect.
So a hot, wet environment is the worst thing for DNA.
Yes.
And also the presence of bacteria is also extremely destructive to DNA, is it not?
Yes.
Would you agree, sir, that a piece of duct tape, well, let's talk about the duct tape for a minute. If you place a piece of duct tape on a person's skin and rip it off, it is likely to bring with it not only the dead surface cells, but the living sublevel cells, correct?
That's correct.
That's the point you were making on direct, correct? But when DNA is placed on a surface of the skin and not violently removed, then the cells that are in contact with the tape are in fact the dead cells, in direct contact with the tape.
Well, the dead cells, of course, the governing cells. Well, I think that's correct.
Yeah, the dead cells are the ones that are up against the tape.
Yeah, of course, depends how much force is applied. And then you, but yes.
Okay. When it's torn off, it may pull with it some live cells, but what's in contact is dead, correct?
Well, in order to tear the other cells off, yeah, it should be also into the deeper layer, I think.
I mean, assuming it's not torn off. That's my point. Okay. And you would agree with me, would you not, that duct tape placed upon the face of a human being who is then placed in a semi-swampy, occasionally underwater, hot environment in Florida, in an area that is an erstwhile trash dump, and sits there for 6 months as every bit of skin cell decomposes off the body, leaving it completely skeletonized. You would agree with me, would you not, that the likelihood of finding any intact DNA on that tape is extremely remote?
Well, of course, the conditions which you describe are very bad for DNA. This is not a condition where you would have your DNA in. But of course, depending on different circumstances, whether or not you lose all of it, as explained, we only need a smaller number of a small amount of cells in order to get a DNA profile. So the question then is, okay, would you lose all cell material? And that's possible, but it's also possible that still enough cells would be present to obtain a DNA profile, especially when using low copy number DNA.
But if there's no DNA on, when you test a bone for DNA, you don't swab the outside of the bone, do you?
No, if you want to identify the person of the bone, you cut out a piece of the bone or the skull. That's the two.
Scope. There was no bones brought up.
Because you don't expect to find any intact, recognizable DNA on the outside of the bone because it decomposes. Isn't that the reason?
The reason is that the the body mass on the outside of the bones, of course, during decomposition has more, the DNA is degrading much more there. So why we use the bone and the skull is that because the chance of obtaining DNA profile from those locations is much bigger than from, and I'm talking about decompositional bodies which are in late stages. So there's no good blood anymore, and the skin and flesh are coming off the bones. That's the reason why we use it. Still, there is DNA in those locations. So it is possible, but it is way more difficult to get it from those locations, like for skin or the decomposing flesh or blood, than it is from the bones.
And while you have indicated that you believe it may be possible, you would agree it is extremely unlikely.
It will be very difficult to obtain a profile.
All right, let's talk about this masking issue that you discussed with Mr. Bias. You indicated that contamination in a DNA profile can mask existing DNA.
Yes.
But it would only mask existing DNA at exactly the same loci, correct? So going by your chart
so
here.
the size of the question about the cocoon. So I think it's he's from the Netherlands. I think they have a different name for it, so that's why he didn't quite know how to say cocoon.
That you use from your PowerPoint.
In fact, his native language, I'm sure, is Dutch. So.
The only thing that this 17 allele.
Oh, heck yes. I'm a musician, classically trained violinist since the age of 3, and I play guitar and many other instruments as well. Yes, yes. Beep, beep, beep.
Would mask would be a smaller 17 allele, correct?
Not the profile that we were discussing.
It's an example, Judge. Correct?
So with the lower 17, it's like 55. No, that would not be very likely. I think it was the other profile, the contamination, where.
Do you have a slide of that profile? Put that up and we'll talk about that.
So
let me clear this.
This is a profile where there's more information visible.
Let me ask you the question then. Let's look at the various loci that we see here.
Loci.
Taking this 15 loci here. The only thing that would mask would be another 15 loci, correct?
That's correct.
It wouldn't mask a 14 loci.
No.
The same thing with the 16. It would only mask another 16. It wouldn't mask a 17.
No.
And the same could be said for each one of these loci. It would only mask it's identical loci, correct?
Correct.
So in order for this profile to mask the profile of someone else, that person's profile would have to match at every single loci.
Yeah, it depends. What you see with the 17, for instance, what I already said, it would not be very likely that this profile is covering a full profile. So you will not lose a lot of information. What it would mask is, of course, the locations where you have the detection already, which you just circled.
Right.
And it's not so likely that a full profile would have been covered here. What could have happened is like a 17, well, in this case, there's no 17, but like 16 or 15. If you have a very partial profile caused by a very small donation of a other party, that could have been covered. So then you would not expect that this covers a full profile.
Right. There's no way this covers a full profile.
No.
This masks a full profile.
No.
The only thing it would mask would be identical alleles.
Lower. Of course, you see some alleles on this plate which are not mentioned, which are not detected by the threshold or by the analysis software. So therefore, you don't know completely if it's all these alleles. And also, if you look at this, this would be a good profile to enhance with low copy number DNA. Then maybe there would be extra information. So yeah, we would use this as a start for the investigation. Say, okay, maybe we should do low copy number and see if we get more information there. Also, maybe with a third person. If you look behind the 15, there's a very small peak with this low copy number. It's possible that you get a 16 there.
I'm sorry, you're talking about this?
The peak behind. No, that's in front.
I'm sorry.
That would be a stellar peak.
Hold on. Show me what you can illustrate with yours on the bigger screen here. If you use your finger, no, the one right in front of you. If you use your finger, you can circle or illustrate what you're referring to.
Oh, okay. Oh, sorry, I'm not so good. No, behind the 15, you see a small peak. And of course,
when you say behind, that's where you're losing me. I'm not sure what you're talking about behind.
After? Just you have the 15.
Talking about, that didn't work. Hold on.
They always have trouble with this telestrator.
Okay, so just kind of put a little spot on what you're talking about.
Yeah.
Is it where you have your that little peak back there?
The second blue one, there's a small peak above that.
Well, there's a lot of small peaks in here, right?
Yes.
And you're saying that some of that could be noise.
Well, if you use the low copy number technique, that could be happening that you get information out of there. From this, it's correct, and the factory, I think, they use 50 as a cutoff for the analysis. Actually, the analysis is done by the computer mostly, and then later on, after the computer is finished analyzing, then a scientist comes and rechecks if all the data is correct or he agrees with that. So the data is correctly analyzed, but there's information there. If you look at these rounds, and these ones.
And what could those be?
So
what could those be?
Those could be, well, I think if we use low copy number on these would go above the threshold and you would get information out of that.
What else could they be? If it's not DNA, what is it?
If it's not DNA. Well, these peaks can also be artifacts.
Okay. And again, your comments about what low copy number DNA could possibly do are completely speculative. You don't know whether it would come up with an additional profile or not.
Well,
isn't that right?
Pretty sure recognizing these locations. The peaks we see over here in the two circles are on locations where normally also markers are. So it's not pure speculation. That's that's the experience you need when looking over these profiles. That you recognize locations where you could get DNA extra information if you would use the low copy number method.
And every laboratory.
It sounds like what he's kind of getting at is like the state could have tested some of these partial profiles or whatever. With low copy number DNA and maybe have gotten more information as to where they came from, and they didn't. So essentially this expert is assessing the potential that could have maybe come out of testing these. Now, what I don't know, and we'll find out, right, is then did the defense have someone test these profiles? Like I don't know. But he's pointing out that this work wasn't done and they could have gotten more information. That's what it sounds like to me.
Validates its equipment with certain limitations as to what will be called as an actual DNA peak versus what will not, correct?
Yeah, what I said here, it's the 50 RFU is a standard from the factory.
What is your RFU limits at your laboratory? Same?
We use the same.
So even in your laboratory, you would not call that as a DNA peak?
No, we would not mention this in the report, but we would enhance it.
You would potentially run a couple more runs of PCR?
Yes.
And then if it still didn't show anything, you would call it as nothing?
No, if the computer...
This is a lot like in BK's case, right, where we heard about unknown male B and unknown male D. We don't know what happened to A and C, right, at this juncture, but, where everybody's been asking the question, like, why weren't these tested? Blah, blah. This is a lot like, this is like very much the same type of thing where it's like, what's going on? Were these not tested? And, I don't know. Again, I'm wondering if we're going to, in this case, at least we'll find out if maybe they were tested and maybe by the defense. I don't know. But it seems like they should all be tested in every case, right? Like, I don't know why you wouldn't. I guess what the justification would be when they say like, oh, we looked at it and it wasn't enough, we couldn't get a sample, which is why it matters when they say, hey, if you did these other steps, you could have potentially gotten something and you didn't do that. John Benet Ramsey, that's another example of where there's this DNA there that it's the same thing. It's like the state has it and they haven't utilized the new technologies that didn't exist a long time ago in that case, right? They haven't, but at this point, the new technologies have been around for a little while. They haven't utilized that to do further testing. Just recently, John Benet's like, I think half brother was on with Bob Motta, Defense Diaries, and was talking about how like, this was recently, that they just still haven't tested this. And so it seems like this is a thing that happens. And I don't understand it for the life of me. I don't know why you wouldn't test these things. Why assume you're not going to get more information if you take these other steps and then, enhance it and then try it again? Like, why make that assumption? It just doesn't make any sense to me. I don't know.
And analysis software, which is highly sophisticated, don't mention it. No, we're not going to mention it.
Did you ask to retest this tape?
Yeah, we mentioned that we could investigate.
That's the question I had.
A lot of items.
But
did you tape? Yes.
Did you ask specifically to retest this tape?
Yes, we could retest the tape. Yes.
It's not what I asked you. Listen carefully. Did you ask to retest this tape? Specifically, this piece of tape.
To Jose Bias.
To anyone.
Anyone. Well, we mentioned that we could investigate this tape, yes. This piece of tape.
Are you aware if items were, at the defense's request, sent for additional DNA testing?
Object outside of the scope and outside of this witness's knowledge.
Overruled.
This is exactly what I was saying. I was saying if it was tested, it would be a different witness that would have, because I was assuming this guy didn't test it. Interesting. So I wonder if maybe what happened was they did send it for additional testing and it did not yield any further results.
Do you know?
Well, yesterday during the deposition.
Well, other than what I told you,
yeah,
because you can't really quote me.
Oh, okay.
Do you know?
Say move to strike.
I just told him not to quote.
Objection overruled.
Okay. So aside from something I may have told you at deposition yesterday, as of yesterday, you have no idea if any item in this case was retested at the request of the defense.
No.
No further questions.
Redirect. I bet there's going to be a recross as well.
Mr. Eikelenboom, you were asked about your laboratory being on a farm. Do you recall those questions?
The farm.
Your laboratory is actually known internationally as the crime farm, is it not?
Objection, Your Honor.
Fucking hell.
Other people may call something.
Oh my God. Shut up. Sit down, Mr. Ashton.
Okay. In fact, you've been sought out by other different countries to have DNA tested at your crime farm.
Objection. Relevant.
Stop.
Overruled.
That's correct.
Mr. Ashton asked for this.
And
he asked these questions, so he gets to respond. I'll redirect.
And Mr. Ashton asked you about exposure. Your exposure, you've already had exposure internationally from your laboratory, have you not?
Objection, leading and relevant.
For fuck's sake, you can.
That's the leading, sustain.
So again, I've said this before. In most court, like typically the rule is you can lead the witness, the expert witness. Now, this Judge Belvin has some practices that are unique to his court. One of them is not leading expert witnesses. The other one is on cross exams for either side, right? On cross exams, if there was an objection for outside the scope of direct, that would be sustained. Like that, I've never seen that before. Because normally what happens is when you have your first direct, right, and then what normally happens is on cross, you can ask questions that go beyond what was asked in direct. You have more latitude to go outside of just specifically what was brought up on direct. And the reason for that is like, it's not your witness. You don't know what they're going to say. And it's, of course, it's it's at your own peril, because if you don't know what they're going to say and you ask a question, it could be a good answer for you, it could be a bad answer for you. But that's sort of the whole point. And then you have redirect, and then on recross, normally you are limited to what was on redirect, right? And also on redirect, you're limited to what was on cross. So that's the other thing. If you go way beyond on cross and you get, you go and you get into these other areas, it's a strategic choice where, because then you're saying, well, whoever's going to, whether it's the state or the defense, depending on whose case in chief it is, whoever's going to be coming back on redirect, now they can ask about those things, right? But the distinction here in this court is that on regular cross, first time through, you can't go outside what was brought up on direct. That's really unusual. Same with here, where he's like, you can't lead the expert witness. So it's just an interesting thing.
Have you had any previous exposure just in the United States while you were in Holland prior to you being involved in this case?
Yes.
What kind of exposure have you received?
Objection. May we approach?
No, John Bonet's case remains unsolved.
Objection overruled.
Mr. Eikelenboom, I want to talk about the recognition and exposure that you received prior to ever being involved in this case. When did you first start getting recognition from the United States?
Objection. It's not the question the court authorized him to ask.
Overruled. You can answer the question.
I can mention the name of the case. The first case was the Tim Masters case.
Well, that was the case.
Which was an exoneration.
He was
We started with that case in 2006.
Okay, let me stop you there. What were you asked to do in that case?
We were asked to do contact DNA in that case.
And what do you mean by an exoneration case?
We were approached by a police officer who worked on a case, and she came to the Netherlands, or she was in the Netherlands on a visit, and asked, she visited us and talked about this Masters case. And she asked if we would be able and willing to do DNA in this case.
And was this to help free him from prison?
Sorry?
Was this to help free Mr. Masters from prison?
That's correct.
And what happened? What did you do?
We came over to the United States, talked with the defense team. Because there was no money at that time, we evaluated the case. I worked in quite some miscarriage of justice in the Netherlands. And thought, well, this could be a miscarriage of justice. So we decided to continue with the case. Say, okay, we will, if the court allows us, do contact DNA in this case. And I testified about contact DNA in the case, and the judge allowed the evidence to go to the Netherlands.
And the evidence came to the Netherlands, and what did you do there?
We did do the DNA investigation, trace recovery, and DNA profiling. And then we were able to obtain a DNA profile, which was not matching the person in jail, Tim Masters.
Wow.
We obtained a lot of DNA profiles, all not matching Tim Masters. In 2006, there was not much interest, there was not a lot of media attention, but by the end of 2008, we were able to get a match with a suspect, or a former suspect in the case more than 20 years ago.
Wow.
And that was the time that they released Tim Masters, and it was the first miscarriage of justice which was acknowledged in the state of Colorado.
Wow.
And by that time, there was a lot of media attention.
Okay. And you received international media attention as a result of that?
Yes.
And that was from being able to obtain a DNA profile from 20 years past
Wow.
on Touch DNA.
Wow.
Correct.
And this
Okay.
person was found outdoors.
Yes.
And the clothing that you tested was subjected to numerous elements.
Wow.
Yes.
And held for 20 years.
Yes.
And then you finally were able to find something
Wow.
that wasn't found before.
Correct.
And subsequent to that, have you received other exposure from other cases?
Objection. Leading.
Question is not completed yet. Overruled.
Have you received other exposure from other cases in which you have worked?
Yes. Because of this case, we got other cases from the United States, which also get some exposure in national media here.
Okay. And did law enforcement agencies, as a result of that, travel to the Netherlands to consult with you?
Correct.
Okay. And were you able to assist them in their cases?
Yeah, we were currently working on several cases.
Okay. So this case is not the first high-profile case you've ever worked?
No.
Okay. Now, when you talked about running extra cycles and that's the only thing you do, there are actually kits that are sensitive, that are more sensitive than your standard kits when running DNA, is there not?
That's correct. I had it in the presentation, but shortcut it.
Sorry, I didn't mean. I'm trying to keep it as simple as possible. Now, when we say kits, we're referring to the type of what is used to try and generate the profile, correct?
Yeah, you could say these are chemicals used in order to, of course, it's a very complex procedure, but it's chemicals used to identify the different locations on the different chromosomes and make a profile.
Okay, and one example of this would be the mini filer
Yes,
kit.
the mini filer is especially made for broken down deteriorated DNA. So that could have been helpful in this case.
And it's not just running extra cycles. There's also possibly extending the injection time.
Correct.
Okay, and that would, there are basically techniques that you
This is interesting. Are we getting into doubling the size, basically, so to speak? Interesting.
use that might amplify the DNA or
Wow.
make it a little bit clearer so that the computer reads it. Is that correct?
Interesting.
That's a poorly asked question, I realize, but I'm trying to.
Well, I think it comes back to what I already described. The trace recovery is very important. And it was underestimated in the 90s. Everybody was looking at DNA. But if I have a big stain and I just cut it out and there's so much oil or grease in it, or especially metals with the PCR, it could happen that there's a lot of DNA there, but you still don't get a profile. So you need to have a lot of knowledge about the amount from such a stain. You cannot just say, I cut out 10 by 10 centimeters of stain. So cutting it at exactly the right location was the...
So in other words, I don't know that in other cases that, in other words, if there's an example of where this is explained, where something gets much bigger, they may or may not specify exactly how much bigger, but I think that, so whether there's an example where DNA exactly doubles or not, I think that in terms of trying to understand what the heck was going on, at least we're getting closer if we can see examples of when they get more data, right? When the file is bigger, they amplify it, they expand it. We were talking about some of this last night, but that's at least, because that you can see how that could yield a potential of where something doubles, right?
The exact amounts of pollution, and also with DNA extraction, which I didn't talk about here as well, but DNA extraction, what kind of method do you use? The phenol chloroform will not be able to perform as good as a cleaning action as, for instance, the Kaizen material. So certain filters, we use filters to clean the DNA, that would also make a difference in the chance of obtaining a profile. So it's the whole process from finding the stain till the end, or till analysis, in order to gain success with the DNA.
Now, and another reason that you are able to generate profiles where other labs do not. Also,
assumes a fact which is not in evidence.
Sustain.
Another thing that you
Just a second. Motion to strike, granted.
Another thing that you do differently is, or another consideration is also the type of machine used to run a profile, correct?
That's correct.
Now, I know you have a slide for that. Can you bring that up and explain why that might help you generate profiles that other machines do not?
DNA is, can everybody see this?
Yes, may we, Judge?
That's the same demonstrative exhibit number what, Madam Clerk? Okay.
So we see two machines over here. The one is slightly bigger than the other one.
They look the same size to me. Which one's bigger?
The right one is bigger.
Okay.
That will become visible if we look more closely. This is the 310, which we use. Is a smaller machine, and it's just one capillary.
And that's this line right here, correct?
That's correct. There's a line,
that out.
and actually this is a very small tube in which the DNA is separated, and then it's a laser detects fluorescent labels which we put on the small pieces of DNA, which we saw with the PCR amplification. And when the laser is hitting the label, it will fluoresce in different colors if it's a different mark or different location on the DNA. If you go to the bigger machines, they have 16 capillaries there. So now the laser has to go to 16 capillaries.
And that's these things right here, right?
So the ABI 310, you can see it in the text, and the ABI 300 are different in the way that the bigger machine has more capillaries, and that means that at the same time, where we do one sample, they can do 16. Well, one can imagine that for bigger laboratories, the state labs and the national labs, of course, they have lots of cases. And
Objection, Your Honor, this is not within the scope of cross.
It is actually, Judge. Mr. Ashton discussed that the only thing that he does different is run extra cycles. I'm pointing out that there are significant differences.
So the choosing of the machine is also of importance in order to get a profile. And we really tested this thoroughly because we do a lot of counter expertise in the Netherlands. So we test laboratory, or we do counter expertise on laboratory, which use the, all the bigger laboratories in Holland use the ABI 3100, so the one with 16 or even more now. And we found out that extracts where those laboratories actually didn't get any result. We were able sometimes to get full profiles, partial profiles, but we get a lot of results. And the only thing different, because we're using the same extract because they made the extract, so the only difference in the whole method was the machine. So that's why how we found out that the machine makes a difference as well. And of course, it does make sense if the laser has to go to one capillary. This is a glass capillary. It has to go to 1. Of course, it's more sensitive than it has to go to 16 because you can lose some power of this laser light going through. So the machine using that it's slow, so that this takes time, and that's why I say we have a turnover time, which is longer because we don't do 16 samples at the same time. We do 1 sample at a time.
Now, Mr. Ashton questioned you about degradation of DNA and how water and heat are bad for DNA. Do you recall that line of questioning?
Yes.
Have you found DNA profiles, and do you have any examples of what you can show the jury of profiles that items that you've been able to obtain profiles in that have been exposed to these types of elements?
Do you want to see the slide?
Sure.
Yeah, in the slide you see 3 different kinds of pieces of evidence. You see a panties, which is more than a panties, a pantyhose.
Yes.
On the left side, left upper side, and that's a piece of panty which is more than 20 years old. And after 20 years, we were still able to get contact DNA from these panties.
Now, I'm a little confused because this looks like there's a lot of blood here. How do you know? I mean, isn't that just the blood the DNA profile that you got from the blood, or is that?
The blood was from the victim, and of course, and it's more or less a given in the homicides we work on is that you always have a lot of DNA of the victim, and of course, during our investigations, we're not looking for DNA of the victim, especially not on the clothing of the victim. So we're looking for DNA of possible perpetrators, and in this case. Of course, and that's why the sampling is so important. If you take a stain straight into the middle of the blood stain, you will have an enormous amount of DNA of the victim. But what you need is the DNA of a possible perpetrator. So taking a sample on a location, for instance, where there's less blood, where you're able to still enhance a profile of a second donor, that will help in order to get a profile. And that's what happened in this case.
Okay. And what else do we have here?
The second is a right hand of a victim which has been lying almost 3 weeks in the water. And also in this case, where we were able not only to detect DNA from the victim, which if of course also 3 weeks in the water is not a very good condition, but also DNA from a suspect, which was later convicted, based also on the DNA.
Okay, and what about here, the jacket?
And the jacket is more or less the same. This jacket was not the body, but it was worn by a victim, which was lying in the water for around 3 or 4 days. And we were still able to obtain DNA from a suspect there.
So while, if I understand you correctly, while these conditions certainly don't help, they don't preclude you from being able to obtain a profile. Is that correct?
That's correct. Very often the bigger labs or the labs say, well, this has been in the water, we don't investigate it. And that's why we say, okay, well, give the evidence to us, we will try to investigate it. And then we were able to get DNA from that.
Okay. Now, you had requested to do DNA on items in this case, did you not? You were willing and able to do it?
Yes.
And you were willing and able to do it pro bono?
Objection. Relevance.
Approach.
Just move it along. Yeah. And the only reason you did not do the DNA testing in this case is because the prosecution objected to taking it.
Your Honor. Relevance. Yes, please.
Okay, we'll take our mid-afternoon recess to 20 minutes past the hour of 3. Please remember all of my previous admonitions. You may be seated. Okay, objection will be sustained in the sense that you can question him about the question that Mr. Ashton asked about, did he ask to examine that piece of duct tape? I guess that was on the mouth.
Allegedly, sir.
Well, wherever it was.
Yes. 264 group of items. Yes, sir.
And as to the other issue that you raised at the sidebar about asking the court to take judicial notice of different testing, give me exactly what you want, because I am really going to need to research that because of the issue of burden shifting. There is a very delicate and fine line.
Okay. Yes. So this is because the state seems to be suggesting that, again, the defense should have went for further testing. It's funny. This is the question I was asking, right? I was like, did the defense go for further testing or whatever? Now it seems like we're getting an answer to that they didn't, but the state wants to imply that they should have, and that's what he's referencing.
With that, that's something that I don't want to have to deal with at the last minute, because if I get it at the last minute, I'm going to err on the side of being safe and disallow it. But I need plenty of time, because those cases are all over the board, and it depends on which group you have, and the cases have shifted from time to time, just as the composition of the Florida Supreme Court, or if you look at the District Court of Appeals, whichever panel you happen to get. So that is not a very easy legal issue to decipher. Some things are best left unsaid. We'll be in recess. Yes, sir.
Okay, and they come right back. Here they are.
Okay, state recognized presence of the jury and the defense.
Yes, sir, we do.
You may continue.
Mr. Eikelenboom, the 17 allele that was found on the sticky side of the duct tape, it was found at one marker, correct? The D3 marker?
Now this
Yes, 17.
This should be the DNA.
And in order to include someone as a match,
FBI
you
analyst.
have to have all 13 markers identifying that person, correct? For inclusion, I guess, generally speaking now.
No, what you normally do is you have a reference
Unless
profile.
this is, unless this is, so remember there are 3 separate pieces of duct tape, right? So so it must be that these 2 partial profiles or whatever it is were on a different piece of duct tape, and the one that had the FBI analyst was on, I believe, the duct tape. Well, one of the pieces of duct tape. It was the only, I guess, full profile that they got came from the FBI analyst on accident. Because initially I was like, I'm trying to figure out which one are they talking about? But I think they must be talking about another partial.
That's in the United States, it uses 13 core loci, profiler, co-filer, and ideally you would have a match on all those loci. With a partial profile or very partial profile, as in this case, you can only compare a reference profile, complete reference profile, with the 17 or the locus D3 here, and the amylogenin.
Now, you testified earlier that you believe that this was human DNA, correct?
Yes.
17. Okay. Now, for exclusion, to exclude someone, how many markers do you need that is different from that person's profile? Did I ask a question?
As I understand correct, if somebody doesn't have the 17 in his profile, of course, if you don't have the 17 in the row of numbers of the 13 core loci, well, then you cannot have donated the 17. Is that what you mean?
Correct. So if I am a 14-15 at this marker, which is the D3, and a 17 shows up, could you exclude this person?
Yeah, you would not be the person who could have donated 17 then, because it's not in your profile.
Okay. I have no further questions.
Recross.
Recross. Thank you, sir. So one of the challenges with, let me restart. Original DNA testing was done with a system called restriction fragment length polymorphism, correct?
Correct.
And that system required a fairly significant amount of genetic material in order to get a profile.
Correct.
Sort of a quarter size spot of blood or a bigger or a substantial amount of semen.
Yes, correct. Blood and semen mainly.
With advances over through the early 90s, this PCR approach became the approach used by most laboratories.
As always.
That's correct.
Because it replicates even a small amount of DNA to make it larger, to make it visible.
Correct.
As that has happened, the concern for contamination has become greater.
Correct.
In fact, the smaller amount of DNA you're looking at, the more difficult it is to relate it to the crime itself. Isn't that true?
That's correct.
So in other words, that you might find a speck of DNA through even just regular PCR or low copy number doesn't necessarily mean it relates to the crime.
No.
So the fear for contamination is much greater.
Correct.
Now, in this particular case, I'm going to... I think Mike will be able to pick me up. If you had tested the tape in this case, there are 3 possible results that you might have achieved. The first is that you might have found nothing.
Correct. Yep.
And if you found nothing, that would not be inconsistent with the tape being placed on the child prior to decomposition, would it? Because as you said, the DNA could have simply degraded and decomposed, correct?
That is possible.
The other possible result is that you might have found Caylee's DNA on the tape, correct?
Correct.
And that obviously would be pretty strong evidence that the tape was placed over her mouth before she decomposed, correct?
Correct.
The third option is you could found an unknown DNA profile on the duct tape. Isn't that correct?
Correct.
And there would be absolutely no way to ever know whether that unknown profile had anything to do with the crime. Isn't that correct?
Well, I think the district attorney was hypothesis, what we call it working hypothesis, was that the tape was crime related. So what you do with DNA testing is test whether or not you get a result, and you can substantiate or refute, find support or no support for a certain hypothesis.
But my point is, if you got a result, an unknown result, a result that didn't match anyone that anyone knew anything about, you would never know whether that DNA came from something related to the crime or some contamination, which is very, very possible with low copy number DNA. Isn't that true?
Okay, low copy number DNA is more sensitive or prone to contaminations. That's true. We see that in the case we work in the Tim Masters case, for instance, we had a lot of contamination, which makes the whole investigation even more difficult. Having said that, what we do now is, and that's actually what the FBI also did, is testing that against all.
You guys hear his question? Hold on. Let me back this up.
Or some contamination, which is very, very possible with low copy number DNA. Isn't that true?
Okay, low copy number DNA is more.
It came from something related to the crime.
Okay, here we go.
An unknown result. A result that didn't match anyone.
Wait, here we go. Back up further. This is this question. Whoa, whoa. Spinny wheel. Why? Just why, spinny wheel? Interesting. Well, basically, what it sounded like he was saying is like, if you found some other profile or whatever, how would you know it had anything to do with the crime? And literally what he's asking is the thing that is the whole thing that we hear about with touch DNA, right? Which is it could have been, you don't know, right? Like, oh my God, what does that even mean? I guess I have to just like refresh this. Hang on.
Find support or no support for a certain hypothesis.
But my point is, if you got a result, an unknown result, a result that didn't match anyone that anyone knew anything about, you would never know whether that DNA came from something related to the crime or some contamination, which is very, very possible with low copy number DNA. Isn't that true?
What he is saying is literally, this is the state, right? This is literally what you hear with usually defense attorneys. What he's saying is like, essentially, how would you ever know if any of the DNA actually is related to the crime versus it got there some other way? Did you guys hear that? Let me back that up. I can't believe I'm hearing this. You guys?
Certain hypothesis.
But my point is, if you got a result, an unknown result, a result that didn't match anyone that anyone knew anything about, you would never know whether that DNA came from something related to the crime or some contamination, which is very, very possible with low copy number DNA. Isn't that true?
Okay, low copy number DNA is more sensitive or prone to contaminations.
Wow.
That's true.
Wow.
We see that in the case we work in the Tim Masters case, for instance, we had a lot of contamination, which makes the whole investigation even more difficult.
Yeah.
Having said that,
I mean, isn't that
we do
insane? Like what he's just saying, and again, because this is coming from the state, is like, then why are we even bothering with DNA at all? Like on crime scene, like what? Unbelievable.
Now is, and that's actually what the FBI also did, is testing that against all the persons in which you know who worked on the case, the crime scene investigators, lab technicians, everybody had contact with the evidence, you have a profile from. And I think in the United States also you have this database of profiles, not only from suspect, but also from lab co-workers. At least in Holland we have that. So everyone working on crime scenes or working in a laboratory has to give his profile and will be compared to obtain.
That's what happened in this case with the FBI analyst who left DNA accidentally on the duct tape.
Profiles. So if you can exclude, or there's no support for hypothesis that any of these co-workers contaminated the crime scene or the evidence, then of course it becomes more likely that it is in some way crime related.
Well, but because this test is so sensitive, you can't ever know whether somebody had contact with their wife and then got transferred DNA onto an item because it's so hypersensitive. You just can't ever really know.
Oh my God.
Isn't that true?
Well,
you never really know.
Wow.
No, it was low copy number. It's an issue which is more.
He's getting worse with it. This is crazy. So the other thing is this: there's an emphasis here on unknown, where he's saying that, in a way, he's implying a lot of things. But one of the things is that if you were to test DNA, and let's say it's an unknown, but then you can, at this point you can use IgG, right? And then it becomes a known person, right? He's saying that person what he's saying is that, how do you know that person had anything to do with the crime? Essentially what he's saying is only if it's somebody you already suspect or whatever. I'm so shocked he's saying it. I can't even formulate a sentence properly. So for example, if you're at a crime scene, right, and you don't know who did it and you test this DNA and it's unknown, right? But then you can, again, in the future from wherever they are, use IG, match it to somebody. It's well, that person couldn't have had anything to do with it. I'm trying to wrap my head around this, but I backed it up. Let's see.
Ever know whether somebody had
that it is in some way crime related.
Well, but because this test is so sensitive, you can't ever know whether somebody had contact with their wife and then got transferred DNA onto an item because it's so hypersensitive. You just can't ever really know. Isn't that true?
Well,
you never really know.
Right.
No, it was low copy number. It's an issue which is more common.
Wow.
Of course, the type of transfer you described now is a lab technician having contact with his wife and contaminating the DNA with the DNA of his wife, but then still you would expect more DNA of this lab technician than from his wife. So this is called secondary transfer.
Right.
It's all possible. I won't deny that's possible.
Wow.
Secondary transfer is described, and there actually is literature about it. But it is less likely than direct contact, and so contaminations are easier found. And we, in the case we work on, we regularly find contamination by police officers or lab technicians.
Wow.
But then we recognize those.
Of course, the problem with low copy number is you may find unknown DNA, and then you'll never know whether it's contamination or an unknown suspect. That's the confusing.
Guys, he keeps going with it. Is he trying to? Is he trying to suggest that there's more than just one lab tech? Like that, in other words, that lady from earlier wasn't the only lab technician that left DNA. The only reason he would be suggesting this is because there's a possibility this could be George's DNA. I mean, that's what it is. And so, in a way, he's almost trying to blame law enforcement or lab technicians, saying that there wasn't just one FBI that accidentally left it. There were other people that also left. Two other people that also left DNA. Because to him, that's better than saying it could have been potentially George Anthony. Is that what this is? I'm just lost. But look at this. This is a great, I'm going to take a screenshot. This sums it right up. Sums it up right here, doesn't it? His pose. Wow.
It's possible that it is.
I know, right?
Literally.
Literally.
Where you get an unknown profile with low copy number DNA, and you really don't know where it came from.
That's possible.
Could you pull up that slide that you pulled up with Mr. Bias, the one with the jacket and all that in it?
Demonstrative exhibit by the defense, number what, Madam Clerk?
CI. Thank you, sir. The first object in the top left, was that associated with skeletonized remains?
No.
I mean, his freaking duct tape is gorgeous
to the
duct
right,
tape.
that obviously is
and I have to say, too, let's not forget, right? George is very possessive about his stuff. We heard a lot of testimony about how he didn't want people going in his sheds. And by the way, their property has 4 different sheds. They're all George's sheds, okay? He kept locks on them. Remember the whole thing about the reporting gas cans missing, stolen gas cans? It's just what? I mean, very possessive. And in those sheds, okay, is where 3 things were, well, more than 3 things, but 3 pertains to the crime scene. The black trash bags, what the remains were found in, the canvas laundry bags, which were like the remains were found in, and the freaking duct tape. And when they searched the house after the remains were found, and we saw pictures of this, George had this weird habit of storing trash bags inside other things. They showed pictures of a suitcase with a black trash bag in it. They showed pictures of a trash bag with another trash bag inside of it, but no trash. And the biggest thing of all, they had a picture of the matching canvas laundry bag because Cindy testified they purchased them as a set. And the way that Caylee was found, she was inside this black trash bag, inside a canvas laundry bag, okay? And they found literally that exact same setup, the trash bag inside the laundry bag, or maybe I have it, maybe it's reversed actually. The canvas bag inside the black trash bag. Either way, it was the exact same setup as the way the remains were found. And they found that in one of the sheds. And then the only thing that was missing was the roll of duct tape. So.
And that is not fully skeletonized. There's still tissue there. Is that correct?
Correct.
And the jacket that we see here, that
Yeah.
was that associated with fully skeletonized remains?
No.
No further questions.
That would be wild.
Oh, I'm sorry. I don't think that, I just told that may not have been published, and that's my fault. Let me go through that again. I apologize.
Oh my
Just so
God.
the jury knows what we're talking about.
Right? No, George is.
None of these three, just to sum up,
Yep.
were associated with fully skeletonized remains, were they?
That's
I
correct.
mean, most people think, I mean,
No further questions.
the thing is, because most people think, they think what they think about Casey Anthony, they've not maybe assessed, potentially George's situation. And again, the other problem is a lot of people don't really actually know the facts of the case, like in the evidence, right? Or they know some of it, but not all of it. I mean, again, if you watch like I said, the list that I have going of like the case against George is extensive, and it's like the only thing for Casey is just her odd behavior, and that's it. But in terms of actual physical evidence and odd behavior, George has it tenfold. I mean, the only physical evidence points to George, but he has also as much odd behavior, but I understand people have opinions, but I'm just saying, like, it is, yeah. That's the thing.
Redirect.
Oh, look at that. Redirect.
Based on what you do, these issues, the fact that they were, whether it's skeletonized remains or not, have no bearing on whether you would get DNA or not, correct? An item is an item.
Yeah, if there's DNA in an item,
like for example, these panties, you're not testing the skeletons, you're testing the item.
Correct.
Okay. Just like duct tape is an item.
Yes, correct.
The fact that the remains are skeletonized have no bearing on the item, do they?
Well, of course, it can give problems, but the item itself, it can be investigated. So,
Right.
And then the condition of the item is more important than the skeletonization of the body.
Right.
So the condition of the item, of course, is important.
Look at him go. I love it. He loves to meet people.
Mr. Ashton's 3 scenarios also leave out a fourth
I have no idea
important scenario, do they not?
what Green Coon is.
Number 4 could also be that this duct tape was not wrapped around Caylee's mouth. Isn't that not true?
That's correct.
And in fact,
Yeah.
based on what you've testified already, you would have likely seen
So
some
that's
DNA.
Right.
Based on,
I forgot about that. I'm so glad this came up because I had forgotten about that. That's the other thing is that, right. That's the other thing. I forgot about that. I'm so glad you mentioned it. That the tape that was, according to the state, is supposed to be over her mouth. Remember, it wasn't found on her mouth, okay, with the remains. There was 2 pieces that were found further away from the remains, and then there was 1 piece that was still attached to like the hair mat, but not over the mouth, right, or whatever. So the other point that he's making is that the fact that Caylee's DNA was not found on the sticky side of any of the duct tape, any of it, is like the duct tape wasn't placed, like it could have just been in the bag or whatever. Like it could have just been whatever, but it wasn't. I mean, and yes, had that duct tape been touching the skin, I have no doubt that there would have been her DNA on that sticky side. I don't see any way around it. I'd forgotten that was another thing, in this case, that just blows my mind that the state still tries to suggest that the duct tape was on the mouth and on the face and all that's it's just, the evidence doesn't support it.
on the scenario that the state presents, does it not?
Well, if there was DNA, if the tape was placed over the nose and mouth, and especially the mouth and the mucosa from the nose, then there would be, at least at the beginning, there would be DNA.
And Mr. Ashton asked you about contamination and how sensitive DNA is now. When you find the perpetrator's DNA on an item, and you've testified in your experience, that DNA profile matches the perpetrator or the suspect.
Suspect and
Yes.
later convicted persons.
You have never gone into court and said, you just can't ever know.
In what sense?
Well, Mr. Ashton.
You can see he's reading from that. He wrote down verbatim what Mr. Ashton said, because Mr. Ashton said, you just can't ever know. That was one of the ones where we were freaking out, or I was freaking out.
I was questioning you about, you just can't ever know if someone's DNA is on an item relates to the crime.
The final decision whether it's crime related is in our system up to the judge and the system to the jury, of course. So no, we would never go further than there's support for hypothesis this DNA came from this person. And on an activity level, so it could be transferred. There's support for the hypothesis it is transferred during the crime or during pulling down the panties, for instance. So
panties. That's
where we would go with this evidence.
Right. The evidence is either there or it's not. You don't give any interpretations and say things like, you just can't ever know.
No, it's on a crime level. Yeah, it does match or doesn't match, or it would support a certain hypothesis or it wouldn't support, support a hypothesis.
There's either DNA there or it's not. Correct? I'm speaking generally. I'm not.
Yeah. Well, if you have alleles, there's DNA, and if you don't, then there's no.
No further questions.
Okay. Wow. Popping back up.
Are you telling this jury that the proximity of tape to rotting flesh does not increase the likelihood that the DNA on the tape would decompose as well?
Notice what he did here, because he realizes, right, that he's losing. I mean, I'm speaking even just in this one witness, but I think in general they realize that. But look at what he did. He added in rotting flesh. Think about that. And we've seen the state do this time and time again. Mr. Ashton's done this a lot, where he brings in these things to try to appeal to emotion. And it
depends, of course. If the tape was on the body, which is decomposing, that would increase the chance that the DNA on the tape would also decompose.
No further questions. Thank you. Oh, I'm sorry. I thought you were done. Apologize. Go ahead.
Oh my God.
Of course, it's depending. If it's not on the body or it's a little bit away from that, then of course the chance of degradation of DNA is smaller.
That type of thing is really disrespectful to the victim, right? Like trying to rile up the jury at the expense of, and in that manner, right? The way he did it with the face, it was like trying to make people, I don't know, it was like grotesque. I don't know. What's another word for it? It just that feels really disrespectful to the victim. And especially because it's like you're trying to use the victim to serve your own means, right? It's like using the victim, the fact that it was a child, and trying to appeal to that, but it's like not even being done in a appropriate way or a respectful way. And also it's like the strategy is more important than what you're actually saying, you know? Just trying to
of course, the outside conditions are still bad for DNA. On the other hand, of course, we have the PCR method, which is so sensitive. We only need a couple of cells to obtain alleles or profiles.
So it does make a difference if the tape or item is in contact with decomposing flesh. It does make a difference, doesn't it?
Yeah, in my opinion, it does.
No further questions.
Yeah.
Interesting.
Okay, may the doctor be excused for today. Thank you, doctor. You may stand down.
Easier to stand down. And that's it for this one, my friends. So, well, this is who we have next time.
I
who it is.
MELICH.
Just as true to form, right? Everybody comes back a million times. So I should say too, for anyone who hasn't watched this whole trial, the very first witnesses that the defense called in their case in chief, in fact, like the first, I don't know, maybe 4, 5, 6, 8 witnesses were all law enforcement. Okay. From the state, right? Of course. But they hadn't yet called, and you never see this, right? Ever. The defense, this is the lead detective, guys. This is Yuri Malek. He's the lead detective. He's the one who interrogated Casey. The defense is calling him to the stand. Holy shit. I can't wait to see what he's going to say. I've never seen that. Have you guys ever seen that? The defense is calling the lead detective to the stand. Wow. So that is their next witness. I wonder how long he's on the stand for. Let me see. This won't give me a preview like it does on YouTube because this is the court TV archives. Well, I guess we'll have to save him for next time. Wow. I mean, it's unusual in the first place for the defense to call a lot of law enforcement. Every now and again, you'll see it where they call like maybe one, and it's not just like the people that did something, you know, like in other words, when I say the law enforcement, like the very first witness that the defense called was, what's his name? I'm blanking on his name right now. But he wasn't the lead detective, but he was he was the lead crime scene investigator guy. Oh, what was his name? Anyway, Hispanic dude. That was their first witness. Was, again, so when you think of who are the strong, or the state, right? The most important witnesses for any state, right? It's going to be their lead detective and like their lead crime scene analyst, right? And again, the first witness the defense called was like the crime scene, you know, lead crime scene dude. And then now you've got them calling Yuri Mellet, the lead detective. I mean, that is just a lot, right? Wow. So, but we'll have to watch this next time, guys. So I do have a BK stream scheduled. I'm looking at the time. So my list of what I want to prepare for that has grown even just since this live stream, because we started talking about more things. I may have to reschedule it for tomorrow. We will see if I can get some of this stuff done in time. But I might have expanded my list, as I said, of things I want to get ready to have ready for the live stream. So, we'll see, but I may end up moving it to tomorrow because I would rather be prepared. And I want to look for some additional stuff that we've referenced here too. So, and I'm going to take a look also at the Twiz. I think it's a map, Twiz map. So, yeah, right. I know. And literally doesn't even serve any point except for trying to appeal to emotion. I mean, it's pathetic, really, right? It's like, that's pathetic. And it's disrespectful to the victim. Like trying to use Caylee for, you know, it's just, so yeah. So I may have to move that till tomorrow, but either way, hopefully you guys have enjoyed this. You know, especially some of you guys hadn't been following this before. But you know, it is, regardless of anything else, like it is a really fascinating trial. There's a lot of interesting issues that come up. A lot of this is related to other cases, and good lawyering, at least from the defense's side. The state is questionable at best, but yeah. And you've got the Judge Belvin with his quirks. You've got a lot of different, like, little, you know, each trial has its own flavor and its own little, you know, situation going on. And again, just the thing here, we know what happens in the end, but you know, we still have a lot of witnesses to go. Like, let me see here. We have, where is it? Hold on. So this is, just a second here. So we still have, in terms of the way court TV groups it, sometimes there's more than one witness in one video. Oh, there's a lot more to go. Holy shit. Wow. Wow. And we have a ways to go to get to Roy Kronk. Amazing. Wow. George and Cindy both come back multiple more times. Holy shit. Gosh. So it looks like, dude. So the defense, it looks like the defense is also going to call George and Cindy and Lee, the brother, as well. Oh my God. Cindy comes back at least 2 more times. There's Lee. I think Lee comes back 2 more times. And George comes back 2 more times. Oh my God. That is wild. That's wild. I can't wait. That's super exciting. So there's a lot more to come in this. Wow. I'm glad. Thank you. That's awesome. So Carla's laughing at something. Don't know what, but good. Excellent. We love laughter. Wow. Very interesting. You know, then there's a lot more. I'm sure there's gonna be a lot more surprise. Roy Kronk's, that's what I'm really, I'm excited for all of it, but like, that's ever since opening statements, right? It's like, holy shit. And of course, the other thing is, like, the state didn't mention Roy Kronk at all in opening statements, and that's the person who found the body. They also didn't. I kept waiting the whole time during this case in chief. I kept thinking, when are they going to call Roy Kronk? Because he's the person who found the body. In every trial, the person who finds the body testifies in the state's case in chief. Every trial. And like, I kept thinking, when are they going to call Roy Kronk? And then then they were like, okay, we rest our case. I was like, they are not calling Roy Kronk? You've got to be kidding me. You've got to be kidding me. I don't even know. I didn't even think that was allowed. I thought you had to call the person who found the body. I mean, I didn't even think, isn't it insane? But the defense calls him. So the way that Jose Baez put it in the opening statements is he said about referencing the state. He said, this is their three-legged pony and they're going to ride it all the way to the finish line, which is fucking hilarious. Yeah. Love it as well. We love having you. Excellent. So yes. So I try to alternate because I'm covering so many different things. I try to, alternate so that way we get to go back and forth. But yeah, so again, it might have to push it to tomorrow for the BK. It depends on how quickly I can find the stuff I'm looking for. But love you guys. Thanks for being here as always. Love the Squirrel Crew. And I will see you guys. Oh, let me pull my banner down. Boop, boop, boop. Okay. See you guys next time.